I'd like to call this remand hearing to order. This is a hearing of the Anchorage Municipal Assembly. This is an adjudicatory hearing which arises out of an appeal of special assessments to finance the Turnagain Heights Lateral Sewer Improvement District, Road Improvement District, and Water Improvement District by order of the Superior Court in case number 38N126917CI. The matter has been remanded to the Assembly of the Municipality of Anchorage for an adjudicatory hearing under AMC 19.20.340 in Chapter 3.60. My name is Amy Domboski. I am the hearing remand chair that has been appointed by the Municipal Assembly. And to my left are the other two members of the hearing remand panel, and I'll let them introduce themselves.
Dick Train, Anchorage Assembly.
Bill Evans, Anchorage Assembly.
Alrighty. So with that, if both parties could introduce themselves for the record, please.
Mike Staley here on behalf of the appellants.
And I'm Robert Owens with the Municipal Attorney's Office.
All right. And special counsel.
Joe Lebeck, special counsel to the Assembly.
All right. And also in Assembly chambers are Assembly Counsel Julia Tucker and Municipal Clerk Barbara Jones. All right, to start this, first the issues on appeal as they have been outlined by the court. First, that the special assessment exceeds the value of the benefit conferred upon the property owners, taxpayers. Second, that the $1 million of the cost of constructing Pump Station 10 was improperly shifted to the improvement districts. Additional issues would be the cost for the three improvement projects must be reassessed under AMC 1920.340 and 3.60. Also, whether lift station project costs were improperly imposed on lot owners. Additionally, whether assessed costs included the addition of independent lift project that was not approved by ballot of the lot owners. Additionally, adjudication is required rather than merely legislation because the facts are disputed. Again, whether bidding procedures were properly implemented, and lastly, determine how costs are offset and have been conferred to the property owners. With that, I will just reference that the process that has been laid out today is going to be a relaxed administrative process. We have, through joint stipulation, agreed that the municipality, the appellee, will be allowed 30 minutes to present their opening remarks, followed by the appellant's counsel will be allowed 30 minutes in total to set forward your opening remarks, Mr. Staley. The property owners may make comments. They'll be limited to 10 minutes each. And through its designee, Mr. Owens, the municipality will be allowed 4 hours, not including cross-examination, to present evidence in support of special assessments. And then the appellants, through their designee, will be allowed 4 hours, not including cross-examination, to present evidence in support of the issues and respond to arguments made by the appellee. The MOA, through its designee, is represented 30 minutes to present closing statements, as will the appellants through their attorney. Now, with that process laid out, the one thing we promised to do, and we had done at previous meetings, is the assembly members that sit on this panel, as well as all assembly members, have made disclosures in public, and they have been voted on, and those disclosures have been deemed to not substantiate conflicts, and all members have been instructed to participate, with the exception of one who's not on this panel, which is Mr. Starr. But all three of us will go forward and redisclose to you today our disclosures, and if there's any questions, now is the time to address those. So I'll start with mine, and this is the disclosure that essentially I gave at one of our assembly meetings. And with respect to the Eberhardt versus MOA remand from the Superior Court, I wish to disclose the receipt of a campaign endorsement and contribution 2 years ago from one current appellant in this matter. In 2012, I received a contribution from Chuck Spinelli. I understand from the municipal clerk's notice dated March 26, Nanny Slusher is substituted for Ray Craig by court order. The Assembly's first work session on the remand was held on February 21st, 2014, and I was unable to attend. Until I attended the follow-up training with on March 5th, I had no knowledge of the remand order or the pending issues related to this litigation. In terms of ex parte communication, I did receive and return a telephone call from Andre Spinelli, Mr. Chuck Spinelli's son, prior to March 5th. Andre Spinelli inquired about the February 21st work session. Because I didn't attend, I had no knowledge about the Eberhardt remand until March 5th. I referred Mr. Spinelli to the municipal website for the February 21st work session. Since March 5th, following advice to council, I have avoided ex parte contact on this matter. I have had no contact with appellants in this case or any other matter, and I have occasional routine contact with members of the administration, including Mr. Wheeler, but never on this matter. I joined the Anchorage Assembly in April 2013, and I have no private or financial interest in the matter, and the Municipal Assembly did rule that I didn't have a conflict. Additionally, I would like to point out that through the course of the procedure, developing the procedures, I was instructed by the chair to inquire with Ms. Mahoney and Mr. Vakala as to how long it takes tax assessment rolls to come out. I did that, and we had no contact about the substantive issues. In fact, the answer was unknown, and they said they'd get back to us. So that's been it for the communication. Do you have any questions from either the MOA or from the appellants?
No questions.
No, I don't either.
Okay. Mr. Traney?
Thank you, Madam Chair. In reviewing the full list of appellants in the Eberhardt versus MOA remand order from the Superior Court dated September 6, 2013, I say that I received a 2013 campaign contribution from Corbett Mont, a named appellant in this matter. In terms of ex parte communication, I have none to disclose. I participated in the work session on February 21st, 2014, when I first learned of the remand order, consistent with the advice of counsel and my duties as vice chair of the body. I will avoid ex parte contact in the Eberhardt manner under remand from the Superior Court. As vice chair and member of this body, I continue to have routine contact with members of the administration, including contact with Municipal Attorney Wheeler and his staff, but none on the Eberhardt remand order. I have no private or financial interest in this matter. I'm confident that Mr. Month, support of my campaign, will not influence my decisions in the Eberhardt manner.
Thank you, Mr. Traney. So the Assembly did rule that Mr. Traney does not have a conflict. Are there any questions from the municipality,
No,
from the appellants?
None, Madam Chair.
Okay, thank you. Mr. Evans?
With respect to the Eberhardt versus MOA remand from the Superior Court, I wish to disclose the receipt of a 2014 campaign contribution of $500 from Mr. Chuck Spinelli, one of the current appellants in this matter. Although I may not have met Mr. Spinelli, I did have lunch one time with his son, Andre Spinelli, who also contributed $250 to my 2014 campaign. I understand from the municipal clerk's notice dated March 26th that Nan Schleusner is substituted for Ray Craig by court order. I was elected and subsequently sworn in on April 15th, 2014, and prior to serving on the Assembly, I had no knowledge of the remand order or the pending issues related to this litigation. In terms of ex parte communication, I have none to disclose. Consistent with advice of counsel and my duties as a member of this body, I will not be engaging in ex parte contacts about the Eberhardt matter under remand from the Superior Court. I should note that within about 2 weeks ago, I did have a telephone conference with Matt Fink on a matter related to a liquor license. I didn't realize at the time Matt Fink was one of the appellants. Nothing regarding this matter was discussed, but I did have that conversation with him. I expect to have contact with members of the administration, including Mr. Wheeler, but not on the Eberhardt remand matter, and I have had none. I have no private or financial interest in this matter. I'm confident that Mr. Spinelli's support for my campaign will not influence my decision in the Eberhardt matter, and I should be able to represent the public interest without conflict.
Thank you, Mr. Evans. With respect to everything except for Matt Fink, the Assembly did rule that Mr. Evans does not have a conflict and was directed to participate in this matter. Are there any questions from the municipality regarding Mr. Evans's disclosure?
No, none at all.
Mr. Staley?
None, Madam Chair.
Okay, thank you. And with respect to Matt Fink, that phone call, Mr. Training, do you concur? I don't believe there's a conflict there.
There's a conflict now.
Okay, so this body has decided there is no conflict in that matter either, and we will proceed. Just to let both know that as we call witnesses, the witnesses will be sworn in by the municipal clerk, so they will be under oath. Are there any questions or are there any concerns before we get started? Mr. Staley?
Brief comment, Madam Chair. As Mr. Owens and I chatted, and we've agreed to be somewhat flexible regarding the timing issues that you discussed when you were laying out the procedures. We believe that we have adequate time. It may well be that Mr. Owens has more witnesses, some of whom I was going to call, and so it may be that his case, if you will, takes more than 4 hours because a portion of my case will come in through cross-examination of his witnesses. We've also agreed to be flexible with regard to openings and closings, and we hope that the committee will accommodate our accommodation of each other.
Absolutely. Mr. Owens, any comments?
Yeah, I concur. It's very likely that the case in chief that I have to present would extend beyond 4 hours, but I have the majority of the witnesses that are going to be presented. And I really do believe that we'll be able to wrap this up in the time that's been allotted.
Wonderful. And just for the record, we have scheduled to meet today from 8 to 5, tomorrow from 8 to 4, and if necessary, Wednesday from 8 to 7. With that said, obviously it'll make for some long days. We will be taking some breaks. We will try to do that between witnesses rather than interrupt those witnesses' testimony, as well as I haven't heard yet what time we'll be taking lunch today. But as soon as we take our first morning break, I'll come back and I'll let you know when that will be. I would anticipate it'll be somewhere around noon. Is that okay?
Yes.
All right. Mr. Owens, I believe you are up first. Okay, one more, but I'm going to interrupt you because I just had a sidebar conversation with special counsel. It dawned on me as I was thinking of your witness list, I have one more disclosure that I'd like to make before both of you, before we start. And that is one of the contractors, Roger Hickel, who I anticipate will probably come and testify. I worked at a law firm in which I was a paralegal that worked on some of his personal matters. And he did donate to my 2013 assembly race. So I want to make that disclosure to both of you before we get started. Do either of you have questions for me?
No.
I don't intend to call him.
Okay. Do any members of the subcommittee have questions?
No.
Okay. Am I okay to?
You're fine.
Okay, just making sure.
No problem.
Okay.
I'll let you know later if you need to withdraw.
Yeah, right. All right, Mr. Owens, please proceed.
Okay. Good morning. Thank you for your kind attention and your participation in this hearing. Set my glasses down.
Madam Clerk, can you dim the lights a little bit so we can see the screen? I cannot see that, with or without glasses.
It's also an exhibit. I'll be able to point that out.
Okay. There we go.
That's great.
Yep.
Ready to go?
Yep.
Okay. In your introduction, you succinctly summarized the court's order for September of 2013 that remanded these 3 assessment roles to the Assembly for reconsideration. The issues you mentioned, whether the assessed costs include lift station costs inappropriately, whether the bidding process was valid, if the owners benefited from the work, and whether the cost allocation of the PRU's work was appropriate, have been broken down for our purposes in 4 general categories. These are basically cost allocation, bidding and contract award to Prue's construction, benefit, and accuracy of the assessment rules. There's a couple of fundamental concepts that are going to carry through these presentations and the discussions in the next couple of days. Generally, this is a special assessment district. These are fundamentally a contract between the municipality and the property owners that initiate the process in this case. They came to the municipality and requested that roads, water, and sewer improvements be constructed. The road provisions that govern special allocations of street improvements is controlled by AMC 19.40. And for roads only, the municipality subsidizes the cost of the construction by paying, in this case, 30% of the cost of the construction. In addition, if the municipality owns land that is benefited by the road, then the municipality pays its fair share for those works in addition to the 30% share. So in this case, the municipality owned Linary Park and a couple other parcels that amounted to about 17.5% of the project. And so with the 30%, it paid about 47.5% of the cost of the road. The amount that would be assessed for the road is only 70% of the total amount of the cost. The water and sewer improvements are governed by different rules, and that's the tariff provisions. Under the code, there's a reference to the tariff, and the tariff requires 100% recovery of all costs of improvements for both the water and the sewer improvements. Now, I mentioned 1940 as being the governing code provision for street improvements. As a side note, I'd just like to point out that the court's order, I believe, got it wrong. It referred to 1920 as being the code provision governing governing assessment allocations generally. And that's for general purposes, but streets have a special provision of the code in 1940. The difference is substantial. You need to satisfy yourselves as to which of those is appropriate for these road improvements. But I would have you note that the ordinance 2004-2 that initially set up the road improvement district specifically incorporated the terms of AMC 1940 down here at the bottom. In addition, in the fiscal note, there's a reference to AMC 1940 as well as being the one that governed and defines the allocation of these costs. That also carried over into the 2007 update of the project estimate and budget, where again, in the ordinance, there's a reference to AMC 1940, and in the fiscal note, it is again indicating that the costs are to be allocated as indicated or as controlled by AMC 1940. These two exhibits are in the municipality's exhibits as Exhibit B12 and Exhibit C11 respectively. So I recommend that however this comes out today, that the body make a finding as to what it believes to be the code provisions that govern allocation of street assessment costs. Now, improvement districts, as a contract between the property owners and the municipality, have very simple terms. Basically, the municipality provides a cost estimate up front. The majority of the property owners have to agree that that is a cost that they're willing to undertake, and they promise to pay it when the work is completed. The municipality takes all the risk of the project. They finance it. They guarantee the maximum cost to the owners. It will not, there's a ceiling established, so the owners have assurance that their costs are fixed. And the municipality takes all risks for unexpected conditions. It does the design and potential design defect risk. It does the construction, latent defects, unexpected conditions, and it actually maintains the facility after it's constructed. So in that sense, the municipality takes on a significant burden, and it has a right then to, and it has an obligation as well, to comply with municipal procurement codes as it goes forward. The work is done on a contract with the municipality, not the owners. The one thing that the improvement district codes allow the municipality that's not available to private developers is the ability to compel all owners who are benefited to pay for it. If in the absence of municipal participation, private entities would be limited to those who would agree to pay, and they can't force people to pay even though they benefit. Using the special improvement district formula gives people who want to develop their property that additional capacity of compelling people who are not willing to participate to pay their fair share if a majority of the owners agree. So you're going to be hearing references to a road improvement district, which is, the acronym is a RID, a water improvement district, which is the WID, and the lateral or sewer improvement district, which is the LID. In addition, there's a fourth project that was constructed at the same time, and that's the Pump Station 10 project. Each of the LID, WID, RID were funded through improvement district funds that were capital improvement funds lent by the municipality to the project. The Pump Station 10 project was funded by the utilities capital funds as well as a state grant from the Clean Water Fund. So it had a separate source of funds, and it was needed by AWU because the existing Pump Station 10 was outdated and too small. It was located near this work. It was going to be connected to this work. It was going to share some of the facilities of the improvement district work, and so it made sense to build it at the same time. So, other issues of general concern to the project. Constructability. The projects are located in, obviously, one of the most sensitive earthquake areas in the city. The history speaks for itself. There are substantial concerns about the safety of this slope. It's located on a hillside slope, the improvement district work was. The ground generally slopes from Iliamna down to the coastal trail towards the water. So stabilizing that slope was a key concern. In addition, some of the individual lots on that slope were located in a low-lying area, the ones on the north side of West Marston Drive. And so developing a capability to have material flow into the main trunks created particular challenges in that it required particularly deep trenches for the sewer lines. There were budget issues. The improvement districts had a maximum price. The owners had approved a maximum price, and the municipality was not prepared to do an unlimited procurement here. So they worked hard to make sure that the projects came in within the owner-approved budget. The amount of the cost estimate that was approved in 2006 was a revised one, but in both instances, the code provides that the estimate is what the owners approve, and they understand that it could be exceeded by as much as 10%. Anything more than that, the city absorbs. It cannot require the owners to pay. So for the improvement districts, there was a specific fixed limit on the budget that had to be monitored through the bidding process. For the pump station work, there was concern about cost and a prudent need to maintain reasonable costs for the pump station, but it needed to go forward, and it had a separate source of funds. and there was less concern, and there was an ability to go back to the board and have approval given if the bids came in too high. So there was no fixed maximum for the pump station. There were, to accomplish cost allocation, monitor the work, develop the way that the work was to be performed, each of the 4 projects were broken down into a number of tasks, and then those tasks were divided up among several schedules that became the core of the bid process as well as the billing and accounting process. So there were schedules A through G. Schedule G is linear park work, and we're not going to be talking much about it. These schedules were used to monitor costs and allocate costs, and it also were used to identify work that was to be constructed with the pump station in the vicinity of the pump station that included also aspects of the other improvement districts, but because of the proximity, there was a need to make sure that the site didn't get disturbed later on if the improvement districts were built later. So they were portions of the improvement district that either shared facilities or were located in proximity with the pump station were combined with the pump station work in schedules A through C. So there's going to be a little bit of terminology that's used in the context of the analysis of the bid process. You will hear a reference to the basic bid. When the package was released for bids, the schedules were labeled, and the basic bid, for purposes of the solicitation, included schedules A, B, and C. The deductive alternates, which involved components of the work for the water, road, and lateral improvement districts, were a separate group, which was D, E, and F, and there was a concerned need to monitor those in case if the budget was busted on any of those, they wouldn't be constructed, it would be delayed, but the work on the pump station would go forward. So the improvement district work that was identified in schedules D, E, and F is referred to in the bidding material as the deductive alternates. Then there, in the same context, is a reference to the process that was used for determining who had the lowest responsible bid. That was identified and explained in a number of documents, including the solicitation. And it was stated that the process would be the purchasing department would examine all of the total amount bid for all of the projects, the combined total first. That would determine who had the low bid. And then they would look and see to be sure that none of the works identified in schedules D, E, and F exceeded the amount of money available for those improvement district components. So the process was look at the total picture. If it came in under budget, make sure that the schedule DEF came in within budget, and that would be the successful bidder. This is a process that was a little unique to this project and not one that is, and the general mass provisions refers to some of these terms differently, but mass also allows project managers to define and accommodate unique circumstances for each project. The cost allocation methods were generally, the schedules again played a role in this. The schedules identified a list of specific aspects of each that were defined in each schedule. That enabled bidders to bid on that. It enabled the purchasing department to evaluate the amount bid for each of the schedules, and it allowed the cost and project management teams to monitor the cost as work progressed. Within those schedules and within the way the work was developed and designed, there were certain aspects that included shared facilities, and so there had to be an allocation of the cost of those shared facilities. And there was some that were joint use. For example, it's pretty common in the work around the city that if a developer is developing land and putting in a storm drain, and it intersects a section where there's existing flow, the developer's work wouldn't need to normally accommodate that increased flow. So where those events occur, it's pretty common that the municipality will pay to upsize the pipe from what would have been needed just for the development, but because of surrounding area flow, we'll pay to upsize, say, from an 8-inch pipe to a 12-inch pipe. We pay the difference between the two. That's sort of an example of how cost allocation occurs where there is a facility like a pipe being used by more than one aspect of the city. So there would be existing sewer flow within West Marston area, within the West Anchorage area that was coming down to the pump station, and there was accommodation for the new sewer improvement district. At a couple of points, they flowed in the common pipe, and there was an allocation of those costs. Now, the project managers did their best to apply a fair formula in these instances. Reasonable minds might differ, might have different suggestions on how that could have been done. But the test really is whether or not they exercised good faith in making these allocations and that there was no malice. Assuming good faith, a demonstration will prove that it was good faith and no malice against these property owners, then their judgment should be respected. On the issue of bidding and contract award, this was a project, consolidated projects. It was let according to the standard procurement process of AMC Title VII. There's no special rules for improvement districts. The owners don't get to pick their contractor. The property owners don't decide when the bid goes out. They don't decide how its selections are made. The owners are not at risk. The municipality is at risk. The municipality enters into these contracts. We have to follow the code. We have to look out for the municipality's interest in these circumstances. The owners can't protest the award. The procurement code is designed to protect and ensure the integrity of the process for other bidders and to ensure that the municipality gets a fair return and a fair process for its procurements. The owners are not interested parties in the context of the procurement code. Interested parties there are defined as other bidders. So if there is a disappointed bidder that thinks the process was inappropriate, they have a way of seeking relief. The property owners don't get a free ride if they find some sort of a mistake in the bidding process. They still ended up with the benefit that doesn't excuse them from having to pay for it. Now, there were 3 complications in this procurement. The maximum price established for the improvement districts required special care. And also, there was a mistake by one of the bidders that submitted a bid for this project. That had to be addressed, and it was, and we'll show how that worked out. In addition, the owners attempted to interfere with the award of this contract. That complicated matters, and I'm sure you're going to hear about that. But the evidence will show that the mistake was handled appropriately according to code, according to law that's been established by the Supreme Court in Alaska. Basically, the procurement officer required the bidder that claimed a mistake to prove that there was a mistake, prove that it was important or material, and we understand that the municipality is not here to put people out of business. So if it would have a serious material effect on the business, then mistakes can be allowed and people relieved of their bid. In terms of evaluating the bids, you'll see that there was considerable care taken to evaluate the bids to ensure that the improvement district budget estimates weren't exceeded and to monitor the total cost being submitted for each of the 4 projects. The owner's attempt to interfere with the process was basically an attempt to insist that the municipality not award the contract to Prue's Construction and instead, this for the improvement districts, and instead postpone it and rebid it at a later time. The timing on this was inappropriate and it was not definitive. Their communications with the city did not clearly define what their intentions were, and they were too late anyway. So the award was made and the work was completed. It was completed on time, it was completed on budget. The benefit is clear. We'll present evidence that will show that the property values skyrocketed after these improvements went in. The sales prices of properties that have been sold all included the full cost of the assessments in addition to other compensations. So there's full compensation. The market recognizes 100% value of these improvements. There's one exception. You'll hear from Mr. Hitchens, who had a house at the end of Iliamna. He had a very unique situation in that he was situated in a pastoral setting at the end of the road. It was really a wonderful arrangement. But he was sitting adjacent to municipal land. The right-of-way was there. He knew it. He'll testify that he knew it. He owned 3 parcels. 2 of them were vacant and not on the road system, no access. He has no problem with the assessment that was, he'll testify that no difficulty with the assessment on those 2 lots. He recognizes the distinction between those lots and his lot where he had a house. The house he sold before the work was begun and at a time of heightened public concern about what the impact of this work was going to be in the neighborhood. In essence, I think that his sale was premature. He bolted, and so he didn't get the full value that he might have otherwise obtained. That, I think, explains difficulties he had in obtaining his preferred price and selling it in general. But that is a unique and separate parcel, distinct from the others, and is not representative of the others. The rolls themselves are now accurate. We're presenting new rolls that have been combed thoroughly. We went after the lawsuit was commenced in 2012 to challenge the 2012 assessment rolls. We reviewed those, and particularly the PM&E road portion. In their review, identified some landscaping charges that, although appropriate for the project, were charged to the road system and that was inconsistent with promises made in the preliminary meetings with homeowners. We notified the court of that, requested that it informed them of the error, and suggested that we reevaluate. After that, went back and did a thorough review of each of the projects, identified some other misallocations as between the 3 projects, and reassigned those, and have done a thorough audit of each of the projects as well, and can report now and will demonstrate that the figures are accurate. The material we've presented includes a complete breakdown of each of the projects, total line item entries and information, as well as a summary. These have been available for quite some time. The Pump Station 10 project, with the Clean Water Act grant associated with it, was subject to a state accounting requirements. They conducted their own audit of that account, and it came up clean as well. So we are confident that the corrections have been made and verified, that the rolls are accurate, that the project was managed professionally and competently, and that this was a complicated project that was finished on time and on budget. So fundamentally, a deal is a deal. The benefited properties should pay for the improvements that were constructed at their request. As one other side, couple of procedural notes. Each of you has a 2-volume set of exhibits from the municipality. The way these have been organized is that one of the volumes contains the exhibits A through L. J is not in there. J is a separate reference binder. That basically has the code, the tariffs, the design study reports, and the total cost breakdown for each of the projects with the cost summary. Kind of in an interest of preserving paper and assuming that the detailed cost accounting reports wouldn't be of particular interest to each of you, we provided one general reference binder that you could share, and each of you then has the exhibits that are otherwise going to be referred to. That exhibit binder is broken down by topic. The contents are arranged by topic. There's an index at the front, and each of the topics is tabbed, and there's an index within the tabbed sections as well, so you don't always have to flip to the front. One other point is that there's going to be a number of drawings and maps and plans that are used in this. This is an example. It's going to be important. Not all of these maps are oriented the same way. North isn't always the same direction. So I'll make an effort to try to keep you posted as to which direction is which as I go along. In general, the pump station that we often refer to is located down in this area. It's towards the water. The slope runs from Iliamna up here down towards the water. North is towards the water. And so we'll try to keep that orientation for you. You'll be seeing with me today at various times representatives from AWU, which are here in the front end. We've got a client here from Steve Nuss is one of the, is going to be my client for the day. Brian is also an AWU employee that'll be testifying. We also have people here from PM&E. Today it's Russ Oswald, and he'll likely be a person attending most of the time. So I thank you for your patience and attention, and we'll move ahead.
Thank you, Mr. Owens. Mr. Staley,
Thank you.
do you need the projector?
I do.
Okay.
I, too, want to thank you for your time in hearing the evidence that we're going to present to you over the next 3 days. It's important to keep in mind that with regard to special assessments, McQuillan, which is often referred to as the Hornbook of municipal law, states that the rules and regulations regarding special assessments are to be interpreted in favor of the property owners. And the reason for that is clear, is that the municipality does control this. They're controlling, what is going to be allocated, what's going to be asked of these people to pay. And so they're the ones who set the budget, they set the bidding, and they set the roles. And because of that, if there's an ambiguity, it's to be interpreted in favor of the property owners. There's a couple of other rules that are important to keep in mind. And one is that municipal code says that when there is a special assessment, one, it's supposed to be kept separate from all other municipal work. And the reason for that is so that there isn't this blending of costs. And by law, property owners cannot be asked to pay for anything outside of those special assessments. So that's, again, a fundamental rule of law that's important to keep in mind. And if there's an ambiguity on that, It's to be interpreted in favor of the property owners. One final sort of rule of law is that the assessments, even though you look at the actual costs in the first instance to determine the assessments must have a proportional relationship to the benefit conferred. That is, it would not be fair, it would not be lawful to confer a benefit of $10,000 and assess someone $100,000. There's just no proportional relationship there. The benefit conferred has to be proportional to the amount of the assessment, and the assessment has to be proportional to the benefit conferred. Those, again, that's a fundamental rule of law that governs your decision in this case. This hearing really concerns two separate projects, and in some ways that's really disappointing, because if these had been kept separate and apart, if they had been done separately and not blended with one contractor doing the design for both and one contractor doing the construction for both, then many of these issues would not be before you today. It's because they were blended and made into one project with one design engineer, one contractor, that these questions have arisen. The first project is Pump Station 10. That project has been on the books in terms of either upgrading it or replacing it since at least the mid-90s. For a long time, it's been known that it was not sufficient, that the existing Pump Station 10 was not sufficient to handle the waste that went to it from the existing neighborhoods. There were instances that pump was running nearly continuously, and there were instances when it was feared that raw sewage was being discharged into the inlet. And so since the mid-90s, they knew that they needed to upgrade or replace that pump station. Ultimately, they decided not to upgrade it, but to replace it and put it in a new location. And as Mr. Owens has indicated, half or more of that was paid for by grants under the Clean Water Act or other things. The other half of that is paid by the ratepayers from all the way from Eagle River to Girdwood. And so just like any other item of infrastructure for a utility like that, it's not paid by the people that immediately use it. The people in Eagle River aren't going to use this pump station. The people in Girdwood aren't going to use this pump station, and yet they pay for that. But similarly, when they need a new sewage treatment plant in Eagle River or Girdwood, the people in Turnagain pay for that. That's paid for by the ratepayers. So that basic infrastructure is to be paid by the ratepayers citywide. Now there is, I believe you'll see, a special surcharge that's charged to the people that are immediately adjacent to it. I think you'll see that there's a 3% trunk surcharge for those people that are hooking up to that trunk. And so these people are being asked to pay for something, but again, that's separate and apart from these special assessments. So keep in mind you've got three things here. One, you've got this basic infrastructure that's going to be built, and it's going to be paid for by ratepayers citywide. That includes my clients and all the people in this assessment district. They're going to get a utility bill that pays for a portion of that infrastructure. Then you've got the surcharge that's going to be paid for by these people. All of that is separate and apart from the assessment district. The assessment district is not to pay for that basic infrastructure. The other project is the improvement district. And as Mr. Owens has indicated, there's a RID, a road improvement, a WID, a water improvement, and a LID, a lateral or sewer improvement. Now again, that's separate from this basic infrastructure. These improvement districts were put in place so that certain land that prior to this time had been undevelopable by law, you could not build on it. These improvements, the road, the water, and the sewer, are being put in so that this land can be developed. And there is a benefit there to the municipality. And indeed, the municipality even calculated the benefit to it. It said this upgrade, this RID, in conjunction with the proposed LID and WID, will provide public roads, water, and sewer to 31 undeveloped parcels. Not only undeveloped, but undevelopable, not legally able to be developed. Assuming the value of the existing undevelopable lots is $28,000, and an average developed lot will have a value of $500,000, the estimated annual property tax impact upon full development is as follows. And you can see that the difference is nearly $250,000 per year to the municipality as a result of these improvements going in. And that's assuming that these homes, many of these lots, which were not capable of being developed, are right down on the coastal trail. The same project had been undertaken on the east side of Linnery Park, and we now have homes owned by former Governor Sheffield, the Rasmussen family. Many of those homes are valued at well more than $500,000. Indeed, they're valued at more than $1 million. So to look at this estimate and say that the value, the assessed value of these lots when they're developed is only $500,000 is being extremely conservative. There's a good chance that the annual increase to the municipality as a result of this development going forward is going to be far in excess of $250,000 and probably $500,000 per year every year as a result of this development. Some individuals didn't want this development to take place. Some people in the neighborhood who didn't own any of the land down there didn't want it to take place because they would have liked that green space to just remain a sort of a de facto park. But even some of the people that owned those lots didn't want this development to take place. Diane Wilkie, for instance, has a home in Turnagain, but that green space was out in front of her home. She bought one of those lots for the particular express reason of ensuring that that land would not be developed. So when this came before the assembly for a vote to say, should we improve this, despite the fact that she owned one of those waterfront lots, she said, no, please don't. I don't want this area developed. Cliff and Diddy Hitchens owned a home down there. It was a fully developed home, fully taxed, had road access, had water, had sewer. In fact, it was built, as of today, by our current governor, Bill Walker. And they bought it from him in 1993 as a fully developed home, and they were taxed on it as a fully developed home the entire time. They bought the 2 vacant lots next to them that could not be developed because there was no access. And they didn't have the utilities, and they were in this area that it wasn't allowed to be developed. They now can be developed because of this project, but they voted against it. They bought that house, they bought the 2 vacant lots next to them, not speculating on being able to develop them and build them, but because they enjoyed the green space. They wanted the green space, they didn't want it developed, and so they voted against it. Now, it doesn't matter. If you own a lot, if Diane Wilkie owns that lot and she votes against it, it doesn't matter, she still has to pay for it. And so, therein lies the rub, is that you can buy a lot down there, not for the purpose of speculating and developing, but for purpose of preserving green space, but you're going to have to pay for it. As Mr. Owens indicated, though, the Hitchens had 3 lots, one of which had a home on it, and had road access, had water, had sewer. This is the Hitchens' driveway to their home. Marston Drive, dead-ended, and at the end of Marston Drive, there were 2 driveways. One went to Lot 11, which was owned by the McLeods, and one went to Lot 10, which was owned by the Hitchens. These photos are a little dark, but this is This is the Hitchens home. And this area here, this is the vast expanse of greenery out in front of their home. Off going down in this direction are the 2 extra lots that they purchased. Now that is where the right-of-way is. That is where the road is built. In fact, you can see what happened. Again, I apologize, these are dark. Doesn't seem to help. But again, you can see the home. And you can see the road and the fact that the greenery has gone away. And so what once was a vast expanse of land out in front of their home has now been turned into a road very close to the home itself. It doesn't take a rocket scientist to say that this didn't benefit them. It doesn't take a rocket scientist to say that this didn't improve their situation. This didn't improve the value of their home. Indeed, it did the exact opposite. It took away from the value of their home, and that's why they voted against it. Despite the fact that they voted against it, at least 57% of the people that were going to be held responsible for this voted for it. And the Hitchens indeed do not dispute that for the 2 lots next door to them, that they are responsible for those assessments. But this is what the municipality, this is the municipality's Exhibit A6, and this is what the municipality shows as being the improvement district. And while it's not very clear again, you can see that there's some different colors here. These 2 lots here are the McLeods and the Hitchens. And those 2 lots both have homes on them. They both had road access, they had water, they had sewer, and they had been there for years before this was going to go forward. You'll see that there's these 2 lots. They're actually in red, even though it doesn't show up very good. This one's in blue, and then all the rest are in gray. The one in blue is actually one of the vacant lots owned by the Hitchens, and it's in blue because it actually had sewer. Because the old sewer line ran between the Hitchens' home and the first vacant lot that they bought, and ran across the street to the old pump station over here. Again, you can't see it very well, and I'm going to try and blow it up. But you can see where the location of the old pump station is identified. And so that's what they called the East Trunk Line. That was the main line running to the old sewer station that handled all the waste for the existing homes in Turnagain. Now, even before these assessments, even before these improvements were done, we can take a look at what the municipality said with regard to the value of this land. The first sheet that you're looking at here is Block B, Lot 8. This is one of the vacant lots that the Hitchens owned next to their house. And you can see in 2004 it had a value of $14,800. In 2005 it still had a value of $14,800. In 2006 it had a value of $26,300. So it's going up for some reason, despite the fact that you can't develop it. But I will, later in this hearing, you will see that immediately before these improvements, it had gradually gone up to the value of $36,000. Immediately after these improvements, it was valued at $80,000 or $84,000. Roughly a $40-some thousand gain because of that road going in for that area. And that lot, by the way, is the same size, basically, as the lot that the Hitchens home is on. And this is the assessment for the Hitchens home. And again, you can see that the land value has been fully assessed and fully taxed since long before these improvements went in. In 2004, the land was valued at $34,900. In 2005, $82,500. In 2006, $87,600. That's more than what these lots were valued at after this improvement went in. At the time that these improvements went in, the Hitchens land that their house was on was valued at well more than $100,000 and taxed at well more than $100,000. And after the improvements went in, it did not raise substantially at all. It raised by a few $1,000s. And that makes sense. Every year it raises by a few $1,000s because of inflation. But it wasn't because of the improvements. You know, again, their lot was valued at $87,600 in 2006. The lots next door of the same size after the improvements went in were valued at $84,000. They were fully assessed, fully taxed, and rightfully so because they had road access, they had water, they had sewer. It was a fully developed and fully taxed lot. And here, the next page is the McLeods right next door. And you can see that with the exception of $100 here or there, the assessments are nearly identical. Again, in 2004, $74,400. In 2005, $82,200. And in 2006, $87,300. That's what those lots were valued at before these improvements went in. That's what they were assessed at. That's what they were taxed. In the fall of 2003, and that's when these improvement districts really got going, was in 2002 and 2003. In the fall of 2003, the McLeods, who owned the home next to the Hitchens, wrote to Jim Lamson, who was the project engineer. And you can see that he said that Andy Underwood had given him his name as the person to contact. And essentially what Mr. McLeod said in September of 2003 was, we don't believe we should be in this improvement district. We understand that you're going to put in road, water, and sewer so that these undeveloped and undevelopable lots can be developed, but we already have a fully developed home. So we shouldn't be in here. We have access from the dead end of Marston Drive. We've got road, water, and sewer. And so he's asking that he not be included in that district. And Mr. Lamson, who at that time was the project engineer, wrote back to him and indicates that, well, he says, first of all, that road, that Marston Drive, it's going to be completely rebuilt all the way in front of your house. Right there, along the full frontage of your lot. It's going to be upgraded in width, curb, road base. It's going to be a whole brand new road all the way in front of your house. But he says, but you know what? You do raise an interesting question. I don't know if that's really going to benefit you the way that it's going to benefit the others. And so he says, email continues, that if this petition is approved by the property owners, he'll work with them to explore ways to adjust the amount of the proposed assessment to reflect this lesser benefit. And indeed, a couple of months later, in November of 2003, Howard Holton, professional engineer with the municipality, wrote to say, The assessment roll being forwarded to the Assembly will recommend a proposed assessment of only $1,463.23 on your property, which is equal to the estimated cost of installing the curbs. So instead of being assessed for the full value of the road, they decided to accommodate the McLeods by assessing them only for the curbing. And all of this occurred without lawyers, without Assembly members even. The Assembly members did approve that when the rolls went through, but all of this occurred at the engineering level by having the engineers look at it and say, you know what, this doesn't make sense. Unknown to the Hitchens, that took place. The McLeods were actually absentee owners of that house, if you will. They rented it out, and so they weren't there, and so the Hitchens didn't even know that that was going out. So the McLeods, while they owned that home, actually rented it, so next door to the Hitchens were the McLeods' renters. But in October of 2003, that same time, Cliff Hitchens wrote to Andy Underwood. Again, you'll remember that Andy Underwood was the original contact of the McLeods as well. And just like Mr. McLeod, Mr. Hitchens says, with regard to the potential special assessment charges for improvements to the district, I wish to point out that this lot already enjoys road access, has no need for the alleged improvements. Therefore, please delete my property as I will not benefit in whole or in part from these improvements. Essentially the same thing that Mr. McLeod had said, but he's writing it to Mr. Underwood instead of Mr. Lamson. Well, Cliff didn't hear anything. Mr. Underwood never got back to him. And 1 year went by and another year went by, and he assumed essentially that he had been removed from this. But they knew that the project was going forward, and they knew from their perspective that it was going to devalue their home, that they were going to go from having this beautiful green space out in front of them to having a road right next to their home. And so they put the home on the market. And they put the home on the market in 2007, and if you recall, 2007 in Anchorage, it was a seller's market. This was before the bottom had fallen out of anything, and homes were selling. They were selling quick. There were often competing bids. Their home did not sell. And so they asked the real estate agent why they were having such a hard time, and the real estate said that people who come to look at the home are concerned about the unknown total expenses and unknown impact on the property and setting as a result of these improvement districts. Thus, this issue is keeping you from getting a sale on the property and is impacting the value of your home. Well, during this process, Cliff again wrote, this time he wrote to Russ Oswald, and while you can't read this here, this says Andy Underwood. So he CC'd it to Andy Underwood, and he says, I wrote 80 days back and 3 months and 7 years ago, asking you to remove our house from this improvement district. He says, as I've received no reply, it seems fair that you agree with me that this lot receives no benefit in whole and part, and therefore no assessment should be made. Well, at this time, Andy Underwood forwarded to Jim Lamson, the project engineer. May 31st, 2007, he says, hello, Jim, attaches a letter I received this morning from Cliff Hitchens in the Turnagain Improvement District. He has 3 lots or properties in the improvement district. One of his properties, lot 10, is for the road only. He wants this one taken out of the RID. For some reason, he thinks I'm the RID guy. Jim, could you talk to Mr. Hitchens? And thus began a conversation between Mr. Lamson and the Hitchens regarding this. But at this point, the project had moved to a completely different stage. And so Mr. Lamson said, well, you're going to have to wait until we get to some further point. So the Hitchens wrote to Matt Clayman in 2008. And again, they summarized that this improvement district wasn't improving their property. In fact, it was negatively impacting it. That it was fully improved when they bought the property in 1993. It has been fully taxed as though it's been fully improved the entire time that they've owned it. And they informed the municipality that the house had sold. However, they were required to have money held in escrow until this assessment issue could be resolved. Finally, in 2009, Mr. Lamson took this issue up with the Hitchens, and bottom email is from Cliff to Mr. Lamson saying, "Hi, Jim, having read your email to Sheila Selcraig, who was an assembly person at that time, it seems to me that we have with this property a unique set of circumstances. The building has access. It's been there for 30 years, fully developed, fully taxed." Mr. Lamson writes back, "I commend you for your continued efforts to pursue this. I plan to set up a following meeting with the key players." And then Lamson writes to Sheila Selcraig and Harriet Drummond and says, "I wanted to let you know that Cliff Hitchens and I remain in contact regarding this. Today I told him I would be setting up a meeting." And indeed, that meeting took place, and it took place on July 6th of 2009. And in this email of July 9th, 2009, Mr. Lamson summarizes that. Again, I apologize, these are difficult to read. But essentially he says that there was a discussion on whether the benefit received by this property was proportionate to the assessment. That is the standard. Mr. Lamson understood that. And he says that the Hitchens wanted to have this assessment either eliminated or reduced. And in the bottom paragraph, he references the fact that they had reached an equity adjustment with the owner of Lot 11, which was the McLeods, to assess them just for the curbing, which was $1,815. At the conclusion of that meeting, the Hitchens understood that basically there was an agreement between Harriet Drummond, Sheila Selcraig, themselves. Matt Clayman was in attendance at the meeting. The Hitchens had an attorney with them, Dick Roston, and that there was an agreement that Mr. Lamson would calculate the amount of the curbing and that that's what they would be assessed, just like the McLeods. You can see that Mr. Hitchens wrote to Jim that same day in the afternoon, "Thanks, Jim. As a compromise position on our part, we can accept the new assessment of $2,656. And again, later that same day, Sheila Selcraig writes to Cliff Hitchens, Jim Lamson, and Harriet Drummond, CC'ing Matt Clayman, Russ Oswald, Gary Jones, and Jerry Hansen, and states, "It is my understanding that Harriet Drummond and Jim Lamson will take the lead in working with the Hitchens to define and finalize an agreement that addresses this problem." And so in July of 2009, the Hitchens thought that
Mr. Staley, can you please go ahead and summarize your 30 minutes?
I've got a bit, Madam Chair, and as I indicated, we have discussed this ahead of time.
Just give me 1 second. Mr. Owens, are you okay to let him to proceed for another 5 minutes? Okay, thank you.
I'm going to summarize this part of it because I do have something else that I want to move on to. And so in July of 2009, they thought they had a deal. And indeed, we can see that in October 12 of 2010, a document was prepared that essentially summarized that meeting, summarized the equity adjustment that had been discussed, and again references that $2,656 figure. Unfortunately, this never got before the Assembly, and most likely it never got before the Assembly because the Hitchens had sold that lot, and they never got notice of any further meetings regarding it. The notices went to the new owner, and the new owners never gave them notice, and so it just never happened. Dr. Diddy Hitchens actually wrote sometime later to say what's going on, and that's when she realized that the Assembly had passed earlier assessment rolls that essentially had assessed their property for $80,000. That issue is now before you because those old assessment rolls have been set aside. And I'd ask you just to think of this from a fairness perspective. I mean, you've got two houses at the dead end of Marston Drive, both of which have been fully approved, fully assessed, and fully taxed. With regard to one, it's only been assessed for the curbing. With regard to the other, there was an agreement to assess them for curbing, but that hasn't taken place. The hallmark of arbitrary and capriciousness is to treat similarly situated people dissimilarly. And I ask you that at the end of this hearing, that you honor that agreement and that you assess the Hitchens just for that curbing. I want to go back to the bigger picture, though, because I want to talk about these two projects. As originally conceived, these improvement districts were to feed into the existing pump station. Pump Station 10 was originally going to be rebuilt where it was, or very close to where it was. And where it was, again, was over here. And so, with that in mind, the improvement districts were budgeted, and one of the line items you'll see, number 17, is that they were going to construct a sewer lift station. Just a small one, the cost of $110,000, because you couldn't take the sewage from this new improvement district and get it to Pump Station 10 by gravity. And so they were just going to flow to a central collection space, and then it was going to be a forced feed, a forced main to get it over to Pump Station 10. Normally, sewers are about 8 feet deep. But because of the topography that Mr. Owens discussed, in this instance, the sewer main was going to be 12 feet deep. Now that's important because depth equals dollars. Indeed, Sandy Notestein, the engineering technician that came up with that budget, noted in 2002 the difference between having a sewer at 8 feet versus 12 feet would add $5,000 more per lot for those additional 4 feet. Indeed, the total cost differential between a sewer at 8 feet is $565, a sewer at 12 feet is $705,000. So 125% of the 8-foot depth, or 25% more for 4 feet. So for every 4 feet, the cost of the project is going to go up by 25%. And that's because there's more trenching. You've got to dig deeper, so you've got more labor to trench. You've got more material that you've taken out that's unusable material that you've got to dispose of, so you've got extra disposal costs, and you've got more backfill costs. So the deeper you go, the more the expense. In 2004, AWU decided that they were going to look at combining this Pump Station 10 project with these improvement district projects. And that's because they were looking at maybe building this Pump Station 10 in a different location. And again, Sandy Notestein, at that same time in 2004, basically wrote and said, don't do it, it's going to require a reballot, it might fail. We've already had to go to 12 feet instead of the normal 8 feet. She was ignored. They went forward. They hired VEI to study it anyway. And what this did, by moving the pump station from where it was to the new location, it meant that everything was going to be gravity to that new pump station. And everything was going to be deeper at that new pump station. And VEI wrote in 2005, they were asked to look at this, and they said the various alternatives, because they were studying various alternatives, will impact the lid cost because of the varying pipe depths. Okay? So they've recognized right away that this was going to increase the cost. This is the new pump station 10 plan that was devised and was ultimately built. So I want to point out some things here, and I think that this is time well spent because I think this is going to help you with all of the witnesses' testimony. So you've got the old sewer trunk line that went to the old pump station here. Now what they're going to do is they're going to tie into it here, and this is the new east trunk line going to the new pump station here. On top of that is what they're calling a subdrain that had to be put in. Over here you've got a storm drain that's going to be put in. Over here you've got a water line that's going to be put in. And then this gray area is a new access road to the pump station, okay? Because prior to any of this being done, there was no access to this lot. So this was a lot that the municipality purchased. They decided to relocate the pump station. It was going to require a new access road. It would require a new trunk line, new sub-drain in the trunk line, a new storm drain, and a water line to get there. All of that is necessary for that pump station to work for the existing homes in Turnagain, okay? So if that pump station is going to pump the sewage for the existing homes in Turnagain, all of that is required, and that is what is reflected on ultimately on schedules A through C. And you can even see that down here at the bottom, Schedule A, Schedule B, Schedule C. All of that work, all of that infrastructure is for the pump station. I want to talk for a minute about this new access road that's going to be required. VEI acknowledged it. This is the Pump Station 10 feasibility study in June 2004. They acknowledge that a new access road with 2 vehicle parking area will be constructed. The access roads will consist of both rebuilding a portion of an existing trail to accommodate the truck traffic. And again, you can see that on here. Here's the trail transition that they're talking about. Shannon and Wilson also acknowledged this new access road. New asphalt pavements may need to be placed for the new access roadways and must be able to support the anticipated loads. One of the things that the municipality talked about was shared costs. One of the things you're going to learn in this hearing was AWU paid nothing for that access road. Nothing. It was necessary as a part of Pump Station 10, and yet, as far as I know, they have not paid anything for that access road. Instead, all of the cost of that access road was allocated to the improvement district. There are a lot that clearly benefits from this. Put in your mind for a minute the comparison between the Hitchens, who are being assessed $80,000 for this road, who didn't need it, who didn't want it, and who don't benefit from it, and AWU, who couldn't get to that pump station without it, who needed it, who was a part of it in every engineering study that looked at it, and they're not paying anything, not as a lot owner, not as a utility, or anything. This new design had a significant impact on the cost of the improvement district. The depth was going to be much deeper. Here's the Shannon and Wilson geotechnical report for Pump Station 10, and they acknowledge that they're boring test holes to 5 feet below the proposed grade of the new sewer line, approximately 21 to 42 feet below ground surface. So for every 4 feet deeper that you go, you have a 25% increase in costs. This is the new project as conceived with the new pump station. And so you can see here is the new pump station design. Here's that new east trunk line. Here's the deep subdrain that's going to go through here. And now here's this new improvement district that has to tie into that. And all of this is going to be gravity fed to this. So all of this ends up being much deeper, more than 20 feet deep. And so more than 50% more cost associated with that. As a result of this, the estimated cost for the entire project more than doubled. It went from approximately $3.5 million to well more than $7 million. Now, undoubtedly, a part of that was the lapse of time and the increase of pricing because of that. But the vast majority of this was because of the design change necessitated by AWWU's decision to relocate Pump Station 10 and have a new east trunk line that was going to be a gravity line and that was then going to require that the sewer lines for the improvement district go much deeper. 25% additional cost for each 4 feet. And now we're talking about being well more than 8 feet deeper than originally planned. So they had meetings with the homeowners and they said, you've got to approve new estimates on this. You'll see the meeting notes. Nowhere is it disclosed to the homeowners that the reason for this is that we've decided to build the pump station somewhere else and that necessitated design changes to your improvement district that's resulting in this cost. Instead, they blame it on the passage of time and they blame it on the Geotechnical Commission. Clearly, the passage of time had something to do with it, but the design changes necessitated by AWU had a big part of that. You're also going to hear a lot about a deep subdrain, and the Geotechnical Commission required a deep subdrain. And this came up, again, we're talking about the Pump Station 10 Geotechnical Report, and they recommend that there's a deep subdrain. The gravity-fed utility trenches will naturally be preferential drainage paths, and groundwater should easily be collected in drain pipes routed to the storm sewer system. VEI, the engineers hired by AWU, said in October of 2005, Pump Station 10 Soils Report recommends subdrains be installed in the same trench as the gravity sewer lines. Pump Station 10 upgrade project is responsible for redirecting 2 trunk sewer lines to the new pump station. The east trunk sewer installation will be extended northeast, blah, blah, blah. The portion of the trunk line within the Marston right-of-way transverses the side hill and will definitely require deep subdrain installation. The reason why I bring that to your attention is that 94% of the cost, that deep subdrain That deep subdrain is in two places. Okay? That deep subdrain is here for their trunk line, but that deep subdrain also now has to be here. So it undoubtedly increased the cost to the homeowners because it had to be installed there. But this subdrain here that was called for by the soils report that follows the east trunk line to the pump station, 94% of that has been allocated to the improvement districts. In June of 2008, AWU put out the invitation to bid, and they expressly say in the invitation to bid that there's a basic bid and a deductive alternate. The deductive alternate is the RID, LID, and WID. And they call it a deductive alternate because what you're telling the potential bidders is that part of the project might not be go forward. It might be deducted. And so it says if any one of the projects exceeds the amount available from the respective funding source for that project, the deductive alternate will not be awarded in its entirety. And so they've told the bidders that. The homeowners first got notice that these projects were going to be combined in a single bid 3 days after that invitation to bid went out. So on June 23rd, and again, the homeowners are told construction will be competitively bid as a joint project. Contractors will prepare bids based on the entire project, broken down by schedules as listed below. The basic bid, Pump Station 10, is A, B, and C. The deductive alternate, D for the road, E for the lid, F for the WID, and G for linear park improvement. And they're told that the improvement district will go forward so long as no single improvement district exceeds the available funding. Okay? And so the homeowners have been told that A, B, and C are for the pump station, and that this project won't even go forward if the amount bid comes in higher than the available funding.
Mr. Staley, I'm going to interrupt you for just a moment. Mr. Owens, we are 18 minutes past his initial 30 minutes. Do you have any objections to him continuing?
I'm getting close here, so I'd like to finish. I think I'd like to be able to outline my case. You and I talked about this ahead of time. I thought we had...
Okay, I'll let you continue with no objection from the municipality.
Thank you, Madam Chair. When the property owners first learned that these projects were going to be bid together, they complained and they said, don't do that. And they didn't want that to happen because they knew that this pump station project was much more complicated and they weren't likely to get road builders, and indeed that happened. You had two general contractors, large construction contractors bid, Hickel and Pruse, no road builders. Quality Asphalt Paving didn't bid. None of the other traditional road builders bid. The low bidder, as you know, was allowed to walk away, and Pruse was left as the sole bidder, and the property owners said, please don't award our portion of the work. We would rather rebid this at some other time. And recall that 57% had approved this. Matt Fink owned 7 or 8% himself. Chuck Spinelli owned another 7 or 8%. Ray Krieg owned several percent. All three of them, before this bid was awarded, said, don't do this. So removing, and all three of those people had voted for it. So you remove theirs, you're suddenly down to much less than 50% that want this to go forward. And indeed, shortly thereafter, a week or so later, they filed a petition by 70% of the people that were going to be responsible saying, please don't go forward with this. And AWWU ignored it and went through anyway. Immediately after the award, what happened was nearly $1 million from Schedules A, B, and C, that were the basic bid for the pump station, was shifted over to the improvement districts. Now, Mr. Owens has called this cost sharing, but this isn't cost sharing. Keep in mind, AWU has paid nothing for that access road. AWU has offered to pay nothing for the increase of cost to the lid associated with with that deeper design necessitated by them. They haven't shared in any of those costs. The only thing they've done is they've shifted costs that were part of the necessary infrastructure from the pump station to the homeowners. And while I first thought that they had done this after the fact, scrambling because the bid for the pump station came in higher than they expected, in fact, they were planning to do this all along. But because they were planning to do that all along, it's no wonder that they didn't honor the homeowner's request to say, don't award the improvement districts. Because they were planning to save at least $1 million by shifting these costs. Remember that the invitation to bid said that if any one of these bids for the improvement district came in higher than the approved funding, that none of that improvement district work would be awarded. Now keep in mind, you've got a total project cost. A total project cost has various components, one of which is the construction cost, the contractor construction cost. But long before you ever get to the contractor out there digging the trenches, you've spent hundreds of thousands of dollars with the design engineer. You've spent more than $100,000 with regard to public meetings. And so you've got engineering, surveying, rights of way. So the construction contract is just one component of the total project cost. Here is the estimate for the road improvement district. This is what would be called the Schedule D. And the contract cost for Schedule D is $2,033,505. They've added a 15% contingency in case it goes over. And so they've estimated that it's $2,338,530. Now, as I indicated, all along they were planning to shift some of these costs from the subdrain that was necessary for PS10, which is really Schedule B for PS10, to the improvement district, to the road. So you will see that right here at the top. Note, the following items of work are funded by the RID, but will be constructed with the PS10 upgrade. And you'll see it's the 12-inch perforated subdrain, it's the subdrain cleanout, the subdrain pump station. This is all from Schedule B. Now, this isn't the subdrain on the east side for the improvement district. This is the subdrain. This is the subdrain right here. And you'll hear this testimony. It's Schedule B. So they were planning on shifting that all along, and they've estimated what that is, $315,000, contingency again of 15%, so $363,000. So the total construction cost for the road is $2,701,545. Write that number down, $2,701,545. Now again, that's the construction cost. In addition to that, you've got easement acquisition, liability for, or utility for illumination, consultant design engineering, public involvement program, design survey, PM&E design management, geotechnical engineering, construction management, I don't know what's Corps of Engineers, stream permitting. All of that's going to cost an additional $3.8. And you've got some overhead. Then you've got an escalator because it's 2008. So the total project cost is $4,418,944. Write that number down. That is the number to the dollar that was the approved estimate. This is where the approved estimate comes from. This number is to the dollar the maximum funding that's available for the construction portion of it. And we can see that right here on the bid abstract when they opened it up. There's that number again, $2,701,545. That's the maximum available for the construction contract for the road. Now again, keep in mind that they planned all along to take, and remember that $2,701,000 includes these numbers that they were going to shift, includes this deep subdrain from Schedule B that they were going to shift over. And indeed, when they were analyzing the bid, here it is. Schedule D, deductive alternate, RID items from Schedule B, pump station 10 upgrade and subdrain improvements. And so it's talking about the fact that these are the items from Schedule B that they're going to put in Schedule D, and they've known this all along. And here's what Cruz bid for those items. And here's what it added up to. $834,542. All but $56,000 of Schedule B. 94% of Schedule B was shifted to the RID. And it was always planned to be shifted to the RID. So when we look at what Cruz bid for the RID, we can see that Cruz bid, this is the bid tab, Cruz bid for the RID from Schedule B, 834,542, and from Schedule D, 2371706. That 2371706 is slightly higher than what the engineer had estimated for just that portion that wasn't going to be allocated, but this portion here is substantially more than had been anticipated, and the total, $3,206,248, is $500,000 more than the maximum bid. This contract should not have been awarded. The invitation to bid said, the letter to the homeowners said, if any one of these exceeds the maximum funding, it should not be awarded. The homeowners said, don't award it. And they ignored it, and they awarded it anyway. And you know what? The actual cost, the total project cost for this, guess what? It came in $500,000 over the approved estimate. No surprise, because even though they're very good at doing this estimating, the construction portion, the bid for the construction portion was $500,000 more than the maximum allowed funding. There's one more thing I want you to keep in mind, and then I'm going to be done. The construction is just one portion of the project. So we saw that from Schedule B, they shifted $834,000 of the pump structure infrastructure. With regard to the WID, they took $60,000 from Schedule C of the pump station infrastructure and shifted it. And for the lid, they took nearly $95,000 from Schedule E and shifted it. This is what the municipality is calling cost sharing. It's cost shifting from Schedules A, B, and C. The water line that went to the pump station, the subdrain that went to the pump station, the east trunk line that went to the pump station, a portion of that was all shifted over to the improvement districts. But you know what else was shifted and that we don't know and we can't see because it's not clearly delineated this way? Keep in mind that the construction cost is just one portion of it. When we look at this bid, we can see that the construction portion of the RID was 2.7. The non-construction portion was 3.8. For a total of that can't be right. It added up to 3.8 for a total of 4.4. But from 2.7 to 4.4, all of that is non-construction. So when they shifted nearly $1 million of construction costs, they also shifted a lot of that design cost. The design engineering for that subdrain that was a necessary part of that east trunk line, that was all borne by the improvement district. And so it's not just the $1 million construction cost that got shifted, but it's the non-construction costs associated with that got constructed as well. I'm confident that when you hear the evidence, you'll agree with me that this is not right, that the Superior Court asked you to take a look at this for a reason. And if this body doesn't do the right thing, the Superior Court will be looking at it again. I thank you for your time, and I look forward to presenting the evidence.
Thank you, Mr. Staley. Thank you, Mr. Owens, for your indulgence. At this time, I'm going to go ahead and we will briefly recess till 10:15 so members can stretch and grab a cup of coffee. Assembly members are instructed not to discuss this matter of any substantive nature as we'll wait till our deliberations to do that. But until now, we will stand adjourned until 10:15. We will call the remand hearing back to order. At this time, we are going to open up the opportunity for property owners to either testify or make comments. If there is anyone here in the audience that would like to do so, please come forward. All right, seeing none, then we will move on to the municipality of Anchorage. You now have a flexible 4 hours, I think, to present your testimony. With that said, in between witnesses, we do plan on taking breaks as needed. Mr. Staley, if you need a break or if committee members need breaks, just give me the wave and then we'll just build them in. We'll be flexible as we go.
Great. Thank you very much. Municipality would like to call Brian Boss.
Okay, Brian, please step forward. And actually, you can step up to the mic, and then the municipal clerk will swear you in. Please state your name and spell your last name for the record, please.
My name's Brian Boss, last name spelled B-A-U-S.
Thank you.
Thank you, Mr. Boss. Could you please raise your right hand? Do you solemnly and sincerely swear or affirm that the answers you will give to the questions asked of you in these proceedings will be true?
I do.
Thank you. Mr. Owens, could you please speak a little bit closer to the mic so that we have a good record of the proceedings? Thank you.
Good morning, Mr. Boss. What do you do for work?
I am the Planning and Development Services Manager for the Anchorage Water and Wastewater Utility. Would you like me to elaborate my role?
What does that mean?
So essentially, the Planning and Development Services Department administers the balloting process of improvement districts for water improvements and sewer improvement districts. And then we also administer the levy of improvement districts. So that's after construction's finished, portioning out the cost to each property and then going through the assembly process to get the rolls approved and then send it off to our billing section to get them billed.
And how long have you been with AWU?
Since about 2001.
And how long have you been in your current position?
Since about 2007.
And what were your roles before that?
I was a project engineer before this, a civil engineer too. My primary work was with another agency roads section, but I was also detailed as a project engineer for this project from about 2005 to approximately 2007.
And have you prepared a little presentation for the panel to put this project into context?
Yes, I have.
Okay, would you proceed?
Sure. So now I just need to get we plugged in the monitor to the computer. We're just trying to get it on screen.
There we go.
Okay, my presentation is essentially an overview of special assessment improvement districts related to this case. As I said, I'm Brian Boss, presentations for the hearing panel. The intent of a special assessment district is it's a program to improve private property. General components of a special assessment district are that it's a program where property owners come to the municipality and they request a specific improvement be built. These programs are generally initiated by neighborhoods that have diverse property ownership, so it's not one common owner like a standard private development. It's more a group of properties that don't have specific improvements and want them, and they're typically not developer engineers, so they're looking for the municipality to help them manage the project and get the project off the ground. So essentially, they come to the municipality, they request an improvement be built. The municipality would then go through a balloting process and receive approval by the property owner. By state law and local law, over 50% of the property owners have to approve that process or that cost estimate. Once it's approved by the property owners, it goes before the assembly for approval. It's designed and constructed by the municipality. At that point, the municipality does the upfront financing. Then after it's constructed, property owners would reimburse the municipality via an assessment. Applicable regulation associated with the improvement district process is found in state statute AS 2946, Anchorage Municipal Code Title 19, and the Anchorage Water and Sewer Tariffs Rule 8.2. This program is an alternative program to the private development program. So essentially, when people are trying to improve property, they really have two choices to build water and sewer infrastructure. One is this improvement district program. The other is the private development method, where you have one developer that would pay to design and construct an improvement district. Then they would, or an improvement. Then they would enter into agreements with the municipality to contribute those improvements back to the municipality for ownership and maintenance in lieu of an assessment. These are the three improvement districts that were built as part of the Turnagain Heights Sewer Lateral Improvement District, Turnagain Heights Water Improvement District, and Marston 4-Acre Road Improvement District. Can I borrow your laser? I got this pointer here. Yeah, I'll take the laser pointer. Whoa. So, as you can see, the properties shaded in gray are the properties that were beneficiaries of the sewer improvement district. The shaded piping is the piping that was paid for as part of the improvement district. So from this manhole to here, that piping was entirely paid for by the improvement district. and this portion of piping from here to here was paid for as a pro rata share by the property owners. For the water improvement district, the same type configuration. The shaded blue line is the water pipe that the property owners paid for as part of the improvement district. The shaded properties are the properties that benefited by it. And as far as the road improvement district, here's the scope of the road. And once again, the shaded properties are the properties that were the beneficiaries of the road improvement district. So the improvement districts really built new infrastructure on a foundation of a disaster area. Everybody that's from Alaska or who has lived in Alaska for a long time knows about the 1964 earthquake. The 1964 earthquake devastated this area. So you'll see in your exhibits there's photographs of the area before and after the earthquake and just post development. And what you're going to see is the Turnagain Heights neighborhoods were just leveled. They basically slid into the ocean. And then what they did is they regraded them, and then it grew back to natural vegetation over time until the improvement districts were constructed. It was always somewhat controversial as far as developing land after the earthquake. The property remained platted, and property owners maintained title to the property. We know that state officials didn't intend for people to develop again, or at least didn't anticipate people to develop again. We have accounts from property owners, and there's records reading back about the earthquake where the state contributed land to property owners that had destroyed land in the earthquake in Zodiac Manor. They basically provided them land in Zodiac Manor thinking they were never going to build again. Their property was destroyed, so they gave them land, but the property owners retained that original title. What ended up happening is towards the late 70s, property owners that retained that title started applying for building permits. When they started applying for building permits, there was all sorts of controversy by adjacent property owners, by members of the municipality, over whether or not they should build because of the earthquake and because of the potential for it to happen again, and public health and safety concerns. So what ended up getting passed was a series of ordinances. The ordinances that ended up at was AO 7884, which basically limited development contingent upon other improvements going in, such as streets, road, water, and sewer. So for properties to acquire a building permit, they had to have all these other things, and they were outlined within the ordinance. Implementation of improvement districts in this area offered many benefits, and a lot of them were related to some of the issues associated with the earthquake. One, it minimized risk to the property owners. So as I said before, you had discontinuous property ownership throughout the Turnagain Heights and Simonson's Estates neighborhood. It wasn't one property owner, it was many. Implementing the improvement district process allowed everybody to pay into it, and it ensured that 100% of the property owners would participate in payment for those improvements. It also established a cost cap. Because of the laws associated with improvement districts, the municipality can't charge over 110% of what is balloted. So the property owners got the advantage of knowing the ceiling of what their improvements were going to be once the assembly approved the districts. It also offered a time payment of assessment. So property owners didn't have to pay for it all at once. They could pay for it over 30 years after the improvements were constructed. Placed the burden of project management on the MOA. As I said, there were a lot of complexities associated with this project. You had coordinating multiple things associated with the earthquake. There were contaminated soils. There were issues associated with people that had died in the earthquake and recovering property and bodies and things like that. So one thing this did is the municipality took that responsibility, and the developer, the property owners, didn't have to. We also financed it up front for the property owners. So we paid the upfront money. They paid for it over time. And then we were also responsible for the study, the design, and the construction closeout. They didn't have to do that. We did that for them, and then they paid us for it at the end. For the RID, there was also a subsidy offered, and this is found in municipal code. Basically, the property owners paid 70% of the RID project costs, and the municipality paid 30%. For the water and sewer improvement districts, it's different. In tariff, it says that property owners pay 100% of the project costs, although it can't go above that 110% cap. Once the balloting's finalized, the municipality really controls implementation of the project. So basically, we would finalize the balloting, go through the assembly process, and then it's really turned over to the municipality to design, construct, everything associated with purchasing that's done by the municipality and lets us control what we're building. What we do to ensure equity to the property owner is we track the scope of services. That's done in a couple of different ways. Basically, you're tracking the task you're doing based on schedules and scope, and then you track the accounting based on project accounts and activity IDs within those accounts. So we're tracking what we're doing to make sure we're actually charging property owners for what they balloted versus some of the ancillary things we would build with the improvement districts. Going over the timeline of these improvement districts, things really got started in 2002. What we received was an individual request from property owners in the form of petitions. Those petitions came in a letter where they basically requested that we start the improvement districts, and the letter demonstrated that they understood basically about the balloting and the improvement district process and the financial obligations they would acquire. Improvement district balloting wrapped up in about 2002 to 2003. The property owner approval for the initial ballot was 59% for the RID, 70% for the WID, and 70% for the LID. As we went forward in the process, it took till about 2004 before the Assembly finally approved the initial improvement districts, and that was through the ordinances that you see in front of you on the screen, AO 2004-2, 2004-19, and 2004-20. Those are also in your exhibit packets as Exhibit B12, B10, and B8. There was a great deal of back and forth between the municipality of Anchorage and the property owners at this time, where we were just chalking up different options versus the private development program and the improvement district program. That's why it took so long for this to ballot. In 2005, we started design with VEI Consultants. There was a contract let where VEI had the design contract for the road, the water, and the sewer. As we progressed forward in design, it became readily apparent that we were going to need to reballot these districts. It was just apparent that those costs were going to go over that 110% cap. So what we did is, as soon as we had the design study report to where it outlined all the costs and we could make that available to everybody, we reballoted the district. When we reballoted the district, it was 57% in favor of the RID, 65% in favor of the WID, and 65% in favor of the LID. We then went forward in 2007 through AO 2007, 53, 51, and 52 to have the Assembly reaffirm those districts. And those are in your exhibit packets in C11, C7, and C9. Construction started in 2008. By about the time of construction, we had already expended $850,000 in previous design and study activity related to the RID, WID, and LID. We bid these projects with the Pump Station 10 upgrade. Prus Construction won the award. In 2010, construction was completed. We then went through the process of calculating costs and reconciling costs. What we ended up with was final costs that we presented before the Assembly in Resolutions 2014-193, 194, and 195. Those resolutions are still pending approval of levy action, and that would be considered after this hearing. The costs for those resolutions are given within your exhibit packets in G1, G2, and G3. As far as a summary of the project costs, as you can see, the first line is the WID, the second line is the LID, and the third line is the RID. So in 2003, the estimated cost for the WID was about $500,000, LID was about $800,000, and the RID was about $1.4 million, roughly. As I said, that once we had the design study report, the estimated cost rose dramatically. Those costs ended up being about $1.2 million for the WID, $1.6 million for the LID, and $4.4 million for the RID. Those were the costs that were approved by the property owners and the Assembly in 2007. What we ended up building the project and the 2014 reconciled costs are $1 million, $1.3 million, and about $4.8 million. So what that totals with, based on what we balloted for what we built for, is we built the WID for about 84% of what we balloted. We built the LID for about 80% of what we balloted, and we exceeded the cost cap for the RID and built for about 111% of what we balloted. When we go to levy, property owners will be levied these actual costs for the WID and LID, but they'll receive that 110% cap for the RID. So in summary, the Special Assessment Program is a program to improve property for the benefit of the property owners. It's requested by the property owners and approved by local government. It's managed by the municipality. It's a competing program to the private development process. The subject districts redeveloped a previously destroyed area, so it was essentially new development, just had its challenges associated with a base of a disaster area. We built the improvement districts as requested for 84% of the WID approved costs, 80% of the LID approved costs, and 110% cap of the LRID costs.
So do members of the panel have any questions for Mr. Boss?
I think members of the panel will wait for or after cross-examination.
Okay. That's the presentation.
Good morning, Mr. Boss. You and I have never met or spoke before, I don't believe, have we?
No, I don't think so.
Okay. And am I correct in understanding that you said your involvement in this project was from 2005 to 2007?
That's when I was detailed as a project engineer. So if you look at the hierarchy, for how AWW manages a project, the engineering director is the top tier. Right underneath the engineering division director, you have a project manager. At the time, that was Linda Barber Wilsey for me. Then the second tier is the project engineer tier. At the time, that was myself and Steve Nuss. And then you have a series of engineering technicians that are somewhat pool labor. They come and go. They support the project. So.
And so you supported the project from 2005 to 2007 in that capacity?
Yes.
Okay. And so we know that this project wasn't even actually built until 2008 and 9, and the first time it was brought before the Assembly was 2011. Did you have any direct involvement in that or not?
Yes. So in my capacity as Planning and Development Services Manager, the way a project works, at least in improvement district, is property owners make that initial request to the planning department, which is the department that I run. The planning department does the balloting through to the assembly process. It does the initial estimates, then they pass it off to the project management section. The project management section implements all the way through construction and project closeout, then they turn it back to the planning department. So as the Planning and Development Services Manager, I basically took over in about 2011 to today just for levying of the project.
You mentioned in one of your slides that in 2005, VEI was hired, and as a result of that, the estimates for these improvement districts went up dramatically, correct?
I wouldn't say it was a result of VEI being hired.
Well, I didn't mean, but they were hired to.
Yeah.
They were hired as a consulting engineer, correct?
Correct.
And new estimates were arrived at that more than doubled the price, correct?
Yeah, the new estimates were more than double, that is correct.
Okay.
In fact, I think they were triple for the RID. So.
Okay. And in fact, VEI was hired for Pump Station 10 at or around that same time, correct?
Correct.
And so VEI was working on both looking at building Pump Station 10 as well as how to engineer and design these improvement districts, correct?
Correct.
And VEI, with regard to Pump Station 10, was tasked with looking at a variety of alternatives, some of which were to look at just upgrading Pump Station 10 in its then location or very near its then location, or alternatively moving it to where it was ultimately built, correct?
Yeah, that is true. There was a site selection process VEI was working on with AWW around the initial time frame. Yes.
Okay. And so it was looking at a variety of alternatives, and ultimately it chose the alternative of moving it to this remnant parcel, which is basically adjacent to this improvement district, correct?
Correct.
Okay. And as a result of that, there were design changes necessitated to the improvement district, correct?
Correct.
Okay. And those design changes essentially were that the sewer lines were going to be much deeper, correct?
You had to reconfigure the sewer lines as well as adjust depth in certain areas. Yeah.
Okay. And you don't disagree that as a result of that, as a result of having to dig deeper, that caused costs to go up, correct?
It changed costs. I would just say it changed costs. I mean, when you mean go up, how so?
Well, to dig deeper costs more money, doesn't it? I mean, you have to pay somebody to dig a trench, and if you're paying them to dig it 4 feet or you're paying them to dig it 20 feet, there's going to be a difference in cost, correct?
When you're just talking about depth, yes, but when you're talking about overall project costs, I wouldn't say so. I mean, combining the pump stations that allow us to eliminate one whole pump station, so that's a cost reduction. So what it would do to the overall project cost, I really couldn't tell you because I wasn't the project manager at that time. But I would not say that it was a dramatic increase to the overall project costs. If anything, it was probably a cost savings.
And have you done any analysis to determine that there was a cost savings?
Just preliminary basic stuff, not me myself, but other members of AWW staff.
Okay, can you show me anything to demonstrate cost savings?
No, not today.
We do know that the cost more than doubled from the original estimate to the subsequent estimate, correct?
Correct.
And we do know that the engineer who originally looked at it said that going from 4 feet deep to 8 feet deep was going to increase costs by 25%, correct?
That wasn't an engineer, that was an engineering technician, and she was speaking specifically to just pipe depth. You're talking about the difference of building one pump station versus two pump stations, so it's not exactly apples and oranges.
Well, let me ask you, Mr. Boss, you seem to be representing to this assembly that only one pump station was built. That's not true, is it?
Yes, it is. Well, one sanitary sewer pump station.
Okay, and there's a whole second pump station that ended up having to be built as a result of this design, correct?
I can't really speak to the storm drain pump station. I wasn't really involved with that in any aspect of what I did. But yeah, there was a subgrade and there was a pump station associated with that.
Am I going to be able to still use this, or?
Yeah.
Still have your screen up there. So this is the original estimate. You can see that the small, this is Exhibit 8. Actually, it's Exhibit B5. It's your exhibit, B5.
Mr. Staley, can you repeat that into the mic so I can hear you?
B5.
Bravo 5, thank you.
So this is the original estimate for the sanitary sewer system, the LID. And you can see line item 17 was construct a sewer lift station for this LID at a cost of $110,000, correct?
Yeah, correct.
Ultimately, with this design change, there needed to be, in addition to pump station 10, there needed to be a separate pump station for this deep subdrain. Is that correct?
You're speaking outside of my expertise when you're talking about the subdrain or the requirements for that. That's just not what I did in my capacity.
Okay.
I would note that Mr. Boz was presented to give the overview of the balloting process. The detailed project management and engineering issues would be addressed by another witness.
Okay, I just want to address your comment that you believe there might have been cost savings when we know that the estimated costs, in fact, more than doubled. And so I just want to show you E3, page 11 of 14, which again, at the top of this shows the costs from Schedule B, the deep subdrain, that were shifted from the pump station to the improvement district. The total of Schedule B was just under $900,000, and all but $56,000, in other words, $834,542 was shifted from the pump station to the improvement district. And the bottom line item there is indeed a pump station at the cost of $300,000, correct?
As those are storm drain costs, they would not have been accounted to the sanitary sewer improvement district, and they wouldn't have been balloted or levied as such. So what I can tell you is there was no sanitary sewer pump station that will be levied as part of this process. What you're speaking to is part of the road improvement district.
Well, it was
RID
a part.
Costs.
Well, sir, it was a part of Schedule B for the pump station, correct?
Well, I don't know. That's out of my expertise for this. So.
Let me just address a couple other things that you say that were within your expertise, one of which is you talk about the fact that the municipality assumes a risk because there's this ceiling you can't assess more than 110% of the estimate, correct, sir?
Yeah, correct.
Isn't that, in fact, why the estimates regularly come in high, knowing that, That's an absolute way to protect yourself. If you get an estimate from a contractor and he says you can build this project for $1 million, and that includes 20% contingency, so you've already factored in a 20% risk, and then you ballot with the people at 1.6 million, you've really protected yourself, haven't you?
Well, we always build contingencies into our estimates. And as you see on that sheet you were just showing, the original estimates, you'll see exactly what our contingencies were in that. And they're standard design estimate contingencies. So in this case, I think we had some for geotech and other things like that. But without having that sheet in front of me, I'd have a hard time really speaking specifically to what those were.
So I'm going to show you Exhibit C2, which is VEI's estimate for the WID. And as you've indicated, there's a number of contingencies built into this. Up here at the top, there's a 20% contingency on the construction costs, and so you've built in a 20% buffer there, correct? Or VEI has, rather, correct?
VI, when they generated that estimate, that would be one of their contingencies, yes.
Okay. And so the estimate for the WID was $1,092,446, correct?
Say that again.
$1,092,446 for total project cost was the estimate from VEI.
I would say you're incorrect. As far as what? For the WID, LID, RID?
The WID. This
So
is VEI's estimate for the WID.
The estimated cost that went before the assembly for the WID was $1,229,140.
I understand that. And that's exactly gets to my point. Where is the actual estimate that justifies this high estimate that you asked the property owners to approve?
So it would be with the design records. As I'm saying, I was the project engineer. I didn't prepare that estimate. So you're going outside of my expertise on that too.
So you would anticipate then that some witness should be able to come before this assembly and justify that number. It's not just an artificially high number, correct?
Yeah, someone should be able to walk you through the estimate. All I can speak to is what went before the assembly.
I'm not going to belabor the issue since you don't seem to have the information, but I will put before you C3, the municipalities exhibit, which is VEI's estimate for the LID, and you will see total project costs of $1,025,651. And again, that's not what you put before the property owners in order to get them to approve it. In fact, what you put before the property owners to give yourself plenty of room to come in under budget was $1.6 million, correct?
I would say you're speculating.
Well, was it 1.6 or not?
It was $1,663,105, but
So you would expect, wouldn't you, that there should be some sort of an estimate to justify that number, correct?
yeah, and the estimate would have components of study, design, construction. I'm not exactly sure what you're putting up there in front of me as far as what phase it's speaking of. Is it covering all of that? I'm not sure.
Well, sir, it's got the construction costs for what ultimately was the schedule for the LID. It's got the construction costs for what AWWU was planning to shift from Pump Station 10 to the LID. It's got design engineering, geotechnical engineering, construction management, administration, overhead, and something called AFUDC. Do you know what that is?
Yeah, that's basically what we spend to finance the money. It's hard to explain. There's our overhead rate, and then there's our AFDUC rate. And the AFDUC, I believe that's the interest on the capital program.
Okay, and so do you think that there's something missing here?
Yeah, probably AWW, labor, study activity, things like that don't appear to be on there. But you're going to have to, again, you're going outside of my expertise, and you're going to have to get clarification for whoever prepared the estimate.
Okay, so you would anticipate, though, that some witness is going to be able to come before the assembly and show an actual estimate justifying that 1.6 million?
Yeah.
Okay. Again, though, to address your issue, your testimony about risk, et cetera, to the extent that you build in a lot of contingencies and buffer, there's not much risk that you're going to go over what if you've already built in 20% risk and you can go another 10% higher than that, there isn't really that much risk that you're going to go over, is there?
That's what you're trying to do with an estimate, is make sure you don't go over.
Okay. And with regard to the fact that you finance it, et cetera, again, the cost of that is all in there and paid for by the property owners, correct?
Yes.
Okay. And with regard to your testimony regarding the allocation or the sharing of costs for the RID, you said 70% for the owners, 30% for the municipality. That's how the costs are allocated or shared, correct?
In code, yes.
Okay, that's separate and distinct from cap, correct? I mean, on one hand, you've got the concept of capping something. Total costs shall not exceed X. And then, with regard to those total costs, they will be shared or allocated pursuant to a formula, correct?
Correct.
So those are two different and distinct concepts, correct?
You cap the total project cost, then you allocate them 30 and 70%.
Okay, so if there's a code provision that says that with regard to an improvement district project, that we're concerned as a municipality with runaway overhead. We're concerned that too much of municipal salaries are going to be passed to homeowners, and therefore we're going to cap the amount that you can assess these private property owners at 120% of construction costs. That concept of a cap is separate and is distinct for how that cost is then going to be allocated, correct?
Say that again.
Sure. Again, the concept of capping costs is different than how you allocate costs.
Yeah, correct.
I want to take a look at A7, which is the pump station design, and you're surely familiar with this, correct?
Yeah, I'm familiar with the design plans.
And this is the pump station that got built, correct?
That's the pump station that got built,
Okay.
but not as part of the improvement districts.
No. But a portion of this trunk line was paid for by the improvement district, correct?
Correct.
A portion of this water line was paid for by the improvement district, correct?
Incorrect. It was... So the improvement district portion that got paid for ended at Lot 2. Having trouble seeing your lots.
This
is
is lot
that-
2 here.
So 10 feet onto that portion of property, everything else was picked up by the pump station, and then this portion down here was paid for by the improvement district.
Okay, so this portion was paid for by the improvement district, correct, of this water line to the pump
Correct.
station? This portion of the east trunk line was paid for by the improvement district, correct?
That was prorated out, so there were depth corrections and oversizing as far as piping corrections. However, you're going to want to get detailed specifics from the project manager on that. I'm not going to be able to speak to detailed specifics of that.
This deep subdrain here that goes like this, 100% of that was paid for by the improvement district, correct?
Don't know. That's also a question for the project managers.
Okay. And this access road, 100% of that was paid for by the improvement district?
No, that's not correct. The pump station should have picked up the access road, and then the RID would have picked up all the way fronting. That's also approximately to here. Is that Pete's lot 2 as well? Yeah, so that you're going to want to get specific details about through talking with the project managers, but in the way we balloted the district, no.
That's all the questions I have for this witness.
Thank you, Mr.
Just a moment, Mr. Ross. Are there questions from Assembly members? Mr. Trini, did you have a question? Okay. I have one. And since it seems like you're the expert on balloting, you may or may not be able to answer this. Regarding to Exhibit 19, it's an email from Sandy Notstein to Don Kiefer. Are you familiar with this email?
I believe so, but if I could have a copy to look at, that would help.
Mr. Owens, could you put it up for me, please? Or hand it to him, either way. So it's exhibit number 19.
That's all right.
Is this?
Oh, maybe it's not.
If I'm looking at
Mr.
it,
Boz, that's their exhibits.
am I looking in the right book?
Do you have a witness copy?
I do, but I don't know if Exhibit 19 is the one that...
It's in this. It's in this book right here.
Okay.
We don't have that.
They don't have that one. Let me just hand you my copy. Okay. So it's exhibit number 19. It's under the pre-hearing brief appellant. Exhibit number 19. Yeah, thank you.
I think it's hearing Exhibit 33.
Okay. So this question is specific to a balloting process. In this email, in the second paragraph there, Mr. Staley, do you have a copy of this? Oh, sorry.
Well, I don't know that it is 30. Well, yeah, okay. Yeah, it's 33.
Oh, okay. I'm looking at a different book. I'm sorry.
Yeah, it's hearing Exhibit 33. You're looking at an exhibit to a brief, I believe, but yes.
Yeah. Sorry about that. She references, Ms. Notstein references the change would require a reballot of the parcels. Can you explain to me, first of all, is she right? Go ahead.
In the way we did, the way we actually built the pump stations, I don't believe she was correct. Back in 2004, when the email was written, Sandy Notstein didn't have the knowledge of where the pump station was actually going to be located. So I believe when she wrote this email, she was thinking that it would be located in its existing configuration, which would have considerably changed the depth of how things would have to be laid. Where we actually built the pump station was in a different configuration where I believe she was talking about here that allowed us to do different things. Shallow up piping on the western end of the project, and then on top of that, we didn't have to actually get it into that trunk that drained to the existing interceptor. So I think had she done this with the knowledge of where the new pump station actually went, she probably never would have written this email. But that's why she was doing it, is she was basically exercising caution, trying to combine the lift stations flowing to the one in the old pump station location that was located at Sandstrom Drive. So the full-blown relocation changed things.
Okay, so can you, I guess I'm not tracking entirely, can you explain to me why in one scenario you might have to reballot versus the other scenario where you would not?
When you reballoting in design is basically a function of cost escalation. So when we reballoted the districts, the reason we primarily had to reballot them was because of the market, right? Essentially, when Sandy initially did the estimates for the projects, we were building for approximately $100 a foot, $200 a foot, just rule of thumb ranges. By the time 2005 and 2006 came around, there was a dramatic increase in the market across the country. Gas prices went up, steel prices went up. We were just building for more. So by that time, we were building more for like $300 to $500 a foot. That's why we ended up having to reballot. When she wrote this email, she was concerned that we were going to have to deepen the whole project to get it into the Sandstrom Drive pump station. We actually changed the location of the pump station to make it easier to drain into. And so I think that's what she was worried about here, was we were going to have to deepen everything to get it into Sandstrom Drive versus what we actually did.
Thus, by deepening everything, getting it into Sandstrom Drive, it would increase the cost. That's what
That's
what
she was worried about, was primarily depth in this email.
Okay. Does either Mr. Owens or Mr. Staley have any questions to follow up on that question?
Just very briefly, do you know what the average depth was of the sewers as constructed?
You mean was as constructed?
As constructed, sir.
So the western portion should have been about approximately 8 feet deep, but I'd have to review the plans. And then the portion that goes to the pump station is deeper, but I'm not sure how deep because it's draining into that pump station down there.
Again, somebody should be able to look at the plans and tell us that.
Yeah, we could all look at the plans if you wanted and go over it, but yes.
I'll just wait till the
Thank you.
the engineer is on stand to ask him.
Thank you. Any additional follow-ups? No. Thank you, Mr. Voss.
Our next witness will be Mr. Kyle Brennan.
Mr. Brennan, can you please state your name and spell your last name for the record?
My name is Kyle Brennan, Brennan.
And the municipal clerk will go ahead and swear you in.
Do you solemnly and sincerely swear or affirm that the answers you will give to the questions asked of you in these proceedings will be true?
I do.
And for Mr. Brennan's testimony, we will be looking at exhibits in tab L.
Before you get started, Mr. Owens, can I ask that you have the presentation that was just given to us by Mr. Boss be included as an exhibit?
Sure.
Do you have any objection to that, Mr. Staley?
No.
Okay, so we'll call that one, I think we didn't have any Exhibit Ms, so I think we'll call that one Exhibit M for the
M1.
appellee. Thank you. And Mr. Boss, if you could just give that to the municipal clerk, she'll get it printed off for us. Okay. Thank you.
Good morning, Mr. Brennan.
Morning.
What do you do for work?
I'm a geotechnical engineer with Shannon and Wilson, and I'm also the chairman of the municipality's Geotechnical Advisory Commission.
You might need to pull the microphone just a little closer. And what are your position and responsibilities with Shannon and Wilson?
With Shannon and Wilson, I manage our Anchorage Geotechnical Group, so there's a lot of administration work, but also I manage projects as well, perform engineering calculations, and provide engineering recommendations for a wide variety of projects.
And how long have you been with them?
I've been with Shannon and Wilson for about 14 and a half years.
15 and a half?
14 and a half.
14 and a half. And what did you do before that?
I was a student at the University of Alaska Fairbanks working on a master's degree in geological engineering.
Mm-hmm. And what is your, how long have you been with the Geotechnical Advisory Commission?
I don't know exactly how many years, 3 or 4.
Mm-hmm. So were you on the commission when the issues having to do with the reference to the Geotechnical Commission for the Marston Forester projects were presented?
No, sir, I was not.
Okay. What was your involvement with the projects in 2005?
In 2005, I was the project manager for Shannon and Wilson's work. So I managed the geotechnical work for the Marston Forker project as well as the Pump Station 10 project.
And were you involved in preparing a report in 2005?
Yes, sir. I was the primary author of the report and responsible for its contents. Yes, I managed the work that was required to develop that report.
I think just beyond you, there's 2 binders of exhibits. If you could grab the one that has section L in it. And refer to L1.
Okay.
Are you familiar with this document?
Yes, this looks like the report that we generated for the Marston Forker Road and Drainage project.
Did you assist in writing this document?
Yes.
And did you sign it?
I believe I signed and stamped it, yes. Yes.
What was the purpose of this report?
This report was intended to cover the Marston Forker road improvement project, which included the road developments, the overall site grading that was involved with recontouring the subdivision or this portion of the subdivision, and it was also intended to cover engineering recommendations for the utilities and whatnot. And in that, there was a lot of slope stability studies and evaluations that were incorporated into all of those recommendations.
So is this report specific to the road improvement district?
Yes.
Did it address design concerns for the pump station?
No.
Was there any other reports prepared by Shannon and Wilson in relation to the pump station?
Yeah, I'm certain that there was a Pump Station 10 report separate from this that covered the recommendations for the pump station.
Okay. And what would be the differences between the 2 reports?
Well, generally speaking, the main differences would be in the engineering recommendations that were specifically needed for developing the pump stations, like the building foundations, any other special things that were involved with developing a pump station, as opposed to all the things that you look at for a road improvements and utility improvements. But there were also some similarities, basically because they were in the same area of development.
And what sort of effort went into preparing this report?
Well, generally speaking, we conducted field explorations to evaluate the subsurface conditions within. Are you speaking just about the Marston Forker or
Yes,
both?
the Marston Forker,
Marston Forker.
Road and Drainage Report.
Okay, so generally speaking, it was a subsurface explorations effort to evaluate the subsurface conditions. We conducted laboratory testing on samples recovered from that. We performed engineering calculations, probably most extensively addressing the slope stability issues of the area given its past in the 64 earthquake, and evaluating the stability concerns, figuring out how stable the site was and what could be done to make sure that the development that was occurring for Marston Forker road improvements did not decrease stability, and also what could be done to increase the stability of the site and basically provide more confidence that it would perform under a seismic situation.
What did you consider to be the site for purposes of this report?
For Marston Forker, it was, the road itself, the utilities that went into the road or near the road, and then all of the property surrounding it, essentially from the top of the slope scarp all the way down to the mud flats, essentially.
Could you refer to page 31, native page 31 of Exhibit L1, please? I don't know if I can get this on. There it is.
Okay.
Are you looking at a map of the area?
Yes, I am.
Is it the same one that's on the screen?
Yep.
And could you identify, does this map show where the field test bores were taken?
Yes, it does. It's the small circles labeled B-01 through, I don't know, looks like there's about 11. The small circles with the cross in the middle, the black, alternating black shading.
And are those along the route of West Marston Drive?
Yes, sir.
Do they go around the corner and up onto Foraker?
Yes.
Do they extend any other areas than the right-of-way?
Yes, boring 11 is not on either of those alignments. I'm not sure. I think it's Iliamna. It's basically a little upslope from the Marston Drive.
Am I pointing at that bore here?
That's correct. Yes.
Okay. And is that the area of concern for this report?
I mean, I would consider the area of concern for this report to be the entire image shown in that plan. Yes.
And what sort of lab testing occurred?
Lab testing, general moisture content testing, gradation testing on mineral soils or granular soils such as sand and gravel, Atterberg limits testing, which is a plasticity index test on fine-grained soils, as well as strength testing of fine-grained soils.
And what was all that? What does that mean? What were you trying to find out?
We were trying to evaluate the soil strength properties and the soil strength parameters that we could use in our slope stability evaluation of the site. The history of the site, obviously, in the 64 earthquake, the area looked a lot different than when we were working in the area. There were houses in all of these lots, and they were occupied at the time. After the 64 earthquake, there was the largest slope failure in the Anchorage area during the 64 earthquake was at this location. Mass wasting of soils in downslope and into the mud flats, and so what our task was to take all of the site geometry. There was a fair amount of explorations that had been done after the 64 earthquake in this area and since that we also used in our evaluation of slope stability to determine whether or not the area in question met general stability requirements for development, such that the municipality had a fair amount of confidence that if development did happen in this area, that there would not be another catastrophe under a similar seismic event.
I see. If you could turn to page 16, native 16 of the report, exhibit page 19 of 42, you'll see a section 7 called conclusions,
Yes.
engineering conclusions.
Yes.
The final sentence in that paragraph reads, "It's our opinion that the site conditions are consistent with historic findings and that with careful preparation, the site may be developed as planned." What did you mean there with respect to careful preparation allowing development?
Careful preparation essentially means what I stated earlier. We wanted to make sure that whatever was done in this area for this development was not detrimental to the stability of the site. And then also that what could be done, or the development of the site also needed to essentially improve the conditions to provide additional comfort, confidence that the site would perform during an earthquake. So making sure there was adequate drainage, making sure that retaining wall structures were short, not providing, areas that would, oversteepen and potentially decrease the stability of the site.
And did you make certain recommendations on design enhancements to improve stability?
Yes, sir.
If you turn the page to page 17, number 2, there's a reference to design enhancements. What's the principal ones you're referring to there?
Sure, and that's what I was alluding to, the minimal cut and fill, so not creating over-steepened slopes or steep retaining walls of excessive height on the slope. That has a destabilizing effect. Installation of subsurface drains to reduce the water table. It's static groundwater in a slope is very destabilizing, and the lower that you can get the groundwater, the better off the slope conditions will be. And then protection of the slope at the shoreline, essentially to prevent further erosion or natural erosion processes from Cook Inlet to oversteepen the slope. So from my point of view, probably the most significant and most effective of these options is the subsurface drain, because that not only improves the overall slope stability condition by lowering the slope or lowering the water within the slope, it also provides localized improvements for each one of the properties, because the secondary condition out there that is a problem for stability during seismic events is localized liquefaction underneath individual houses. And so if you can remove water from the slope, remove water from potentially liquefiable soils, you're mitigating that risk as well.
Okay. So my layman's understanding is if the soil is drier, it's not going to liquefy, it won't move as readily under a seismic event.
Exactly. If a soil does not have water, if it's not saturated, it will not liquefy, because that's a requirement. It's a rapid buildup of pore pressure, and you can't have pore pressure if there's no water.
And where would you place these subsurface drains?
Well, you'd place them in an area that's convenient first and foremost. Ideally, they would be at the top of the slope because that's where the water's coming from. So as high up on the slope as possible. You ideally want them to be below static groundwater if possible. Sometimes digging conditions and whatnot prevent that from happening, but if you can get it down that deep, that's better. And then just try to cover as wide a swath of the slope as possible with them. So wide area coverage, as high up on the slope as possible, but also in a place that is convenient and makes sense from a planning and a design standpoint.
And so for the Marston Foraker improvement area, where did you recommend these subsurface drains be placed?
We recommended that they be placed in the trenches that are below where the gravity-fed sewer or stormwater drains were being placed.
And if you look at page 18, section 7.1.2,
Yes.
it's where you refer to placing the subdrains near the sewer lines. But at the end of the paragraph, you state the recommendations apply to trenches for gravity-fed sewer lines only, as trenches for force main sewer lines should not be developed as subsurface curtain drains. What are you meaning there?
The idea there is to take advantage of the gravity-fed nature of the sewer lines that are being placed. That's one of the when I say a convenient place, that's kind of what I'm talking about. You're creating excavations across this slope that are graded to drain naturally to convey the sewage water. Because of that, you can take advantage of that natural or that grading that you're already installing for these lines, extend the excavation a little deeper, put in those drains, and then you don't have to have lift stations or whatever for these curtain or these sub drains. They'll drain naturally and they don't require maintenance. You can just set them and forget them.
And why not force main lines?
Force main lines, well, for one, they'll follow the contours of the land more because they're relying on pressure within the pipe that's artificially being placed in there, and so they're not reliable for grading to drain and all that other stuff. So we basically wanted to steer that away because if if we're not specific like that in our reports, sometimes those recommendations will be applied incorrectly, and had the drains been installed underneath the water mains for whatever reason, they would essentially be ineffective. They would do nothing and be wasted effort.
I'm not sure I follow. Paraphrasing what you're saying, if a line is a force line that's attached to a pump and the liquid is being pushed up the line,
Right.
when they're installed, there's less concern about having a positive grade to facilitate drainage.
Exactly. There's no concern about positive grade, as far as I know. I mean, I'm not.
So the bed of a force line isn't as reliable for maintaining positive drainage.
Exactly. Yep.
Was the 2005 report L1 reviewed by the Geotechnical Advisory Commission, to your knowledge?
Okay, I'm sorry, can you repeat the question?
Was it reviewed by the GAC?
Yes, sir.
And if you could take a look at Exhibit L3.
Was that F3?
Yes, L3.
Oh, I'm sorry, L3.
L. These are the meeting minutes of the GAC in September of 2005, and they are reviewing the water and sewer improvement site stability analysis for the Turnagain Heights subdivision. Do you see
Yes.
that? So in September of 2005, they reviewed your report. Do you know if they took action in response to that?
Essentially, the report and our findings were presented to the GAC, and as far as I remember, the GAC recommended that a third-party review be conducted on our report and findings.
If you'll refer to Exhibit L6, I think you'll find the letter from the Geotechnical Advisory Commission that it recommended a third-party review. Is that the one you're referring to?
Yes, sir.
And you see in the middle of the first paragraph where it says, while the commission does not object to AWW constructing utility improvements, the commission still has concerns about the slope stability and further evaluation may be warranted.
Yes.
So do you read that as indicating that they're concerned about the slope where the road's going to be and where future homes might be constructed?
Yeah.
Objection calls for speculation.
You can answer.
Yes, I do read that as meaning that. And I can also say, based on my experience in that meeting, in the meeting in which I presented the report and our findings, that is what the conversation amongst the GAC and all of their questions to me and to the other people there from the project, they were all concerned, almost solely concerned with the stability of the slope, and there was some members more so than others, but that was the brunt of all of the questioning and what their concerns were.
And was a third-party review done?
Yes, sir.
Could you take a look at Exhibit L4?
Okay.
Would you describe that document, please?
This document is the review results letter from Dr. Bray. The review was conducted on our 2005 report for Marston Forker.
And who's Dr. Bray?
Dr. Bray is a probably worldwide expert on seismic engineering, slope stability, slope engineering.
And did he make certain recommendations?
You know, it's been a while since I've seen this letter. I know he probably did, but what those specifically are, I'd have to review the letter to.
Well, I'll refer you to next Exhibit L2, which is a Shannon and Wilson update in April 2006.
Okay.
And you'll see that the second sentence there, this supplement study was conducted as recommended in March 2006, peer review submitted by Dr. Jonathan Bray.
Yes.
So it appears that Shannon and Wilson did a follow-up analysis following his recommendations.
Yes, there was work that was conducted after his review.
And if you look to the end of your letter, or this letter, it was signed by William Burgess. Do you know him?
Yes, my William Burgess was my supervisor at the time. He was the leader of our geotechnical group here at the time.
And does he reach a conclusion towards the end of the letter, next to the last page, about the adequacy of safety for developing this area?
Yes, sir.
And what's he conclude?
He concludes that, the last sentence of the closure, we conclude that the stability of the site is adequate and development is reasonable under the parameters recommended by Dr. Bray.
So to summarize, the principal concern of the geotechnical engineers was soil stability on the slope.
Yes, sir.
And the areas of greatest concern were the hillside above the pump station.
The area of greatest concern was the slope and specifically the area that was going to be developed eventually with residential structures. Yes.
And subdrains were recommended.
Correct.
And they were to be placed in the sewer trench beneath the right-of-way of Marston Drive.
Correct.
Would that recommendation have been different if Pump Station 10 wasn't part of the project?
Certainly. Yes.
I guess my question is, would those subdrains have been recommended for the Marston right-of-way even if Pump Station 10 wasn't being constructed at this time?
Correct. If Pump Station was not, or if Pump Station 10 was not being constructed, we would have recommended some form of subdrain within Marston Drive to drain the slope. The recommendation probably would have looked a lot like what you see in the report that we produced for Marston Forker.
Okay, thank you. I don't have any other questions.
Just, why don't you just leave it in the notebook? And Good morning, Mr. Brennan.
Good morning.
So, Mr. Owens had you look at L1, which was a geotechnical engineering report prepared in September 2005 for the road improvement district. Is that correct?
Yes, sir.
Okay. And if you look in that notebook that's been handed to you at Exhibit 62, you'll see that there is a September 2005 geotechnical report for Pump Station 10, correct?
Yes.
Okay. And so basically, you were asked to provide these geotechnical reports for both of these projects. Is that correct?
Correct.
And so if looking at Exhibit 62, page 19 of the exhibit, native page 16, you'll see the exact same language for Pump Station 10 regarding design enhancements. Is that correct?
Yes, sir.
Okay. So with regard to Pump Station 10, you were recommending that cuts and fills be minimized and that there be deep subdrains put in the gravity that were below the gravity-fed sewer lines. Is that correct?
Correct.
Okay. And so that was, and if you look at L3, which is the minutes from the Geotechnical Commission meeting, and if you'll go to page 3 of that exhibit, you'll see in the middle of the paragraph, Commissioner Cole asks about the depth of the wet well. Do you see that?
Yes, sir.
And if you look up above, in the first full paragraph, midway down, there's a italicized name, Stephen Nuss, stated that the Pump Station 10 is a separate project, but since the projects are commingled, they were submitted together. Do you see that?
Yes.
So in fact, both of these projects were before the Geotechnical Commission. Is that correct?
Technically speaking, maybe. I don't know exactly. I do know that my primary purpose of submitting our findings to the Geotechnical Advisory Commission was to discuss the Marston Foraker project. Whether in the eyes of the GAC or A was project manager or the engineer himself from VEI, I don't know if that was the case.
Well, sir, your report, Exhibit 62, with regard to Pump Station 10, recommended these deep subdrains to follow the proposed sewer lines. Is that correct?
Right, but that recommendation was also given in the Marston Foraker report, and from my point of view, those subdrains and the placement of them in the sewer lines across the entire area is from the standpoint of trying to stabilize the greater project area, so the entire development. If you were to take those two different projects and separate them, we would have Marston Foraker. Obviously, like I said earlier, we'd have the subdrains underneath the roads for those to improve stability across the entire site. For Pump Station 10, if Pump Station 10 was separated completely from that and Marston Foraker was not being developed, the road improvement was not being developed, then we would have probably come up with a subdrain system to help stabilize the area immediately around Pump Station 10, but it would not have been nearly to the extent that was required for Marston Foraker.
So I'm putting on the screen, sir, Exhibit A7. And this is the design for Pump Station 10. And this is the new pump station. I'll just to orient you.
Yep.
This is the old east trunk line going to the old pump station. It's gonna start with a new east trunk line here coming to the new pump station, and it's got this sub-drain here like this. And so if this project was being built alone, it was in fact your recommendation, was it not, sir, that these deep sub-drains be put in there to follow that trunk line to help stabilize the area, correct?
Not entirely, because I can't say that because these projects were not being conducted separately from each other. And that's why you see the language is the same in the Pump Station 10 and the Marston Forker report. We knew that these projects were technically separate projects, yes, but they were both being developed at the same time. And so we knew we had the recommendation in there for Marston Forker to have these drains to go underneath the sewer lines. So we transferred that as well, also to Pump Station 10, because we knew to maintain the consistency between the two projects.
Well, sir, were you told that it's a possibility that the Marston 4-acre project may not go forward and just Pump Station 10 would be built?
No.
So, again, since you weren't aware that that was a possibility, are you telling me that if Pump Station 10 was just going to go in and you were going to put a sewer line in here, you would have said, don't worry about the deep subdrain? We don't need to worry about that?
I guess, can you repeat the question?
Sure. I'm trying to ask you, sir, as a professional engineer, if this is what you're looking at, is building this project, you're going to cut a new sewer line in here, would you have just said, we don't need to worry about water. We don't need to worry about the stability of that slope?
Okay, so taking Pump Station 10 and completely removing it from Marston Forker, assuming Marston Forker is not being constructed or
Correct.
Designed. Looking at it right now, I don't know what the drainage system would have looked like, but there more than likely would have been some form of subsurface drainage around the pump station site to help with stability of the slope at the pump station location. So there would have been some form of drainage. Exactly what it looks like, I can't tell you sitting here because it's not something that just...
Well, I'm telling you, sir, that they're going to build a new trunk line that's going to go like this. They're going to cut a new trunk line in there. Did you not, in fact, recommend that they put a subdrain in there to dewater that?
Potentially.
Okay. And indeed, that is in your report, page 6, or Exhibit 62, correct?
Yes.
I'm showing you what's been marked by the municipality as Exhibit C13. And this is a letter dated October 6, 2005 from VEI, Mr. Nuss, regarding Pump Station 10. Do you see that?
I do.
So this follows your report of September 2005, correct?
Yep.
And in this letter from VEI, they expressly state that the Pump Station 10 soils report, that's your report, correct?
Yes.
Recommends subdrains be installed in the same trench with the gravity sewer line, correct?
Yes.
Do you think that VEI was misreading your report?
No.
Regarding the area in question, it says, the pump station upgrade project is responsible for redirecting two trunk sewer lines to the new PS10 site, the east trunk and the west trunk. A portion of this trunk line within the Marston right-of-way traverses the side hill and will definitely require subdrain installation. Do you disagree with that?
No.
I want to just follow up briefly on your testimony regarding deep subdrains and force mains.
Okay.
Were you aware that prior to going to you in September of 2005 and asking you to take a look at the Marston 4-acre project, that it had previously been designed with a force main?
No.
No further questions.
No further questions.
Okay, thank you. Are there any questions from Assembly members? None. Seems like I'm the only one with questions, but just to follow up, Mr. Brennan, am I understanding correctly that regardless of what type of development were to occur in this area, because of the soil content, the water, the topography, some sort of subsurface drainage would be required? When I say so, I'm talking about, road improvements, sewer lines being put in, water lines being put in. If you're looking at long-term development in this area, there would have been some sort of recommendation for some sort of drainage.
I think it does depend on the type of development. If this was just to be platted out as parkland,
Sure.
No real structures, no permanently occupied structures, probably not. There probably would not have been any.
What about houses? Like, we're talking about
Right.
the purpose, what I see is the development is for potential homes to be built in these areas.
Yes.
So with
and-
that consideration, whether Pump Station 10 was there or whether it wasn't there, would there have been some sort of recommendation for subsurface drainage?
Most definitely, yeah, and that is the ultimate development of the site being residential structures, and given the site's history in the '64 quake and the destruction that happened there after the '64 earthquake, development in that area with residential structures is very sensitive. People are pretty emotional about it, actually, and so that I think was driving a lot of the concern from everybody that was looking at this project. And so yes, I think that the presence or the ultimate desire to build residential structures on these properties was the driving force behind all of the scrutiny that the project received, and then all of the effort that was put into trying to do whatever we could to do to stabilize the slope from a seismic standpoint. So yes, and so with the questioning prior about whether or not our recommendations for Pump Station 10 would have had drainage systems associated with those, they most likely would have, but that's a pump station. It's not a permanently occupied structure. We probably would look at it a little differently if it was just that project and no other development was happening around there. It may have used the existing utility lines. I don't know. It depends on the exact site layout, and all of these other issues, and how sensitive the municipality would be to developing in that area, considering that it's just a pump station. It's not a permanently occupied structure. If a pump station slides down the hill, the consequences are far less than a lot of houses.
Sure. So it would be fair to say then, as you were making your recommendations, you were holistically looking at this with the full understanding that there was going to be residential housing in this area.
Yeah.
Therefore, whether Pump Station 10 was there or not there, your recommendations would have been for significant drainage.
Certainly, yes.
Thank you. Are there any follow-up questions to that exchange? Mr. Owens?
Nope.
Mr. Staley?
Real briefly, do you know, was there any design consideration taken into account to put in stub outs for the homes that would be built in the area? So that they could drain around their foundations or basements?
Not that I know of. The idea of having that subdrain and having a wide range or a long subdrain across the entire slope was to provide a shorter drainage path for all of the various properties around there, and so specifically around each stub out. No, I do not. But
You're aware, are you not, that oftentimes private developers in fact put in stub outs to allow homeowners who want to build basements or are concerned about water around their foundation can drain into a storm drain or subdrain system, correct?
Sure.
And are you aware, sir, that in fact that was not done in this case?
No.
Mr. Staley, for some clarification for us non-construction people, can you explain to me exactly what a stub out is?
It allows, basically, you've got this drainage system to take water out of the area, and a stub out would allow that when a home is built, that they can tie into that drain so that they can drain around their home.
That's what I assumed. I just wanted to make sure. Thank you. No further questions or comments for this witness?
None.
All right. Thank you, Mr. Brennan.
You're welcome.
At this point, I think it's probably beneficial to take our lunch break. So current time is 11:52. So we will adjourn and be back at 1 o'clock. Okay, we will call the remand hearing back to order. The time is about 1:05. And Mr. Owens, if you'd like to continue.
Okay, thank you. We're going to call Stephen Nuss at this time.
Mr. Nuss, can you please state your name and spell your last name for the record?
Stephen Nuss, and it's N as in November, U as in under, S as in Sierra, S as in Sierra, and Stephen with a PH.
Perfect. And the municipal clerk will go ahead and swear you in under oath.
Could you please raise your right hand? Do you solemnly and sincerely swear or affirm that the answers you will give to the questions asked of you in these proceedings will be true?
I do.
All right, Mr. Owens.
Mr. Nuss, could you tell us what you do for work?
I'm the capital program manager for the Anchorage Water and Wastewater Utility. I've been the capital program manager since officially December of 2009.
What is capital program?
The capital program is the capital construction that AWW performs to upgrade or expand its system. I oversee all the design and construction of that program.
And have you had other positions as well?
Yes, from 2004 to 2007, I was a project engineer, and from 2007 to 2009, I was a project manager.
And what has been your involvement with the Marston-Foraker water and lateral improvement districts?
From 2004 to 2007, I joint shared with Brian the project engineer responsibilities for the Marston-Foraker LID and WID projects. From 2007 to 2009, I took a step back as I moved on to project manage other projects and other people manage this project. And then from 2009 till present, I've been overseeing finalization of the project, closeout, working with Brian on assessments and those kind of things.
Okay. I'd like to take a minute to go into some of the background on this location. If you could take a look in tab A, Exhibit A2, we've got a photograph of an area. Do you recognize this area?
Yes, this is a picture from Shannon Wilson's geotechnical report showing generally the Simonson and Marston area in Turnagain pre-64 earthquake.
Was there a topographical feature along the tree line to this photograph? North is to the top of the page where the water is.
Yes, on the very top there's a line that's generally the mean high water line associated with the Platte. Between that line and a group of trees is largely flat areas, and that tree line essentially is the bluff line as it existed at that point in time.
Any idea how high that was?
I got to go back and look. I want to say it was about 30, 35 feet high, if not more.
If you'd turn to Exhibit A4. And describe that picture.
So this was a post-earthquake photograph that was in Shannon Wilson's geotechnical report for the project. It shows the post-earthquake cleanup activities that were occurring in the vicinity of the Turnagain Slide area at that time. You can see where, I guess, dozer trails had been pushed to push around dirt and other materials, and you can see still some remnants of houses and those kind of things at the north or the top side of the drawing there.
And what are the superimposed lines on this photograph?
So the superimposed is the Platte of Simonson Estates and Turnagain Heights, the subdivision.
Okay. If you could turn now to A5. Describe what this picture is.
This one is... This photograph is pretty obscured in my copy.
Oh, your copy?
Yes.
Okay.
So there is a picture from 2004 of the subject area prior to redevelopment activities associated with the RID, LID, and WID project.
Is this the same area as been depicted previously with the area of concern, the top Marston 4-acre improvement district?
Yes, it is.
Now, if you would, turn to D1, D as in dog. And just before we get to that one, a couple more aspects of this last photograph. Could you describe the topography of the ground in this photograph before construction?
Before construction, there was, I guess, a lot of little tiny isolated hills and valleys throughout the area there. There had been some clearing done of certain parts. I don't know exactly when those were done, but you can kind of see that kind of in the middle there, right above Simonson Estates there. There was I think that was Muka's property, if I have the overlay correct. And then generally speaking, there's a pretty gradual run going from the coastal trail up to about that clearing there, and then near that clearing there was a kind of a prominent hill, and you can see that actually better in some of the plan and profile drawings from the design. But generally the topography goes from the south is higher, north is lower, and then also there's between Simonson Estates and then the Turnagain Heights subdivision, there was kind of a little gully there with a channel, wetlands, whatever you want to call it, that went through and bisected the properties there.
Okay, thank you. Now D1, describe what that is, please.
D1 is what we call a FAR map, a funding authorization request map. We attach these to our projects as we make them available for considerations for budgetary increases, initial openings of projects, and those kind of things. This map here depicts the Pump Station 10 project as it was envisioned without consideration of the Marston Foraker LID.
Which direction is the water on this map?
The water is up north. There's a north arrow up there on
Up
the
into
page.
this area?
Yes.
And is this area in the box the location for the new Pump Station 10?
Generally, we adjusted it, I think, a little bit farther north once we got through with land acquisition activities.
And where is the existing or former Pump Station 10?
The former Pump Station 10 is over there in Sonsom Drive, just right there below the grid southwest identification, yes.
And does this map show any of the sewer, water, or subdrain improvements proposed for the road improvement district?
No, this does not.
So this was then just features associated with Pump Station 10 when it was contemplated at that point in time?
Correct.
Could you describe generally what sort of the purpose, the AWU's areas of responsibility compared to PM&E's? This was a joint project, and what areas did AWU cover?
Well, it was, and it wasn't a joint project. It was a joint project in the sense that we were building it in the same area, and that initially they were separate, completely separate projects, no consideration for overlap. We had a pump station project that needed to be done to upgrade Pump Station 10, and as things progressed where Pump Station 10 moved to actual design and construction, it was at the same time that the improvement district actually moved to being a reality after assembly approval. Pump Station 10 encompasses the sanitary sewer improvements generally as shown there, and was envisioned there, taken from what has previously been identified as the west trunk line, or the east trunk line, and then letting the sewage flow through natural patterns between Diana Durst's property and Chuck Spinelli's property there, and then going to the new Pump Station 10 property. Sorry.
Am I pointing to the right area? This would be the new extension from the old pipeline pump station to the new?
Yes, that would be what we would consider the west trunk.
That is the west trunk.
Yes.
Is the east trunk shown on this?
The existing east trunk is shown there. It goes between lots 10 and 9 that used to be the Hitchens property, and then
Is that this area here?
yep, that's that one there goes through lots 9 and 10, then goes through lots 1 and 2 of Pete's Place, through by Bargava's house, or what used to be Bargava's house, to Pump Station 10. And then
Go ahead.
finishing up, going back to how they got combined is once the improvement district became a reality, had originally been envisioned a separate, smaller lift station for the benefits of the improvement districts. Back in 2004, 2005, we started considering whether or not we needed a separate lift station, long-term operational costs, those kind of things. We decided that having a separate lift station may not be beneficial in the long term, and so we looked at ways to take and be able to construct sanitary sewer within Marston to be able to flow to a new Pump Station 10 location. And that's where it started to combine together in view.
Did the passage of the improvement districts, the assembly approval of creation of the lateral improvement district, influence decision-making in planning the infrastructure for this part of town?
Yes, it was. It was instrumental. I think that framed, knowing that the improvement district was mandated to be constructed by the assembly and that the property owners wanted to develop an area that we had previously considered undevelopable, really impacted how we viewed the area, and it opened up alternatives for sites. Prior to evaluating this site, we had looked at areas within Sonstrom Drive at the intersection of Kissy and Sonstrom only as potential places for a new Pump Station 10.
Okay. Let's talk for just a minute about what laws or regulations influence or control lateral and water improvement districts?
Mhm.
Could you just describe what they are?
WIDs and LIDs are controlled under a segment of AMC 1955 and 1970, I believe. I think, yeah, pretty sure. And then those refer back to our water and sewer tariffs, which are covered under 8.2 of the water and sewer tariffs.
Is that similar to roads? Are they treated the same way?
No, water and sewer improvement districts, the property owners pay 100% of the project costs, and then they also pay the cost of the service. They pay 100% of the project costs as they relate to the construction of the main within the road, but then they also pay separately the cost associated with the service connections from the main to the property line as well. So in a road improvement district, there's different types of road improvement districts. There's a 30-70 split and a 90-10 split, and this one was a 70-30 split with the property owners picking up 70% of the cost and the municipality picking up 30% of the cost.
So we really need to think about the water and sewer improvement districts as separate and distinct under the code and financing as well from the road improvement district.
I believe so, yes.
Once the property owners approached the municipality to form the lateral and sewer improvement districts, what's the process? At what point did you get involved?
So in the initial planning and balloting phase, our planning department within engineering oversees that process. Then it kind of gets booted over the fence to the project management side. The project management side is responsible for the actual procurement of consultants, overseeing the design, procurement of construction activities, overseeing construction, and then performing the closeout of the project. In my capacity, I helped, at least with the WID and the LID, in drafting some of the initial requirements for the design RFP, and then helped in the negotiations of the design contracts after they were selected through a proposal process.
Okay. Show you Exhibit B4. This is a representative copy of an initial document presented to AWWU. Could you describe it?
Boy 4.
Yes.
So this is a copy of the petition that we would have used for the property owners to express interest in the actual creation of the improvement district. If you look at this, it says mail this back to MLF, 2800 Hillcrest Circle, Anchorage, Alaska. I believe that is Mr. Fink, but I'm not 100% positive. He was the one that actually created this after discussion with AWWU as to what the requirements were to get moving to a ballot stage. So this was a petition drafted by the property owners for initiating the discussion with AWWU.
Does this obligate the owners to any financial commitment?
Yes, it's last paragraph there. It says, once the costs for development are determined, the municipality of Anchorage will require that I, as an owner, sign new documentation obligating the repayment of the development costs. It will take the obligation of property owners representing 50% or more of the cost to develop for the development to occur.
So another step was contemplated before a commitment would occur?
Yes.
And at least 50% of the owners would have to approve?
Yes.
If you take a look at B5,
Okay.
could you describe this document?
Yes, this is a typical preliminary cost estimate that we prepare at the utility when we're looking at projects, not just improvement district project, but also a capital improvement project. This one was dated August 15th, 2003. There's an R notation there. I don't know if that means it was revised. And it was prepared by Sandy Notestein.
And Exhibit B5, page 1, is the lateral improvement district estimate.
Yes, sir.
And page 2 looks like it's the water improvement estimate.
Yes, sir.
That was August of 2003. If you look at B6, could you tell us what that document is?
B6 here appear to be ballots or examples of ballots returned to AWW related to the improvement district for the WID.
And what's the purpose of this document?
This is so when you move from the petition phase to the actual balloting phase, the property owners have to vote to approve the creation of the improvement district, and you need a majority of the property owners, more than 50%, to approve it to then be able to move forward to the assembly. So in this case here, Mr. Hitchens and Mrs. Hitchens opposed all three of them, and then in this case here on the bottom, Mr. Fink on one of his parcels voted in favor of the water improvements based upon equal assessment. And there's two different ways to assess water and sewer improvements. There's the equal assessment method based upon a lot, service to one lot considers as service, and you get an equal prorated share based upon that. Or you can also look at it based upon the total area served of a lot, so a larger parcel would pay a larger percentage of the assessment.
And in this instance, do you know which way the property owners voted?
Equal assessment method.
Okay. Now, after the preliminary estimate was prepared in August, if you refer to Exhibit F1, September 03.
Yes, sir.
Do you know what this document is?
These appear to be meeting minutes that were taken of a meeting related to the second ballot of the improvement district, titled Turnagain Heights Second Ballot Meeting 9/8/03. Generally, it shows in attendance, the people in attendance, and where they sat around a table.
So the first ballot would be choosing the assessment method, whether equal or pro rata. And the second ballot then contemplates approval of formation of the district?
Second ballot finalizes approval based upon costs.
Okay. Was AWW represented at this meeting?
Yes, two of our engineering technicians, Andy Underwood and Sandy Nodestein, were present.
Okay. Direct your attention to the second page next to the last paragraph.
The one that states Matt Fink stated that cable, gas, and telephone were pretty much no or low cost.
Yes. Does it indicate whether there's any decisions made about installation of cable, gas, and electric as part of the improvement districts?
It said electric would have a cost of something like $2,000 per lot and were not part of this ballot cost. So they weren't included within the ballot.
Direct your attention to Exhibit B7. You recognize that document?
These are copies of ballots, what appear to be the second ballot for the improvement districts. On the page 1 of 2 appear to be ones by Mr. Fink voting in favor, and page 2 of 2 are the Clarks up top and then the Finks down below, all voted in favor.
And does this indicate it's all three districts that they're voting on?
Yes, water, lateral, road at the top of the page.
And do you know the outcome of that vote?
The outcome of that vote was favorable, and we moved on to assembly approval.
Turn your attention to Exhibit B8, please.
Yes, sir.
Can you identify that for the record, please?
This one is AO 2004-20 as amended, and I'm not sure who amended it, whether it was amended at the assembly or if it was amended before. representing the creation of the sanitary sewer or the lateral improvement district.
And what was the amount that was authorized for the district?
That's under section or finding E. The total cost of the proposed sanitary sewer improvements is estimated at $791,088.60.
Is there any indication of a cost share by the municipality?
Hold on. As supported by the sufficient and proper owners and is shown on the attached preliminary assessment roll. And I know the assessment roll had parcels that were MOA owned, so the MOA does partakes in some of the share.
Could you look at section 6 in that document, please?
The design of the public improvement shall be routed through the Geotechnical Advisory Commission for review and recommendations.
What did you take that statement to mean?
That for the improvement district, we had to go through the GAC and get their buy-off on the proposed approach.
And if you take a look at Exhibit B10, B is in boy. Is this the ordinance creating the water improvement district?
Yes, it is A 2004-19 as amended. And I believe the actual amended section here, if I'm reading these correctly, is section 6. That's the underlined portion. That's the amended section. I would have to confer to the clerk, but the design of public improvement shall be routed through the Geotechnical Advisory Commission for review and recommendations.
So both of these projects were required to be routed through the GAC for review and recommendations?
Yes.
So after the Assembly approved the formation of these districts, what was sort of the next milestone in the progress of the work?
Next milestone in the progress was the obtaining of design consultants. We decided that the scope and magnitude of the project, given the geotechnical characteristics of the area, and really the size of the project was outside of in-house design capabilities, and so we decided to contract for design consultants to design it for the benefit of the property owners.
And what was their initial undertaking?
Initial undertaking was data collection, analysis, survey, soils, those kind of things.
And was that pointed towards any product or work product?
Yeah, there was a couple different things. There had to be a record of survey completed because this was the slide area. There was adjustments that had to be made to account for the shifting of the plat, very complicated process. There was also a draft geotechnical report prepared as well.
And is that what we were addressing earlier with Mr. Brennan, the early geotechnical report?
Yes, I believe that was prepared in September of 2005.
And did the design company was VEI, is that right?
Yes.
And did they issue a report of their findings at some point?
Yes, they also create, after the data collection is done, they do analysis, they come up with alternatives, and we create what's called the design study report. That's sometimes also considered like a 35% design, but not always. But it usually outlines different alternatives, design issues, problems, challenges, design criteria that must be met, those kind of things.
And does it state the assumptions and status of knowledge at that point in time?
Yes, the DSR is largely the baseline for decisions made that impact the rest of the design. So yes, it encompasses known soil conditions, survey conditions, environmental factors, illumination, those kind of things.
Was the DSR made available to property owners?
Yes, after we completed the draft DSR, I forget the actual date, but we held a meeting with the property owners and reviewed the findings of the DSR with with the property owners and gave them an overall update of the status of the project.
Okay, I'd like you to look to Volume J, which is the reference binder, specifically J9. It's in the separate binder. You guys will have to share it. I'll put it on the board when I
have it.
Okay, and if you look on the first page and what's on the screen, is that the cover page for the document?
Yes, this is the draft DSR for the Combined Improvement District projects.
And take a look at page 4, please.
Native 4?
Yes. Does that refer to pump station 10 in the second full paragraph?
In the second full paragraph. Near the project area is an existing AWW wastewater pump station that requires upgrading in order to continue in service and to provide emergency capacity. The existing pump station is scheduled to be replaced, and the site selected for replacement pump station, parentheses, pump station 10, is north of the Marston Drive Foraker Drive project area. The proposed pump station 10 will continue to serve the area that flows into the existing pump station. In addition, it will also serve the Turnagain Heights LID. Costs for the Pump Station 10 upgrade project are being borne separately by AWW, except that costs of joint use mains will be proportionately shared between the Pump Station 10 upgrade project and the Turnagain Heights, it says LIS project, but it should have been LID project. Construction of the proposed Pump Station 10 will precede the Marston Drive Foraker Drive project.
2 points there. Was it the intention at the time that this was written that shared or joint use aspects of the work be shared with respect to cost?
Yes.
And was it the expectation at that time that the pump station would be built before the road, water, and sewer improvement districts?
Yes, we believe we would be going to bid sometime in early 2007.
If you turn to page 6, there's a statement of purpose.
Yes, sir. Native page 6, exhibit page 9 of 211. The purpose of this project is to design road and utility extensions that will meet the criteria set by the Geotechnical Engineering Studies and MOA Title 21, thereby meeting the requirements of the Municipal Ordinance AO 78-84 governing redevelopment in the Turnagain Slide area. The objective of the project is to develop part of the infrastructure necessary for the redevelopment of the private parcels within the Marston Foraker Road Improvement District and the Turnagain Heights Water and Lateral Sewer Improvement Districts.
Does that reflect a concern about geotechnical aspects on the project? Sensitivity to geotechnical
Yes,
issues?
geotechnical engineering studies. And then, so all of those that had previously been done is my understanding.
So on page 7, the next page, you see a reference to the Shannon and Wilson geotechnical report?
Well, there's actually 2. There was one created in 1995 for the overall stability evaluation, and then in 2005.
And that's the report that Mr. Brennan authored and was discussing earlier?
Correct.
It reflects, this document reflects a knowledge of the content and consideration of the recommendations of that report?
I believe so. A summary of recommendations from the 2005 report is as follows. This is page 7. Site stability. Facilities constructed as part of this project shall be designed and constructed to withstand a 500-year return earthquake with a peak ground acceleration of 0.2 G.
And would you go to number 3 on the next page?
Yep, number 3, page 8. Subsurface drainage. Subdrains are required to collect perched water in the road, foundation soils, and utility trenches. Groundwater could contribute to instability during a seismic event and should be removed to the extent possible. Subdrains should be incorporated into the sewer utility trenches. The sewer trench is the deepest utility trench that is graded to drain.
Thank you. Let's see, I lost my place here. If you could turn next to page 13. Native page 13.
Yes, sir.
Specifically at the bottom, there's a section called subsurface.
Yes. The Geotechnical Engineering Report recommends keeping the subsurface dry for stability during earthquake events. Granular backfill and utility trenches can act as collection areas to hold water. Draining these areas is recommended to keep the underlying cohesive soils dry. Because the sanitary sewer lines maintain gravity flow, subdrains are recommended within the sanitary sewer trenches to allow continual drainage to a area without any trapped pockets of water. The proposed subdrain system is depicted in Figure 5. As shown, the subdrain is located 6 inches below the sanitary sewer line.
So draining the utility trenches was recommended to keep the underlying soils dry. Why is that?
Well, as Mr. Brennan explained, we wanted to get as much water out of the area to prevent liquefaction from occurring again in another seismic event, to make the overall site stable. Primary concern there was residences. We didn't want another instance where homes and those kind of things were to get swept out to sea.
And it refers to figure 5, which is on page 14, native page 14.
Yes, sir.
And that depicts the subdrain system for the Marston Road and drainage system.
Yes, it does.
And could you just describe where the subdrain is recommended to be installed?
The subdrain that is there parallels our gravity sewer trenches going from east along Foraker Drive at Lineary Park to west along Marston Drive before going down between lots 2 and 3. Also going basically from lots 12 and 11 of Simonson Estates more east before going through lots 2 and 3. Then it goes to a subdrain lift station before getting pumped over and discharged into an active storm drain.
And is all of this subdrain system depicted here recommended for the road improvement district?
Yes, it is.
And on the next page, 15, there's a reference to the second paragraph and the depth of the storm drain. What's being said there?
The subdrain starts at the beginning of the Marston Drive road improvements, second paragraph, right?
Yep.
At the beginning of the Marston Drive road improvements project runs in a trench by itself northeast along Marston until it reaches the beginning of the sanitary sewer gravity main. At this point, both lines run nearly parallel up station, Marston Drive center line along the trunk line to pump station 10 and then along the alignment from pump station 10 to Sandstrom Drive.
The reference there to the subdrain starts at the beginning of the Marston Drive road improvement project and runs in a trench by itself northeast along Marston Drive until it reaches the beginning of the sanitary sewer system. What area is that referring to?
At that point in time, if you go back to your drawing, your figure number 5, and you need to move it over so you can see the right-hand side of that drawing there. It's talking about that subdrain there, pretty sure. It runs in a trench northeast along Marston until it reaches the beginning of the sanitary sewer gravity line. Up station, Marston drives along the trunk line to pump station 10. So that is, my understanding, that is the, as it runs from where your pencil is down at the bottom left-hand side of the page, up station until it intersects the sanitary sewer line and then runs together.
Is that a stretch where the subdrain is by itself without sewer?
That is what it appears to indicate, yes.
So it was recommended despite the absence of a sewer in that stretch?
Yes.
And then down at the lower, the next to the last paragraph, because of the depth of the subdrain, what's that paragraph telling us?
Because of the depth of the subdrain, gravity discharge to the surface is not possible. A groundwater lift station is required to move the groundwater from the subdrain system. The groundwater lift station would be constructed utilizing a 6-foot diameter manhole.
So what's that mean?
Because you had to drain it to the low point, it was following the sewer lines, you had to discharge it. We also had to discharge it at a place that we weren't concerned about it glaciating over the coastal trail or another pathway, or where the water wouldn't be pumped and impact an individual property owner's lot. So we ended up having to pump it via force main from the lift station, and that's depicted there on the left-hand side of that drawing, through a subdrain force main, not to be confused with the sanitary sewer force main, but a subdrain force main that goes from where it says proposed sanitary sewer lift station over to Sandstrom Drive and discharges into, and I believe that's considered Hood Creek there. That's right in front of Spinelli's property.
Is it this line here?
Yes, sir.
So that was the route that the water would be pumped for discharge purposes.
Correct.
And that would be a force line connected to the the subdrain pump station adjacent to the sewer pump station.
Yes, the subdrain lift station is a completely separate facility from the sanitary sewer pump station. The subdrain lift station is operated and maintained by the Public Works Department, as is all subdrain systems.
So you're saying it was part of the road improvement district
Yes, sir.
facilities?
Storm drain is typically involved with road projects, yes.
And the pump station was required, why again?
Pump station 10, or
No, for the subdrain.
the subdrain pump station was required to move the subdrain water that was collected from the improvement district to an appropriate discharge location.
And that pump, the subdrain pump station, did it accommodate any other type of water? Or was it solely water collected in the subdrains?
Only subdrain.
If you look at page 31, please, native 31. There's a section entitled Shallow Utilities.
Yes, sir.
The second sentence in the first paragraph, could you read that for us, please?
The Road Improvement District Creation Ordinance does not include these shallow utilities as part of the project.
And which shallow utilities is it referring to?
Gas, electrical, telephone, cable.
So the DSR clearly indicates that those shallow utilities are not part of the project.
Yes.
But to your knowledge, was there any planning done to accommodate those shallow utilities after the work was completed?
Yes, at one of the early public meetings, we brought representatives from CEA and Instar, and I think ACS didn't come because CEA and ACS have co-trenching agreements, so CEA was there kind of covering everybody. We coordinated and provided the information to the property owners and had them provide information. We also made contingent with the Road Improvement District project locations for utility crossings, utility duct work, that if the property owners couldn't come to an agreement with the utility companies to construct them as part of the project, that we would make locations available for the utilities to cross underneath the road without having to dig up the improvement project.
Okay, so would you turn to Appendix 7, which begins at the BATE number, the document control number in the lower right-hand corner is 41828. These are cost estimates that were prepared in connection with the DSR.
Yes, sir. These were apparently dated VEI Consultants, April 18th, 2006.
And at this point in time, April 18th, 2006, the total project cost for the Road Improvement District is how much?
It's estimated at $4,500,045.
And on the next page is the Water Improvement District.
Water Improvement District was estimated at $1,092,446. And
finally, the Lateral Improvement District.
Lateral Improvement District, $1,025,651.
How did these costs compare to the original estimates for the work?
They were significantly higher than those costs. The Road Improvement District had almost tripled. The Water Improvement District had almost doubled, and the Lateral Improvement District had risen by about 30%.
So what did that mean in terms of the project's ability to go forward?
The municipality as a whole, we reviewed them because of the cost increases, the substantial cost increases. We decided that we needed to go back and ask the property owners whether or not they wanted the project still.
Did meetings occur with the property owners to discuss this report?
Yes, there were several meetings. I was not present at several of them, but there are meeting minutes throughout the files that depict conversations had and the discussions had and who was involved at those meetings.
If you could refer to Exhibit F4. I'm done with the Volume J.
F4, notes of meeting with property owners 5/5 of 06.
So May of '06. These are notes to the file about a meeting with property owners?
Yes, these were prepared by Jim Lanston, who used to be with Public Works.
And this was after the DSR had been released and shared with property owners?
Yes, sir.
And the end of the first paragraph there identifies what the focus of the meeting was?
The meeting was set up by Russ Oswald at the request of Matt Fink in response to cost estimates in the draft design study report that were significantly higher than the costs approved by the property owners. The goal of the meeting seemed to be gaining a deeper understanding of why the costs were so much higher than originally estimated.
And if you look at page 2, there's a reference to the deep subdrain system. It's page 2, the item number 2.
You're still F4, correct?
Oh, I'm sorry, at F5.
Oh, sure. Okay, so F5 is meeting minutes, follow-up meeting from June 29th, 2006. So it's page 2, item 2, discussion resumed concerning the need for this deep subdrain system.
Okay, I inadvertently switched exhibits here. F4, if you still have that in front of you, is a meeting May 5th. And item number 2, actually, if you look, it says that the meeting was set up by Russ at the request of Mr. Fink.
Correct.
And it was to review the draft design study report costs. And Mr. Fink prepared an agenda for the meeting, which the report here, the minutes, seems to kind of follow the items on that agenda. Item number 2, or issue number 2, refers to the secondary drainage system. Do you see that?
Yes, the property owners wanted to delete the secondary drainage section.
And does it indicate here that they would have to, that additional information would be provided about that?
Yes, so Russ Oswald and it says AE, which is VEI, provide clear geotechnical justification on A, why the deeper subdrain system is needed, and B, how strongly the additional system is supported by the analysis. Also evaluate whether one drainage system could be built to address surface and subsurface drainage.
Okay, so then we go to Exhibit F5, and this is a follow-up meeting in June.
Yes, sir.
And item number 2 is resumption of the discussion about the deep subdrain system.
Yes, sir.
And you see in the third bulleted item under item number 2 how the conversation followed along. Basically, do you see where it says elimination of the subdrain would necessitate reconsideration by the Geotechnical Advisory Commission?
Yes, at the time that this meeting occurred, we had already been back before the GAC, I believe, with the third-party evaluation, and the GAC had supported the final recommendations coming out of the revised geotechnical report, which included the recommendation for the subdrain system, and that if we had tried to eliminate the subdrain system, which was a key part of the site stability requirements there, the thought was that we'd have to go back and start the whole GAC process all over again.
And consequently, the final sentence in that paragraph discusses or addresses how that was concluded?
At conclusion of the meeting, the project team stated that the subdrain system would continue to be included.
The original estimate for construction of the lateral improvement district and the road improvement district, did it contemplate the deep subdrain system?
No, it did not.
So is that a significant driver of the increased costs?
That's one of the drivers, yes.
And turn, if you would, to Exhibit F7.
This is a public update report prepared by Bruce Robeson, who was the project manager for AWW at the time with Russ Oswald, going to the Improvement District's property owners.
What was the purpose of this document?
There was a lot of concern about the status of the project, what was going to happen. There were some property owners who hadn't been present at the DSR meeting and hadn't been involved in some of the side discussion meetings that were being held with Mr. Fink and others. And so this was to give an overall update to all known property owners at that time.
And at the bottom of the first page, it refers to activity since January 2006 to present. And there's a number of bulleted items on that page and continuing on to the second that summarizes activity on the project. Is that right?
Yes, it is.
And on page 2 of this, it refers to an April 27 meeting with the property owners.
Correct, April 27, 2006.
And again, May 5 to review project costs.
Yes, sir.
And then it refers to the May 8th meeting with the Geotechnical Advisory Commission.
Yes.
And again, a meeting with the property owners the following month. And just the outcome of that was that the estimated cost actually increased between April 2006 and the time of this letter.
Correct. More data was available. We had additional bids. Those kind of things were taken into consideration as well.
Okay, so then turn, if you would, to Exhibit C6. This was in September of 2006. Several meetings with property owners to go over the DSR.
Charlie 6.
Charlie 6.
Yes, this is a sample ballot from the reballot conducted in 2006, whether or not property owners wanted to keep moving forward with the project knowing the revised estimated costs.
And was a ballot similar to this sent to each of the property owners?
Yes, sir.
And tell me what's contained in that box, the figures that are shown there.
For each individual property owner, we provided them their estimated assessments. There's a lateral, which is part of the lateral improvement district. There's the trunk improvement district, which is separate from the lateral improvement district and is really not part of the process here. The water improvement district and then the roads improvement district. These are estimates of that individual property owner's payments, number of payments. At that time, the maximum number of years to pay it off was 20. We've since revised that to allow for 30 years of payback, and what the estimated annual payment was for that particular parcel.
So was that information specific to each parcel provided to the owner of each of the parcels?
Yes, it was.
So at the time that they voted on whether to approve the revised cost estimates, they were informed exactly how much their costs would be?
Yes, sir.
Exhibit F8, please.
Public update, January 29th, 2007.
That's the one. Does this indicate that it's a status report on the progress of the work?
This is an update on the status of these 3 improvement district projects, right there below the regarding.
And does it report on the reballot?
Yes, that's the first section, reballot results.
And it indicates that the reballot was successful?
Yes, it was favorable, 57%, 65.6%, and 65.5%.
And on this document, it indicates what the total project estimated cost was for each of the projects?
Yes, it does, under funding, and then what the MOA share is for that.
Also, the third page, it provides sort of a schedule, is that right?
Yes, sir.
And when is the projected time for the construction contract award?
June 2008.
So in January of 2007, they're projecting a contract award in about June of 2008.
Yes, we had to wait for the road bond election in 2008 to guarantee full funding for the project to move forward.
Is that a guaranteed date?
No, that's an estimated date. There's a lot of factors that can move that around.
So it might have been sooner, it might have been later?
It would have been no sooner than the election date.
Okay. And if you look at Exhibit C7, C is in Charlie.
AO 2007-51.
Yes. What is that document?
This is the assembly ordinance where we went back to the assembly in April of 2007 with the revised roles, estimated roles for the improvement districts, asking the assembly to improve the increased assessment related to the water improvement district.
And it indicates the new estimated cost at what?
Oh, where in the heck is it? Excuse me, sorry, it's on second page, section 3. The total cost of the proposed water improvement is estimated at $1,229,140.16.
And could you compare that number to the number on Exhibit C2, which is the 35% April 2006 estimate?
Yes, that number is higher than the Exhibit C2 estimate that was included within the design study report. As we read in the one meeting minutes from June 29, 2006, as we developed the costs and we had more current bid data involved, we updated the unit price estimates within the cost estimate. We also included VEI had done a design estimate included standard factors, but they hadn't included things like AWW, administration costs, and things like that. You'll also see that there's a cost escalation factor not included within this estimate here of C2. And so those items were included within the estimates for the actual rolls that went before the Assembly in April of 2007.
And was there an updated estimate prepared?
Yes, there was an updated estimate prepared prior to the rolls.
And did you locate a copy of that after this morning's discussions?
Yes, I sent our engineering technician back, and she pulled it right from the files.
And so do we have that in the room today?
I provided you a copy.
I don't know where I put mine. What we'll do is when we have a break between direct and cross, if we could, I'll make copies of those, and it'll provide the breakdown of the amount authorized for the ordinance.
Very good. We'll once we have that, we'll incorporate that as Appellee's Exhibit N.
Okay, and that'll be for both the water and the lateral improvement district.
Any objection to that, Mr. Staley?
Well, I haven't seen it before, so.
I'll let you see it. Okay, thank you.
So after the Assembly approved the updated cost estimates for the projects, what happened next?
We resumed design, moved forward to final design. At the same time that we were going through this, we were also moving ahead with final design on Pump Station 10, and we got to a point where where we had planned to be bidding Pump Station 10 in early 2007. That wasn't going to happen, and we were getting to a point where we were facing two contracts being let for work generally within the same vicinity of each other.
So you said you resumed work on design. Why was work resumed?
Well, we were already at risk for probably the municipality as a whole was already at risk for several $100,000 in 2006 in design costs. We had suspended work on the improvement districts until we went back out to reballot. We didn't want to continue incurring additional costs if the improvement districts failed. Those costs would have had to been borne by the AWW ratepayers or by the municipality as a whole, the taxpayers for the road improvement district.
Would AWW have built this sewer and lateral improvement district on its own?
No, we don't do that.
Do you have a means or a process by which you plan for extensions of service?
Yes, we have our capital improvement program. It's a 6-year look ahead. And if we only extend service when there's overarching benefits to us, like intertie pressure zone or connect one water service area with our main water service areas. We've done in the past, those kind of things.
And was this an area that you contemplated any construction on your own account?
No, not until the improvement district was passed.
In the decision to build these improvements, the lateral and the water, was that based solely on the fact that the property owners approved and promised to repay that money if it was constructed?
Yes.
So the work on the design was resumed, and as we've heard earlier, the decision was made to combine the improvement districts in the spring of 2008. Why was there that delay?
I didn't hear your last.
Why was the delay to 2008 after the Assembly approved the revised figures in 2007?
We had to move forward with 65% design, 75% design reviews. There was discussions on aspects of it, coordination with property owners for easement acquisitions, for drainage, those kind of things. It's a process that takes time for any road, water, or sewer project.
So referring to Exhibit F10,
June 23, 2008.
yes. Could you tell us what this document is?
Well, it was a general status update to the property owners from the construction project manager, Jeff Coleman, wanting to give them a status of the project and introduce himself.
And the second full paragraph states construction will be competitively bid as a joint project with Pump Station 10 upgrade, the improvement districts, water, sewer, and road, and Lineary Park improvement. Is this, to your knowledge, an announcement to the property owners that this is going to be consolidated with the pump station?
This was the official announcement. I know there was individual conversation with some of the property owners before this that ultimately sparked this letter being written.
And does it identify how the projects construction-wise would be broken down for the bid documents?
Basic bid, schedules A, B, and C, and then deductive alternates, schedule D, E, F, and G.
And how does it describe the basic bid?
It says schedules A, B, and C, pump station 10 upgrade, water, sewer, and drainage.
So what does that mean to you?
Well, in this case here, schedules A, B, and C, pump station 10 upgrade, water, sewer, and drainage, it isn't necessarily correct in that there was more than just pump station 10 within schedules A, B, and C. Originally, as we had contemplated the construction of the projects for pump station, contemplated the construction of pump station 10 and how we developed it, as you could even see through the DSR as early as 2006. We wanted to make sure that we didn't have overlapping construction impacts from what was needed for the improvement district to what was needed for pump station 10. We didn't want if the improvement district for some reason didn't move forward or failed, we didn't want to have them, or was delayed, we didn't want the improvement district coming back and digging up portions of work that were already constructed. So as early as 2006, we started figuring components of the improvement district that could be constructed within the pump station 10 contract. Not for pump station 10, but within the pump station 10 construction contract. And so that's what's referred to here as the pump station 10 upgrade, schedules A, B, and C, which included individual components of pump station 10 and components of the improvement district.
And I'll direct your attention to the paragraph after the reference to the deductive alternate and ask if you could review that and explain how the lowest successful bidder was to be identified.
For the purpose of the bid evaluation, the low bidder will be determined by the lowest basic bid plus the cumulative total for all 4 projects within the deductive alternative, so long as no single improvement district project within the deductive alternative exceeds available funding. So what that meant is you added all those up together. The price for schedules A, or the bid price for schedules A, the bid price for schedule B, the bid price for schedule C, D, E, F, and G. And the winner, the lowest bidder, is based upon that cumulative total, so long as the deductive alternates weren't broken. And if the deductive alternates amounts exceeded, then you had to go and you would only award to the basic bid component, schedules A, B, and C.
Okay. So here we've referred to, again, these terms, basic bid, deductive alternate, and lowest bidder. What was the work contemplated in the basic bid?
Basic bid was schedules A, B, and C, which included components of both the Pump Station 10 project, the Road Improvement District, the Water Improvement District, and the Lateral Improvement District.
So included components of, does that mean you're just transferring money from one to the other?
Well, we were joint sharing facilities and for the water and the lateral improvement district. And because the sub-drain that was required for the road improvement district had to be constructed in conjunction with the sanitary sewer pipes, we had to build those components that were required for the RID at the same time we built the Pump Station 10 project.
So are you referring to actual components of work as well as the cost associated with those components that were associated in those schedules A through C?
Yes, we tracked those costs separately. So the work was tracked and the costs were tracked separately between the various schedules of the work. We set up, each project had its own project ID and account, and then we also had tracking within the work spreadsheet that tracked units of work. Our construction contractor prepared an estimate of work that he completed. along the various schedules. Our inspector and construction project manager reviewed that, compared it to the inspector's daily reports to verify that as work progressed, what work was being done when, and those things, and kept a pretty good track of how all the costs were, as construction was being done, incurred. At the same time, during design, VEI did the same thing. When they were working on different tasks, they kept track of their time according to their accounting methodology for accounting for different tasks, whether or not it was working on Pump Station 10, the RID, the LID, the WID, those kind of things.
Could you turn to Exhibit E3 and tell me what that document is?
So this is a bid analysis that was prepared by Jeff Coleman prior to awarding the construction contract to Prue's Construction. This is what we use to evaluate the different overall cost components, and you can see on page 1 there of 1 how the projects are broken out. There's actually 6 individual bank accounts that are paying for components of this work. There's the Pump Station 10 sewer upgrade. There's the Pump Station 10 water upgrade. There's Lynn Airy Park improvements. There's Marston Drive, Foraker Drive, RID. There's Turnagain Heights, WID, and then the Turnagain Heights, LID. And this table also refers to what components of that work were and the value of that, well, what value of that work was included within each schedule.
So if you turn the page and walk us through generally what these line items are.
So this typically would be what a contractor would bid from. These are usually include the bid document here that the contractor would put in his unit price, handwrite, or sometimes type in the unit price and an estimated total price. We converted that for analysis purposes to this form here and plugged in Prue's numbers. So item number A1, that's the amount of clearing and grubbing that was included in Pump Station 10 upgrade. We figured there'd be 1.2 acres of land to clear and grub. The bid price by Prue's for that was $20,000 per unit or per acre, so the estimated total price there. And as you work your way down there, you see things like A21, AC pavement, Class E, 2-inch thickness per square yard, 2,500 square yards, $17 a square yard for a total estimated price of $42,500, and those kind of things. And so that works through all of Schedule A.
And on page 4, there's a total?
Yes, there's a total of $3,223,268.50. But of that, if you look at the line above, it says total of Schedule A items for LID. See Schedule E worksheet. And so this is our share of the joint shared sewer pipe between 0 plus 80 and 27 plus 01 pipe stationing of the pipe where...
Wait, 0, you jumped it. Where are you referring?
Sorry. Can you pull up the plans?
Or should we flip over to the detail here for Schedule E?
Well, yeah, go to...
Is this
go to
a cross-reference?
Schedule E, this is page 12 of 14, Exhibit E3. So that bottom section there, it says LID items from Schedule A, Pump Station 10 upgrade sanitary sewer improvements. So Station 23 plus 28 to 2701 of Pump Station 10, there was pipe that we considered joint use. We actually diverted our flow from the previous truck. Okay.
But the pipe that you say that was being jointly used, is that detailed here in this sheet on page 1 under Schedule E?
Yes, it is. It talks about the linear footage, the amount of trench backfill, the shared trench total, half a shared trench total, those costs.
So that is the breakdown of the $94,000, which is identified at the summary for Schedule A?
Yes, sir.
So it consisted of the items identified in pages 1 through 4 of this Exhibit E, together with the items identified as part of the Schedule A in Schedule E, which was on page 12 of 14 of this exhibit.
Yes.
And did that similar methodology apply to Schedule B?
Well, yes. Schedule B, there was a much smaller percentage of the work that was done for Pump Station 10. The majority of Schedule B, because we had to install the subdrain as we installed the sewer pipe, the majority of that work and the construction of the lift station, the subdrain lift station, was almost all entirely related to the improvement district, the RID.
So the detail of that $60,000, $60,821, is found where?
Schedule B,
Yeah, we're talking now about.
C is in Charlie?
Yeah, I
Yes.
jumped ahead. Let's look instead, I'm sorry. I meant to go to B, and at the end of Schedule B, there is a total breakdown of the total cost.
Correct.
And there is a reference to Schedule B items for RID.
Yes, and it says C Schedule D dog workshop.
Okay, and where is that?
That is, begins page 8 of 14 for MOA hearing exhibit E3.
And where is the detail of the $834,000?
It is on page 11 of 14.
There's a reference on page 11 to the note RID items from Schedule B.
Yes, RID items from Schedule B, Pump Station 10 upgrades, storm drain, and subdrain improvements.
And generally described as subdrain paralleling the west trunk is a pump station cost.
Correct. That's the stuff going from Sonson Drive over to Pump Station 10.
And the all other subdrain and storm drain items in Schedule B are identified as a road improvement cost?
Correct.
And those are detailed in this following list.
Yes, sir.
And then if we go to Schedule C, it similarly has a total that includes a cross-reference to another worksheet.
Yes, see Schedule F worksheet, and that's page 13 of 14.
And this refers to the note on page 13 as some stations. Is this what you were talking about before?
Yes, sir.
Now, are you able to, what would assist you in graphically describing where these improvements, oh, one other thing before we go to that. Do these line item costs, these items within the schedule, correspond to any information provided by the contractor in the course of the work?
Yes, so once the contract's actually awarded, we require the contractor to prepare a schedule of values. The schedule of values closely follows the units listed and the bid items listed within the bid tabs. With the exception of this, we had two lift stations, both the Pump Station 10 lift station and then also the subdrain lift station. He further broke out the components of that, like site work, electrical, mechanical, building, and things like that. So as things progressed, he could claim completion and get paid for them. So we then created a pay estimate based upon these numbers and these schedules and tracked payment to the contractor similarly.
Could you refer to Exhibit E16?
Yes. Did you say 16 or 6?
1-6.
Yes, this is pay estimate number 1.
Now, tell us how this pay estimate corresponds to the breakdown that we were just referring to in the bid tabs.
Okay, on page 1 here, you can see The schedule, it says Schedule A, Schedule B, Schedule C, D, E, F, and G. The contract amount is the bid amount that proves bid. Previous earnings, since there had not been any work performed prior to this is the first pay estimate, everything's zero. Amount this estimate, that's the specific amount of work that was performed. This is a roll-up from other pages that we consider the body of the estimate that are within the document here, and then the total amount earned. Page 2, this is generally this is the bank sheet, so to speak. This is how the amounts are paid to the contract, out of what bank account the amounts get paid. And you can identify those. You'll see as you work down the page there, Schedule A, Pump Station 10, Upgrade Sewer. Schedule A, Turnagain Heights, LID. And the unit prices there are, as we discussed in our evaluation form there, the 94,998. And you can see that we track those costs separately. If you move over to the right-hand side of the page, you can see accounting fund, org, class, and the project ID is a key factor there. As you get into the road improvement district, it's not only the project ID, but also the activity ID that becomes a factor there in tracking the costs.
And on page 2, could you explain how the components of Schedules A, B, and C are broken down?
Okay, so Schedule A, Pump Station 10 Upgrade Sewer. At that time, the contract value was a little over $3.2 million. That was getting paid out of Project 3738, out of the Activity ID Construction. For Schedule A, Turnagain Heights LID, $94,000 and change was getting paid out of AWW project number 2903.
So what does that mean?
2903 was the project number set up to track costs for the lateral improvement district, both design and construction.
And what was the other project ID for the PS10 upgrade sewer?
PS10 upgrade sewer 3738 was the project ID.
For Pump Station 10?
Pump Station 10, 3738 was Pump Station 10. 2903 is the Turnagain Heights LID. 2903 is or 2902 was the water improvement district. 2903, because we had money that we got advanced from PM&E to manage and oversee the construction of the project from an award the construction bid. Public Works, we entered into a memorandum of agreement where they gave us the money, because you can't have, with the PeopleSoft system, you can't have a joint accounting purchase order, so it was easier just to do it this way. They gave us money and we set up a separate activity ID, and you can see those there on the far right-hand side. Advanced PM&E RID construction, and then you can also see where we had set up advanced PM&E linear construction for Schedule G.
Okay. Then what about the following pages?
The following pages are what we refer to as the body of the pay estimate. These are the individual bid items or contract items from the contract. The tonnages, estimated tonnages, the unit prices, the total contract amount, and then it's kind of hard to read with this blue photocopy, but it says previous earnings, this estimate, total estimate. So on page 3 here, for instance, they had item A17, temporary erosion and pollution control. They had done about 10% of the work on that item, and so they earned $8,000 for that.
Are the Schedule A items for the lateral improvement district identified on the pay estimate?
Separately, yes. If you look at Exhibit E16, page 4 of 10 on that bottom, you can see it says items A7, A9, A12, A22, A26, A27, A33. Those are the units and the value of those units associated with that. And it's hard to read in the blue on this photocopy, but it says Schedule A, Turnagain Heights LID.
Are there other places where the RID and WID are similarly detailed?
Correct.
Those components of A, B, and C?
Yes. Page 5 of 10 breaks out the Schedule B work. And that actually goes into page 6 of 10. And then 6 to 10 also breaks out the Schedule C work.
And how do you determine if the contractor actually did the work he's claiming payment for?
We have inspectors on site during the course of the project that are keeping track of the contractor's progress as they perform the work.
And in the system, we'll get to that with another witness, I'm sure, but is there additional steps in the process of requesting payment that you've got people in the field, you also have people involved in verifying other aspects of these submittals?
Yes, so the contractor, when he submits the pay estimate, has to certify that the work that he's submitting payment for is correct. Our field people inspect it, the request, they review that against their documentation. We have the person that's preparing the pay estimate review the work to make sure that what gets entered into the pay estimate goes along the right lines and before the contractor and the project manager sign off on the estimate. We have accounts, well, they're not accountants, they're project controls people that assist the project managers and project engineers to make sure all the accounting is straight, especially on the page 2, that everything lines up, formulas are all correct within the document and those kind of things.
Okay. But also direct your attention to exhibit number E15. Just for general reference purposes, what is that document?
E15 is the final pay estimate that was prepared for the construction.
So we've got the first pay estimate and the last pay estimate as part of the exhibit list?
Correct.
And if you would look at the front of your exhibit binder there to the list of exhibits, the very front.
Yes, sir.
That includes, I believe, you'll find that there's a tab J identified there.
Tab J?
J, yes.
Yes, sir.
And in particular, directing your attention to J11, 12, 13, and 14. It's identified as the WID project cost summary and detail, as well as the LID cost summary and detail.
I see the...
And you've got the reference binder there.
Hold on.
Take a look and confirm that you're familiar and those are accurate.
J11?
Yes.
Okay, I'm at J11.
Please just describe what that is.
Well, the first page here, the first page is a summary of costs. This is what we consider the resource activity report. This is a printout from PeopleSoft that we use. You can see that this is referencing project 2902, Turnagain Heights WID. Off the left-hand side, you see the activity ID, design, construction, right-of-way study. And across the top are the resource types. AFUDC has been explained previously as the cost of capital, basically the interest that we have to pay on borrowing money. Cap outlay, that's the actual physical construction cost. That's the cost that we pay the contractor. Sometimes cap outlay can also include like costs associated with acquiring land for a project, things like that. Inventory, INVIS, if we had to release things like manhole lids, pipe or something like that out of AWW's own warehouse for the benefit of the project, we charge it against that project. Labor is direct labor that AWW expended against it. Other are usually miscellaneous permits or design fees, those kind of things. Overhead is a pro rata share of against the project of AWW overhead as it applies to the capital program. PRSVC are professional services. Those are the design and the construction management contracts, and sometimes other designs, other professional services that are used. And so this gives by resource type against each activity ID how much was spent. So, for example, this project, the total amount spent against construction was $876,906.46. Design, $146,006.54. Right-of-way, $18.93. Somebody had some labor against that. Study, that was some of the initial study work that was done, $7,529.82. And so then it gives you the total amount of the project's expenditure at that time, $1,030,740.84, and also adds up each one of the classes.
And is the detail for each of those categories provided?
Not in here, not in Exhibit J11.
Look at J12.
Yes, J12 starts the backup of costs by activity ID, resource type for each of the projects, for each of the components. First page is AFUDC associated with closeout, then bait stamp 51084 is AFUDC interest for construction. Bait stamp 51086 begins design, AFUDC, and so forth. All the way
Those
through.
labels correspond with the categories from J11?
Yes.
And if you would look, please, at J13.
J13 is a similar report related to the Turnagain Heights LID.
And again, is J14 the detail that backs up the figures on J13?
Yes. Appears to be.
So the best of your knowledge is the full accounting for the water improvement district and the lateral improvement district included in the reference material?
If it is what I provided previously, it should be, but without going through here and doing a thorough, lengthy analysis, I cannot honestly say that
Right.
what's in this book is.
I represent it's what you gave me.
Yes.
So let's turn now to...
I do have one minor concern,
Yeah.
Bob. The cost summary date 3/29/11, whereas the reports are as 3/21/14. I don't know if that's a typographical error.
I'm sorry, I didn't follow.
Just all your page labels here, 3/29/11, and I think it's supposed to be 2014, but I'm not 100% positive here. There may be a typographical error on like J13. It says LID cost summary 3/29/11.
Oh.
And I believe that's from.
You're referring to the date that's on the divider sheet that was prepared by my office?
Yes.
Yep, I'm sure that's our mistake.
Okay.
Now let's spend a minute, if you would, talking about the Schedule A lit expenses and what was included in Schedule A and how those costs were allocated.
Yes, sir.
What would assist you in describing that for the panel?
If you can go to Exhibit A7. And if you can put that up on the screen, Bob.
one more time for purposes of orientation. The north is sort of this direction. The water is to the top of the pitch.
Bob, do you have the laser pointer by any chance?
Sorry?
Do you have the laser pointer by any chance? For the panel, do you prefer me to identify them to that screen or to that screen for ease? This one? Okay. Schedule A work included work both for Pump Station 10 and then also the Lateral Improvement District. And I want to explain a little bit about that work here. So this was the previous west trunk line here, or sorry, this was the previous east trunk line that went bifurcated the Hitchens parcels here and then went north and tied into our existing Pump Station 10. During design, we decided that it'd be best to try to intercept these flows and take them and bring them this way along Marston Drive and bring them down to the new Pump Station 10. Schedule A included the actual pump station construction, the construction of the sanitary sewer line from our point of interception with the existing trunk down Marston through the easement between lots 2 and 3. It also included the construction of gravity lines and force mains through an easement through the Durst property here. Schedule A also included construction of Pete's Place, the actual pavement, and then some trail relocation work that had to be done here in this pocket park. This is a pocket park right here. The portion that we've referred to as joint share pipe is this pipe that goes from the intersection along Marston only. This pipe here benefited the property owners that were along this line and along lots 1 and 2 for them to be able to hook up their sanitary sewer main as part of the improvement district. This was a pipe that was originally conceived within the improvement district to be constructed, and so as such, when we envisioned Schedule A work, because we were intercepting trunk flow from here and coming down this way, we thought it fair that the property owners would pay the basic cost of the pipe, just the pipe only, for an 8-inch equivalent size. And then we would pay the upsizing cost to go from 8-inch to 12-inch. That's reflected in the analysis that we previously reviewed and also in the pay estimates. Because we took benefit as well, we agreed to pay, and we thought it was rational and fair to pay for 50% of the trench costs associated with that pipe, 50% of the manhole cost associated with that run of pipe. AWWU, as part of Pump Station 10, paid 100% of the costs of the pipe going down here between lots 2 and 3. We viewed this as a direct replacement for the line that went through this easement here. So that's why AWW paid 100% of these costs associated with the sanitary sewer pipe that went through lots 2 and 3. We also paid 100% of the force main and the gravity costs, sanitary sewer force main and gravity sewer that went over here in through the west trunk alignment. We also paid for demolition of pump station, the old Pump Station 10 out of the project, and like I said, the upgrades of Pete's Place. That was Schedule A. Schedule B was the subdrain system work that was constructed in conjunction with the base bid. So that included subdrain that was down along the entire run of the sewer main here, subdrain along here, storm drain along Pete's Place. AWW paid for 100% of the subdrain within the west trunk alignment. We made a decision during design that even though it wasn't needed, necessarily for Pump Station 10. We wanted to take advantage of the subdrain within this to help dewater the trench and make construction easier for the contractor going through this location. So we included costs of that. The rest of Schedule B was associated with the road improvement district. And again, the only reason we constructed that in conjunction with the sanitary sewer was because the geotechnical recommendation said it needed to be buried 6 inches below the sanitary sewer pipe to provide the benefit to the area. Schedule C was the water improvements. The water improvements generally started here at the end of Marston and went along Pete's Place and extended fire flow. We didn't actually have to have water. There's no running water within Pump Station 10, but for our own design requirements, when you go through a subdivision agreement and things like that, you have to extend water down and fully front. The improvement district paid for the pipe costs of Schedule C in front of lots 1 and 2. Those were included within, those were balloted as being in the improvement district. So they paid for the pipe cost of that. We paid for the rest of the pipe costs fronting lot 3 and going down to the pump station. Because we took a share of this pipe for our benefit, we paid for almost 75% of the trench costs associated with putting in the pipe here in front of lots 1 and 2. While the property owners paid for the full pipe costs, they only paid for about 23% of the trench costs. When we broke these up, we thought, 25% of the pipe, 75% of the pipe in terms of the total run, and that's how come we came up with the general share there between on the excavation costs. We tried to be fair and reasonable when we broke it up. So Schedule C was the water, Pump Station 10 water, and components of the WID water.
We heard before about the cost of upgrading the road on Pete's Place and access to the pump station. What was the thinking there?
So AWW recognized that the road had to be, the Pete's Place itself had to be built to standard to accommodate our trucks and our equipment. Because Pete's Place wasn't included within only the improvement district had to provide, the road improvement district had to provide access to lots 1 and 2. They had to provide some sort of access to lots 1 and 2. As originally envisioned, it was kind of a joint driveway. The plan set can show the demarcation line of what the improvement district paid for under Schedule D and what we paid for under Schedule A. But we had to build Schedule A and Pete's Place to accommodate our trucks. And so as I reviewed through the one pay estimate and the bid documents, there was several thousands of dollars, tens of thousands of dollars associated with at least asphalt for Schedule A alone.
Just want to be sure that I understand what you're saying. You're referring to Schedule A, you're referring to Pete's Place. In a nutshell, were you saying that the pump station paid for the road improvements from the pump station up to a point near the intersection with Marston Drive, and the improvement districts paid for the balance after that?
Yes. And I forget where the demarcation line is. I'd have to go to the plan set to actually see where the demarcation line is.
So let's turn now to the 2012 assessment rolls. Why did it take until 2011 to prepare the rolls?
Rephrase that?
Referring to the original assessment rolls that were approved by the Assembly. They were approved in early February of 2012. They were introduced and rolled out for comment in 2011.
Correct.
The work was concluded when?
So the final pay estimate was September or October of 2009. Construction costs had to be reconciled project had to be prepared for closeout, files, ADC approval of drawings, those kind of things. So, the last couple percent of projects sometimes take us a long time for us to get everything, the I's dotted and the T's crossed. So that's part of the lag there.
Could you mentioned, you stated that you thought the final pay estimate was issued in 2009. Take a look
Sorry,
at
2010.
Exhibit E15.
E15?
Yes.
Yes. Final pay estimate signed and dated. Looks like 10/13/10 was the last signature on here. So
So the project was completed and closed out in October of 2010.
the construction was completed and closed out in October of 2010, but the project itself was not closed out. There's still other activities post-construction that must be done.
Okay. And so the rolls were prepared and distributed in the fall of 2011,
I believe that timeline is correct.
and there was public comment, and ultimately the rolls were approved in February of 2012. I believe those are, I don't have the reference to the exhibit number. In any event, the lawsuit was commenced, and there was a need to go back and review those assessment rolls for accuracy.
Correct.
And what occurred?
Well, after the assembly approved it, Public Works identified an issue. I believe it was with the landscaping within Lineary Park. There were some of the costs from the landscaping that I believe were inadvertently attributed to the RID costs. At that point in time, we started the review after, there was a lawsuit that happened. We also began a review to make sure that the costs that we had been tracking were correct. At that time, we found some discrepancies as well that needed to be resolved between allocation between the RID, WID, and LID in terms of cost accounting.
Some allocations between the three projects?
The major one of about $113,000, I talked briefly about the memorandum of agreement that was entered between Public Works and AWW. It set up amount for reimbursement there, specifically amount for dealing with administration of the project. Because we had outside consultants on here, the 5% that was initially allocated under the MOU wasn't sufficient to cover the amount of administration that the consultants spent on the RID component of the project. The project manager at the time, when we were getting ready to close everything out, Jeff Coleman, had left those costs that were overrun in the LID, and so the initial LID costs were higher than what they were here, and we in that instance had artificially absorbed RID costs within the LID. And then there were some other items where, as people were coding invoices to pay them, they coded them to the wrong account. WID work for LID work for WID work, and those sorts of things.
And how were these reviews performed?
The reviews that were started in 2012 and that went through 13 and everything, we initially performed those with in-house staff, staff from the planning department, staff from project management. Here at least within AWW, we had a consultant, Michelle Ramirez, who's one of our project controls people. She helped review them. We identified a number of things, and then we also brought in the MOA internal auditor to look through the files as well.
And were final adjustments made after those reviews occurred?
Yes, there was a list of adjustments that were made. We performed accounting transfer requests to move the costs associated with that were incorrect from one project or activity ID to another project or activity ID.
And were new revised assessment rolls prepared?
Yes, sir, they were.
And are they in the exhibits here?
Yes, I
Refer to tab G, as in Gloria.
I believe they are G1, G2, and G3.
G2 is the Water Improvement District, and G3 is the Lateral Improvement District.
Yes, sir. I believe those are correct.
And to the best of your understanding, are those accurate? Do you believe those are accurate?
Yes, I have reviewed those, and they look to be the right roles.
Okay, thank you very much. That's all I have.
Mr. Owens, at this moment, we're going to go ahead and take a 10-minute break, and I'd like for you to get that potential Exhibit N ready, and then give a copy to each member and Mr. Steely.
Yep.
Thank you. And the clerk as well. Okay, we'll go ahead and resume. Mr. Steely, did you receive a copy of N1 and N2?
I did.
And are you okay with submitting those as exhibits?
I am. I'm a little disappointed that I didn't get them before today, but, yeah, they're fine to be admitted as exhibits.
And we will also allow, if you have comments on them tomorrow, after you have time to think about them. So if you would, go ahead and proceed. And Mr. Nuss, just for clarification, you're still under oath.
Yes, ma'am.
So I put Exhibit A7 on the overhead, which again is this drawing of the pump station as it's to be built, in fact, as it was built, correct?
Well, it schedules A, B, and C, not just the pump station.
Okay, schedules A, B, and C. I understand your position on that. But first of all, I got to hold it. So this was the old east trunk line going to the old pump station, correct?
Yes, sir.
And a decision was made to change it and route it this way to the new pump station, correct?
Yes, sir.
And that decision was made because it actually was better from AWWU's perspective, looking at it from an engineering perspective. VEI looked at that and made a decision that that was a preferred route to get to the new pump station for that East Main trunk line, correct?
Considering the development of Marston, yes.
But even independent of that, even if you were just going to build this independently of that, that was the preferred route, correct?
I don't know.
You don't know. Maybe
I don't
I'll have
know.
to get Mr. Rolfs here.
Yeah, I don't remember it that way.
Okay.
I remember the discussion that there was concern from AWW about having the line existing going through the easement where it was and the proximity to the existing homes for future maintenance considerations, and that knowing that Marston was going to be developed, there was an opportunity to redirect the flows alternatively. That was the discussion I remember.
Okay, so there was a concern that if you routed it this way, that you thought you would need a larger easement, and indeed the property owner was reluctant to grant that, correct?
No, that it wasn't about acquiring additional easement. It was about future maintenance of that existing trunk line, and that just keeping it there if something would happen in the future, a failure, it would be hard to maintain.
Okay. And so the decision was made, and we can talk to Mr. Rolfs about it more because his firm's the one that really designed it, correct?
He designed it with concurrence from AWW.
And so a decision was made to reroute that east trunk main to the new pump station in this way. Now, that pump station performed for the existing homes in Turnican. Let's assume that this improvement district isn't going to take place. In order for that pump station to function, that trunk line needs to be built, correct?
If that pump station is constructed there, that pump station could have been fed from the existing Sandstrom Drive as the existing pump station was fed. So you don't have to construct that new trunk line necessarily to a new pump station at that location. You could have fed it through the existing east trunk line.
I understand that, Mr. Nuss. A variety of different options were explored by VEI, weren't they?
Yes, a variety of options were explored.
And this is the option that was settled upon between VEI and AWWU, correct?
Yes, this was the recommended alternative.
And so if this pump station was going to be constructed on this option, that trunk line had to be there in order to service the existing Turnagain neighborhood, correct?
Under this scenario, yes.
Okay.
Mr. Staley, can you make sure to speak into your mic? Thank you.
I'm usually loud enough. You testified, sir, that, and I'll represent, this is Lot 2, Lot 1, Lot 2, Lot 3. You testified that you believed that AWWU paid for a portion of the construction of Pete's Place. Prior to this, there was no road there, correct?
There was a trail, and you can see a remnant of that trail as it goes through the lot. That trail kind of started up by McLeod, I'm not sure how to pronounce the last name, their driveway there, and it bifurcated because there was metal U-rail that separated between the Hitchens driveway that was within the right-of-way and the trail access down Pete's Place.
Right. So there was a trail that went down to the coastal trail, correct?
Yes, sir.
But there was no road there?
No.
Okay. Now, again, you're not the engineer that actually did this final design, are you?
No, I'm not the engineer that final designed it.
Okay, and so what is your basis for saying that AWWU paid for a portion of that road?
The plans, the pay estimates, the bid documents.
Okay, and so let's take a look at those bid documents, and I believe that's D5 is the engineer's estimate. That's the final before combining it with the improvement districts.
Bait stamp 601409.
Yes, correct.
Okay.
Okay, so what is it on Exhibit D5? Again, you're not the one who designed it, you're not the one who built it, but you are providing sworn testimony to this panel, and you're saying that it's based upon these bid estimates. So what on here tells you that they built that road, or at least a portion of it?
Well, this is the estimate prior to construction. So this here was an estimate at the time, but if you look on page 2 of 16 of that exhibit, you'll see basic items A22, A23.
I see that.
For AC pavement Class E 2-inch thickness per square yard, 1508, and then remove and replace existing asphalt surfacing Class E 2-inch thickness per square yard, 1575. So the remove and replace, based upon my just viewing this, would be for remove and replace of the existing trail system that was there and costs associated with the road right up there at Marston at the end of the dead end road there. And then the new asphalt would have been for the actual pump station site itself. But then my other items that go to support that is page R6R of the plan set, and then the actual final pay estimates and the quantities paid and the identification on the plan set of where Schedule A picked up costs versus Schedule D picked up costs.
Okay. So you're looking at this and you're seeing this new pavement, and you're saying, gosh, that must be for Pete's Place, right?
I'm saying that was for the actual area right around the pump station because there was an amount of pavement, new pavement required for the access off of Pete's Place into the pump station, and then also for the pavement around pump station. That is shown in the gray on your Exhibit A7 there.
Okay. Now, if you look at this Exhibit A7 on the board, this also reflects Schedules A through C, and what you were looking at was Schedule A, correct?
Correct.
So if we look at this, we can see that in fact it identifies where the new pavement is, doesn't it?
That's generally that shaded gray area. It's kind of hard to tell
Right
on
there,
here.
I highlighted it. It says new pavement.
Mhm.
Is that correct?
Let me go to schedule it. New pump station. Where's new pavement?
Sir, it's right there. New pavement.
Okay, new pave. New pave. I don't know what that actually, I'm assuming that's an arrow. It's kind of hard to tell on this size. I'm assuming that's an arrow pointing to the shaded area.
Yeah, it's pointing to this shaded area here.
Mhm.
This is new pavement that was put in pursuant to either Schedule A, B, or C, correct?
Well, the work in Sandstrom Drive was paid for under Schedule A.
Okay. And so Schedule A says new pavement. Work on Sandstrom Drive was under Schedule A, and we can see on Exhibit A7, which has Schedules A, B, and C, the new pavement identified, correct?
Well, that is one, yes, this is an exhibit drawing of the overall, but it doesn't represent the compendium of information available to identify where schedules broke out pavement and those items.
There's no reference to new pavement anywhere else on this drawing, either, sir.
Not on this particular drawing, no. But there's other drawings that have those kind of references alluded to them that are as part of the data available.
Do you know, sir, why Keats Place Lot 3 was not included in the improvement district?
No, I don't fully know why Pete's Place was not, Lot 3 was not included in the original improvement district.
I mean, it certainly benefited by this road access, correct?
It benefited by the construction of the portion that AWW constructed, yes.
Well, and again, sir, can you point me to a document that shows that AWWU constructed any of that road?
Yes.
Okay, let's take a look at it.
If you would like to pull the plan set up,
Okay.
R6R.
Okay, so we're looking at this plan that you stuck up here, and what on this plan tells me that AWWU paid for at least a portion of Pete's Place?
You can see the demarcation line there where it says Schedule D, Schedule A. Schedule A was the pump station 10 work there. That is the sheet R6R is the plan sheet referencing the improvements along Pete's Place. And so that there is how the contractor, the field personnel kept track of the work and the assignment of the work.
Okay. So again, if we're looking at Exhibit A7, that demarcation line was there between lots 2 and 3, correct?
Yes, sir.
But all of this, you couldn't get down to the pump station without driving down this portion, could you?
Correct.
Okay. And so this lot that AWWU built this pump station on certainly benefited by this road, access road, correct?
Yes.
And yet it hasn't paid its portion of this road, has it?
AWW is not party to the RID.
And my question is, why not? When it's clearly benefited. You've included people like the Hitchens who didn't need access, didn't want access, didn't want the road, didn't need the road, and yet they've been included in this. AWWU cannot access its new pump station without this road going in, and yet it isn't included. Is there a reason?
It was not part of the improvement district. That parcel was not part of the improvement district.
And again, and perhaps you don't know, but my question is why?
Have no idea.
Okay, I just wanted to get clear on that one point. We're going to come back to that issue, but I wanted to get clear on that one point. So AWWU has paid nothing for this portion of this access, even though it needed it to get down there, correct?
AWW needs access to manholes and valve boxes all the time, and we don't usually pay for road access to those manholes and valve boxes either.
A lot of your testimony centered around this concept of shared costs and that kind of thing. Now, as far back as about 2004, the pump station and the improvement districts were commingled in the sense that at least VEI was hired to act as the consulting engineer for both, correct?
They were solicited under two separate requests for proposals, but yes, both, because of the perceived efficiencies gained, they were both selected to be performed by VEI.
And if you'll look at Exhibit 67,
Yes, sir.
this is a memo dated June 2004 from VEI talking about Pump Station 10 replacement feasibility study, correct?
Yes, sir.
And in the second full paragraph, it talks about the topography of the LID neighborhood is such that a pump station is required to provide wastewater collection service. The timing of the two projects presents an opportunity to develop one pump station to serve both needs. Constructing one pump station in lieu of two will provide reduced operations and maintenance costs. Do you see that?
Yes, sir.
And I want to get clear on this. So originally, the improvement districts as conceived were going to have a force main, and they were going to have their own little separate lift station that, through a force main, pumped it into Pump Station 10, that east line that went to the old pump station, correct?
Sort of. They were going to have its gravity line. They had to have gravity line to serve the homes that would flow into an individual lift station, and then that lift station would pump it into existing distribution system and collect that sewage to then discharge into Pump Station 10.
Okay. And the homeowners would be responsible for building that small lift station, correct?
Yes, that would have been part of the lateral improvement district cost.
But AWWU would be responsible for maintaining it, and they'd be responsible for eventually replacing it if it needed replacement, correct?
Yes, sir.
And so what's being mentioned here on this Exhibit 67 is the idea that if we can get rid of that pump station, it may save AWWU operations and maintenance costs, correct?
Yes, and we also contemplated lower capital costs.
And so, in fact, you had AWWU conduct an analysis to see basically the present value of how much AWWU might save if it were to eliminate that. Is that correct?
I had VEI conduct an analysis, yes.
I'm sorry, VEI. And that was slightly over $100,000 if you redesigned this such that you could eliminate that pump station and that force main and go with just a gravity feed by the improvement district to the new pump station, correct?
Where do you see the $100,000 figure, please?
Exhibit 91. And if you look at the last page of Exhibit 91, this is a letter, by the way, from VEI to you, sir.
Yes, sir.
And it's discussing this analysis, and if you look at the last page, it has the 30-year present worth of the Marston pump station to AWWU. That is the savings to AWWU by eliminating that. The present value of it is $104,000, correct?
That was the estimate at that particular time, yes.
And ultimately, through a series of considerations by VEI, that's what was decided to do, was to build the pump station as we've seen it, and put this line in, and then we look at A8 by the existing, or the planned improvement district into that same trunk line, correct?
Well, the improvement district also is that area to the right that you failed to point out, yes.
Well, this whole area is the improvement district from about this lot, this is the McLeods, all the way down like this, correct?
Correct.
Okay. At some point, AWWU had to go to the Geotechnical Commission and to Shannon and Wilson to get soils reports, both with regard to Pump Station 10 and the Road Improvement District, correct?
We didn't have to go to the GAC, but we chose to share the information at the same time, so they understood the entire nature of the development being considered for the area. Yes.
Okay. Well, you had Shannon and Wilson did a soils report. I think we saw it in Exhibit 62 for the pump station, correct?
Yes, Shannon Wilson was contracted by VEI as the geotechnical consultant for both the Pump Station 10 project and for the Improvement District projects.
I'm going to put Exhibit C13 up. This is a letter, again, to you from VEI dated October 6, 2005.
Yes, this is referencing the subdrains.
And it states, the Pump Station 10 soils report recommends subdrains be installed in the same trench with the gravity sewer line.
Yes, that's what it states.
And if you go a little bit further down where it says area in question, it says the Pump Station 10 upgrade project is responsible for redirecting 2 trunk sewer lines to the new pump station site, the east trunk and the west trunk.
Yes, it says that.
And if we look at this, this is the east trunk, correct?
Yes.
And this is the west trunk, correct?
Yes, sir.
And so the Pump Station 10 project is responsible for redirecting these 2 trunk sewer lines to the new pump station. And it goes on to state that the portion of this trunk line, the east trunk line, the portion of this trunk line within the Marston right-of-way traverses the side hill and will definitely require subdrain installation. And again, looking at A7, that's this portion here that he's referring to, correct?
That is the portion that he's referring to.
He goes on to state that this west trunk line is not necessarily as critical since it's down in the flat area, correct?
Please pull up the sheet where you were referencing that.
Again, I'm looking at C13.
Yep. So page 2 of 3 under discussion.
Yeah, actually, he begins discussing this issue on the bottom of page 1. The portion of the trunk sewer line in Sonstrom Drive parallels a subdrain installed along the old Hood Creek alignment. Therefore, no installation subdrain is required there. The remainder of the west trunk line is in an area deemed less important for subdrains. Subdrains in question would extend from Marston Drive north to the proposed pump station 10 site and from Sonson Drive east to the proposed pump station 10 site. You see that?
Yes.
And then he goes on, though, and he ultimately recommends that all of those subdrains be installed, correct?
Yes, he recommended that.
Okay. And he's got the recommendations down here at the bottom of his letter. And he states, installation of subdrains over a wider area will eliminate more groundwater. 2, the subdrains will provide a tool for the contractor during sewer construction. It is possible that the presence of the subdrain will eliminate the need for a formal trench dewatering system. So in order to put that new subdrain in, or both of those new subdrains, frankly, both the east and the west, new trunk lines in, the east and the west, having this subdrain assist the contractor, correct?
There would be added benefit to the contractor.
Okay. Number 3, with deep subdrains in place, the deep excavation for the PS10 wet wells would be protected from groundwater flow, correct?
That's what it states.
Number 4, construction of the shallow utilities for pump station 10 would not have to deal with groundwater, correct?
That was what it states.
Number 5, the discharge of Hood Creek storm drain is provided by this option would be a more trouble-free discharge point, correct?
That's what it states.
Okay. And so, again, VEI was writing to you in October 6th of 2005 stating that the pump station was responsible for redirecting these 2 main trunk lines, and that pursuant to the soils report, that deep subdrains were required in both. One might be more critical than the other, but he was recommending both for a variety of reasons having to do with the construction of the main trunk lines and not having water in them, construction of the pump station itself, the shallow utilities for the pump station, as well as ultimately for the discharge, correct?
That's what the letter states, but it fails to recognize the reason for the redirect of the sewer along Marston.
Can you show me any letter from you back to VEI discussing that says, you know, this really isn't as a result of Pump Station 10, this is really the result of the improvement districts?
Can't think of one off the top of my head right now.
And so again, when we look at A7, which reflects the work to be done on schedules A through C, all of that was necessary for the pump station.
I disagree.
Okay, but pursuant to the documentation we have, the soils report from Shannon and Wilson, the reports from VEI, all of that was necessary for the pump station, correct?
All the work for schedules A through C was not required for the pump station. No, I don't believe that.
Okay, what wasn't required?
I don't believe the subdrain, based upon testimony earlier from Mr. Brennan, the subdrain from the going along Marston Drive through the easement of lots 2 and 3 was required for pump station 10. I know this letter talks to that, and we installed the subdrain along from Sonstrom to pump station 10. But as you have stated previously, VEI was performing work as a whole in this area, and so I think their letter reflects the holistic view of the area and the work to be performed, and is not just subject for pump station 10. That's my interpretation of that.
Well, I was here for Mr. Brennan's testimony as well, and he stated that he authored that report for pump station 10. It recommended the deep subdrain, and even if the subdivisions weren't going to be built, some sort of a deep subdrain would have been recommended.
Well, he said some sort of drainage would have been recommended, maybe more isolated and localized around pump station 10 is what I believe he said.
Well, I understood him to say that the important part of dewatering this was for the stability of the upslope area, correct?
Correct, with the overall analysis that the site was being developed, the holistic view, not just solely for a pump station itself that was not to be permanently occupied.
The changes that were made in the design of this improvement district not only substantially increased the construction cost, but they also substantially increased design costs, correct?
What specific changes are you referring to?
I'm referring to the original design, which was to include a small lift station and a forced main, to the new design, which was all gravity flowing into the new pump station.
Well, you continue to confuse that there was gravity lines. It wasn't just the force main. There were gravity lines with the pump station and associated force main. So that was there. So what specific, you have to elaborate so I understand.
Well, sir, the cost of these projects more than doubled. We saw that, correct?
They didn't more than double for the LID and WID, no.
Okay, what was let's look at the original estimate for the WID and LID. I think that's B5. Engineer's estimate for the LID was $791,000, correct?
Yes, sir.
All right, and ultimately, the LID ended up being $1.6 million, correct?
Well, no, that was the balloted cost, but the actual construction cost came in less.
I understand that. I'm talking about the estimates.
The estimated cost at that time, yes, that's
More than
correct.
doubled.
Okay,
Correct?
the estimates, yes.
Okay. And the same is true with regard to the WID, the original estimate was $562,000. That's page 2 of B5. And if we look at M2, the new estimate is $1.2 million.
Correct.
Okay. So these estimates more than double. And that's not just attributable to increase in material costs.
No, there's cost escalation as part of that, design costs, depth of sewer, those kind of things all attribute to that, yes.
And indeed, what the homeowners were told was that the deep subdrain, in particular the depth of them, was the majority of this increased cost, correct?
I'd have to go back and look through all the meeting minutes to evaluate everything that was said. I think that was one component. I don't believe that was to be the only component that was discussed with the property owners.
And it's not just the construction cost that increased as a result of that, it's also the design costs, correct?
Yes, there was design cost increases as well.
Okay.
The extension of time, those kind of things. Added review that had to be incurred for the Geotechnical Advisory Committee, those kind of things all led to increased costs.
Okay. And so if we look at Exhibit 74, it's another letter from BEI, this time to Russ Oswald, January 14, 2007. And in this letter, BEI is essentially saying we need to be paid more money for the design of this project because it's increased. And particularly, they identify the deep subdrain piping and related subdrain lift station designs required. Correct?
Which page?
Page 1, first bullet point.
That's one of the components, yes. But there's other bulleted items identified as well.
Okay. No, there's one that in particular identifies it. No, that's not it either. So I'd like you to take a look at J11.
The WID cost summary, 321.
Correct.
Yes, sir.
And that shows the cost for design for the WID, correct? Total cost for design.
Yes, $146,006.54.
Okay, so for the WID, it's $146,000. And then if you look at J13 for the LID.
LID was $197,635.23.
So I've written them down, but the WID was $146,000 and the LID was $197,000. Now if you'll take a look at B14.
Dog 14?
B is in boy.
Memorandum regarding fee proposal comments.
Correct. And this is from Mr. Boss, correct?
That's what the letter says, yes.
Okay. And if we look right at the top, and I've highlighted 2 paragraphs there, it says the design costs for the LID should not exceed $60,000, and for the WID, $76,000, correct?
That's what it states, yes.
Okay. But we're talking about costs that are 3 times that amount, basically, correct?
In the end, yes, at this point in time.
Pardon?
Well, this is related to the fee proposal from VEI, so those total design costs include more than the fee proposal here, so you have to look at the PRSVC cost to figure out the total cost increase.
Okay.
But this is reflected of the VEI contract.
Okay, well, let's go ahead and take a look at J11 and J13, just with regard to the contractor services or the professional services, and that'll tell us what those are, correct?
Yes. So J11, professional services related to design, $109,829.45, but not all of that professional services is related to VEI's contract. I'd have to go and look at VEI's contract. There was professional project management costs associated with under the professional services task, so we have to go look at VEI's actual contract to ascertain what amount was VEI, and then same thing with J13 will be similar. The professional services under design for that is $150,664.31. And again, not all of that is VEI's, which is what this memo is referencing.
Referring to your testimony in response to Mr. Owen's question, you talked about how the costs for one of these projects are paid, and you said, I believe, that the property owners pay 100% of the cost of the main and then plus the cost of service, correct?
Yes, sir.
Okay. Just so that we're clear, a main sewer line is not the same as a trunk line, correct?
Correct.
If you'll look at J9,
The design study report for Marston Heights or Marston Fork. Right.
and I think I wanted to look at, you were looking at page 4. Okay, page 4, Mr. Owens had you look at that. Second full paragraph. Down to at the bottom, he had you read that it's talking about Pump Station Ken, and it says that the Pump Station Ken upgrade project costs are being warned separately by AWW, except the cost of joint use mains will be proportionally shared between the Pump Station Ken upgrade project and the Turnagain Heights LID project, correct?
Yes, that's what it says.
Okay. It doesn't say anything about costs of subdrains. It doesn't say anything about costs of the water. It just talks about costs, joint use of the main, correct?
In that particular paragraph, yes.
Okay. One other point of clarification. A storm drain isn't the same as a subdrain, correct?
No, a storm drain deals with taking surface water and then discharging it. A subdrain takes care of subsurface or groundwater and discharges it.
Okay. And most roads have storm drains, correct?
Almost every road has storm drain or a ditch system or something like that to deal with the surface runoff.
Okay. But most roads do not have subdrains in addition to storm drains.
No, there are cases where there are subdrains, French drains, fin drains, curtain drains, whatever you may call them, to deal with subsurface waters that may either percolate through the area and cause problems and glaciation of a road, or may make for unsuitable foundation material, those kind of things. So roads do have them, and what percentage you'd have to ask somebody from Public Works to go into detail of that, but there are other ones.
Yeah, and I didn't mean to indicate that no roads ever do, but I don't believe that most do, and we can ask somebody from Public Works in terms of percentages or somebody else. Were you at all involved in the construction of the road in Turnagain Northeast? That is on the east side of Lineary Park, where the Rasmussen Sheffield's homes are?
No, that was prior to my time. That was in the 90s.
Did you ever look to see whether or not deep subdrains were installed in that project?
No, I did not.
Take a look at F5, please.
Meeting note 62906.
Correct. And I just want to draw your attention to the last page, paragraph numbered 4. The property owners were asking to be kept abreast of the progress of this, correct?
That's what it states here, yes.
I mean, at this point, it wasn't viewed, was it, that they were interfering by wanting to be kept abreast, was it?
No, you know, I would say these were informed property owners that wanted to know the progress of the property. There were several people that wanted to build immediately that would call routinely just to check on the status because they had plans to build. Ms. Grumman was one of those that was a kind of a constant caller wanting to know the status.
And in fact, it was represented to the property owners, and perhaps you were or weren't there, that they could actually encourage road builders to build on this if they were concerned about cost. They could actually encourage people that they know to participate in the bidding process, correct?
I don't see that. Where would that be?
It's not referenced in that exhibit, sir, and you might or might not have been
I don't
in those
recall
meetings.
such discussions.
Okay. You yourself, though, weren't necessarily in all these meetings with the property owners.
No.
One of the items that you testified about with Mr. Owens was that at some point, you know, when these estimates are given to the property owners and they're asked to ballot, they basically are agreeing to pay those, correct? That was your testimony?
Yes, sir.
Now, you understand that there are certain laws that govern what the assessments can legally be, correct?
Well, for the water and sewer, the tariff provisions and AMC 1955, 1970 cover those, yes.
Okay. And so there are rules and regulations that cover water and sewer tariffs and road tariffs, and they might be different regulations, but there are regulations that govern those, correct?
Yes.
Okay. And you also knew that there was a chance that the bid might come in too high, in which case the project wouldn't go forward at all, correct?
No, I didn't view it as the project wouldn't go forward at all. I viewed it as the project. We would have to reconsider elements of the project, see what we could do, go back to the property owners potentially and reballot. Those were items. I didn't ever view that the project would never move forward.
Okay, and maybe I misspoke and wasn't clear, but you understood that when the invitation to bid went out, that if the bid for any one of those improvement districts came in higher than the funding available, that wouldn't be awarded at that time, correct?
Yes, and that's part of what I reviewed with Mr. Owens was that analysis spreadsheet that had reviewed the construction costs. Prior to awarding and making the recommendation of award, my staff, or the consultant, Jeff Coleman and company, went through and evaluated that in conjunction with discussions with Public Works to make sure that there was funds available to move forward with construction.
And in fact, though, the funding that was identified as being available for construction for the road was $2.7 million, correct?
No, I don't believe that is correct. That was an estimate within the one estimate, the 2.7 was an estimate within there of the construction costs. But at the time of bid, there may have actually been more money available than that $2.7 million estimate.
I'm going to put C4 on the overhead, and this is the estimate that you're talking about, correct?
C4, hold on. No, C4 is the 35% design estimate for RID and lineary. You will need to look at the reballoted estimates, the higher, well, maybe that is the 35%.
Go ahead and take a look at it, sir. I believe that it is.
Yep, 4.418. So yes, there is an estimate, total RID construction cost 2.701545. It does say that this is the 35% design estimate and would not have been considered the final engineer's estimate.
But this is the estimate that was used to reballot this with the homeowners, correct?
I don't know for the RID if this was the final one. It may be. I do know that we had different ones than what are included here in exhibits C2 and C3. That's the N1, N2 estimate for the WID and LID.
Right, and those new exhibits that you brought in here today have that 2008 escalator, correct?
Well, it has escalator and internal AWW cost, yes.
Okay. And indeed, what we're looking at here, C4 for the RID, has that 2008 escalator, and the total project cost is $4,418,944. You see that?
Yes, I see 4418944.
And now I'm going to put on the board Exhibit C11, and this is the reballot that was approved,
So the numbers match.
and you can see that the numbers match,
Yes,
correct?
sir.
And so you don't have any question, do you, that that was the estimate that was used for purposes of getting the homeowner's consent, correct?
No.
All right. And the construction costs that are identified are $2,701,545, correct?
That is the estimated cost on here, yes.
Okay. And that included, on the first page, everything that would be identified as Schedule D, correct? And then on the second page at the top, these are the items that are going to be shifted over, if you will, to the road for the subdrain issue, correct?
These are the items within Schedule A that were constructed for the RID, yes.
Okay, I don't think it's Schedule A, though. I think it's Schedule B.
Sorry, Schedule B.
Okay, so these are the items for Schedule B that are going to be constructed and paid for, according to AWWU, out of the road improvement district, correct?
Yes, sir.
And so the total construction costs are $2,701,545, correct?
That's what this says, yes.
And when the bids were opened, that was the exact number in terms of maximum available funding for the RID was, and I'm looking at Exhibit E4, page 1 of 1, $2,701,545, correct?
Which exhibit?
E4.
So this is the bid abstract, and that's the amount available for Schedule D, not necessarily for the RID as a whole. That's the amount listed for Schedule D.
Take a look at E3, please, sir.
Okay, I'm on E3.
Okay, before we go there, though, what we're concerned about is whether or not there's enough money available, whether or not the homeowners have agreed to a figure that provides for construction funding sufficient to pay for whatever the bid might come in at, correct? I mean, the bid has to come in at or below that figure, correct?
Yes, or the municipality has to build it at risk, knowing that it will exceed the 110% cap.
Okay, but the invitation to bid said that if it comes in over that, that it wouldn't go forward, correct? It would have to be reballoted.
Yes. Well, it didn't say it would have to be reballoted. It just said that the deductive alternate wouldn't be awarded, I thought.
Yeah, it wouldn't be awarded. The invitation to bid, it doesn't talk to the potential bidders about reballoting. It just says, you're not going to build that portion, you're just going to build the pump station, correct?
Well, it says A, B, and C, Schedules A, B, and C. We wouldn't build a deductive alternative.
And that $2,701,000 didn't include, that included everything for the road pursuant to the estimate, including the Schedule B items, correct?
On this estimate.
Okay. And if we look at Exhibit E3, when we look at page 8 of the exhibit, that's the start of Schedule D, correct? This is what Cruz bid for Schedule D, correct?
On E3, what page?
Page 8 of 14 pursuant to the exhibit numbers.
So this is Schedule D, begins 8 of 14.
This is what Cruz bid, right? That's what we're looking at?
Yes.
Okay. And it continues on page 9, and it continues on page 10, and then when we get to page 11 of the exhibit, we're still looking at what's identified for this purpose as Schedule D, and it just says that these are the items from Schedule B that are going to be included, correct?
Yes, sir.
Okay. And so we can see that the total there is $3.2 million, which is essentially $500,000 over that $2.7 million figure, correct?
Over the estimate, yes.
Okay. And you know, don't you, sir, that the actual final costs came in approximately $500,000 over the approved cost, correct?
4.898 or something like that, yes. And 4.4, so 400 and some odd, but not quite 5, yes.
You look at F10. This is the letter that went out to the homeowners when the invitation to bid went out, correct?
Yes, sir.
And this is when they were notified, at least this is the first written notification I've seen. I think your testimony was there might have been conversations with a few people, but this is the first written notification that these projects are going to be jointly bid, correct?
Yes, sir.
And the homeowners are told that the bids are being prepared in such a way so that it might be just the basic bid, which is the pump station, or it might be the basic bid plus the alternatives, correct?
Yes.
And it identifies here that the basic bid for the pump station, schedules A, B, and C, is pump station 10 upgrade, water, sewer, and drainage, correct?
That's what it states here.
Nowhere in here does it state that a portion of that is going to be paid for by them.
Not in this letter.
If you look at A10, please.
The plan and profile of the sanitary sewer?
Correct.
Yes, sir.
Help me read this document.
Okay, as you're facing the board there, over off to the left-hand side is Foraker Drive, and then you move to the right, or you're moving down gradient, nope, over to the left is Foraker Drive.
Okay.
That's on the east side of the project, and you're moving westerly, and that manhole right there is at the intersection of the lot line extended of lots 2 and 3. That's where it then goes between lots 2 and 3 and down to pump station 10. The line off to the right-hand side, the shallower line, is the intersection of the east trunk before it turns and goes down Marston to the line there.
Okay. And so I'm just going to put this back up here real quick. Well, maybe that's not.
Nope, you're okay. I can, there.
So we've got from 4 acre to the pump station trunk, and then from Marston to the pump station trunk, correct?
Yes, sir.
Okay, and so and that shows on here, this is from Marston to the pump station trunk, and this is from 4 acre to the pump station trunk, correct?
Well, that alignment there is solely the pipe within Marston. That does not show the pipe going from Marston down to the pump station.
Correct, but this is where it would go down. Correct?
That is where it would go down, yes.
Okay. And the reason why I wanted to get clear on this was when Mr. Boss was testifying, I believe he said that the side from 4 acre across was shallower, and it appears to me that that's actually the deeper side.
And, well, initially, can I borrow the pointer?
Sure.
I'll do it up on the back screen here for the benefit of the panel. Originally envisioned back in the initial estimates that you had referred to back in 2003 from Sandy Notestein, the drainage was to go from this way down to here, this way down to here, and then get pumped some way, probably up to Iliamna, extended. Original concepts as early as 2005 time period when we first met with the property owners showed much shallower line here on the east side of the property of the project, but there were property owners, and there's notes within the DSR and the discussions had. The property owners, especially within this general area here, I think it was Simonson or maybe it was Turnagain Heights, objected to that. They didn't like the idea of having to have on-property force mains within their own property to be, and then having to pump it up. Their view was that those would increase cost maintenance for those that were looking to develop their parcels and sell them. They believe that they should, it would detract in the value of their parcels. We considered doing dual frontage, putting a line within Marston Drive and a line on the north side of those properties, but that would have increased property costs. So to appease those property owners, we designed this line at this depth such that the centroid elevation of each one of those northern lots could gravity flow into the main. That want by the property owners significantly increased the depth of the sewer and therefore the cost of the sewer associated with the project.
And that's really, we looked earlier, or at least in my opening statement, I looked at some documents from Ms. Notestein where this project was originally designed with a sewer at an 8-foot depth. Do you recall that?
Her estimates were based upon an 8-foot depth. There had been no actual design at the time.
Okay, well, there was an initial estimate at 8 foot, and then she did a re-estimate at 12 feet. Is that correct?
Yes.
And that's what you're talking about, is that it went from 8 feet to 12 feet so that there wouldn't necessarily have to be those individual lift stations.
Yes.
Okay.
And actually, it's much deeper than 12 feet. It's 20 feet or so right there.
Well, that's what I'm asking. What is it now? This is the profile for the project as it exists now.
So I believe each one of these bars here, if I read the scale correctly, there's no vertical scale on here. There's only a horizontal scale, and I'd have to go to the actual plan sets to verify this. But I believe each one of these boxes represents a 5-foot elevation difference. So at that intersection there where it goes between lots 2 and lots 3, you're looking 20 plus feet deep.
Okay.
To be able to get it to gravity drain all the way from that side of the property, or from the 4 acre side of the project to where it goes down.
Okay, so when the project was originally conceived, it was going to have this mini pump station. It was originally conceived at 8 feet, and then because of property owners' objections, it was lowered to 12 feet, correct?
Well, it wasn't just 12 feet. It was lowered to make sure that the centroid elevation of each lot could drain by gravity. Only in those cases where a property owner, depending upon how far to the north they built on their property, and if they chose the daylight basement, that daylight basement may have to have a mini lift station. But VEI designed it such that you could generally achieve gravity flow from the centroid elevation of each one of those lots.
Okay, but that's only after it was redesigned with the pump station and the new east trunk line and all of that, correct?
Yes.
Take a look at A17, please. And what is this?
This is the memorandum of agreement between PM&E and AWW for the construction and management of the construction of the improvement district.
And so I can see that, and this is after the bid was received and accepted, correct?
Well, the process, I believe, was started before bidding, but by the time it worked through revisions, review, signature, and all that stuff, it wasn't executed until after. Yes, sir.
And you can see paragraph 1.1, pump station 10 upgrade base bid. And it has a discussion of what the AWW project base bid consists of. It then has a lower paragraph saying that a portion of this is really for the RID, correct?
1.2, yeah. The above listed work includes a portion of the RID work, yes. Right above 1.2.
There's no reference to road work here, though, is there?
Well, there is in the paragraph approximately 2,500 square yards of AC paving, landscaping, and other related miscellaneous appurtenances. I think if you look at this paragraph and then look to the actual bid documents and the invitation to bid that was solicited, this may be a direct cut and paste from the invitation to bid.
Okay. There's no reference here to the water line being transferred to the improvement district, is there?
Not in this, but that was because we were managing the WID and LID. This was primarily concerned with the management of the RID, which comes under the purview of Public Works. AWW manages the WID and LID, so therefore the particulars are referenced here related to the RID. if you look at the discussion of the Turnagain Heights LID, there is some work there, but I think primarily it was just referencing the transfer for the RID for that reason. And I think that's further supported by page 3 of 6, where it was talking about Schedule D, Schedule B, Schedule G. It was only referencing those compensation items related to those items that funding was transferring between the departments.
If you'll look at page 4, paragraph 4.2, it talks about PM&E will reimburse AWWU up to 5% of the awarded contract amount. Do you see that?
Yes, sir.
And then if you'll look at the next exhibit, which is A18, this is an amendment to the contract executed in 2014, correct?
Yes, this relates to my previous testimony to Mr. Owens about discrepancies, yes.
Okay. My question is, paragraph 4.2 on page 2 amends that 5% and now says that PM&E will reimburse AWWU for all costs instead of just limiting it to 5% of the contract amount. Do you know why that change was made?
Yes, as previously testified to, there was costs above the 5% that reflected the true administrative costs for administrating the construction of the RID that had not been included in the original costs of the RID but had been inadvertently absorbed by the LID. Because those aren't legitimate LID costs, they can't be assessed to the LID participants. Those were RID costs that should be borne by the RID.
Okay, but what was the justification for removing that cap of 5%?
The 5% at the time we wrote that was a standard figure, assuming in-house labor and things like that. When you have contracted consultants out there performing inspection and things like that, those costs exceed the 5%. And so when we initially drafted that, we had not considered into that. Now some of our agreements go 8% or higher for that.
That's all the questions I have.
Mr. Owens, do you have any follow-up questions?
Can you deal with that stuff?
Yeah, it's out of my way. I want to refer your attention back to your testimony regarding Exhibit F10, which was the letter dated June 23, 2008 to the homeowners, which brought them up to date on the plan to consolidate construction of the pump station with the other improvement districts.
Yes, sir.
And you were just asked about that and asked whether here under the basic bid portion that's described on page 1, whether that specifically stated that those portions included in A, B, and C that related to the improvement district projects would be paid by the owners. And my recollection was your testimony was it didn't say anything of that sort in this letter.
Yes, there's in this particular letter, there's nothing that really clearly defines, at least the paragraph that Mr. Steele was referencing that said that it would be split out in terms of portions of A, B, and C are actually included within the improvement district.
But the work that is, the components of work in Schedules A, B, and C that came from the improvement district projects, when the original estimates were developed, were part of the estimate for the improvement districts themselves, right?
Well, they were included within the design study report. They were also included within the reballot, and those costs were presented to the property owners.
And so those items of work and those costs were disclosed to the property owners before they voted to approve the work.
Yes, sir.
And then later, they were realigned for construction purposes, but that didn't change the fact that they were always intended to be part of the improvement district. Is that right?
Yes, sir.
So the property owners knew from before they voted on these improvement districts the components of the work that they were paying for.
Yes, that information was provided.
So they just weren't informed that portions of it would be carved out for construction purposes at one time separate from something else.
Yes, they knew all the materials that were going into the sandwich. They just didn't know how the sandwich was going to be prepared.
Great. Thank you very much.
Follow up, Mr. Staley?
Really very briefly, the homeowners didn't know that the way the pump station was designed required a deep subdrain, did they? I mean, they weren't kept abreast of PS10 engineering, development, geotechnical reports, were they?
They were informed that a subdrain was needed for their project, yes.
Okay.
And there were some homeowners that did participate in the Pump Station 10. There was a separate public involvement process for Pump Station 10, and on occasion we also commingled the public involvement. So there were people that were informed of the overall development plan for the area.
Okay. So they were informed that a deep subdrain was required for their project, correct?
Yes, for the improvement district, yes. That's one of the items discussed in some of the referenced correspondence.
And looking at Exhibit A8, indeed, there is a deep subdrain all along here, is there not?
Yes, sir.
Okay. But nowhere that I've seen were they informed that portions of the cost of the pump station project were actually going to be borne by them.
No cost of the Pump Station 10 project were borne by the property owners. No, sir.
Okay. But again, all of these items for the pump station, and again, I know that you might disagree with what Mr. Brennan said and what Mr. Rolfe might say, but all of these parts of it, this was the pump station project if it was to be built alone, correct?
No, if the Pump Station 10 was to be built without consideration of Marston Foraker, it would not likely have that same configuration, no.
Okay. But given the fact that it was going to be built and Marston Foraker may or may not get built, this was the design, correct?
That was the design and consideration of Marston Foraker, yes.
Okay. And at no time have I seen where the homeowners were told that a portion of this design was going to be borne by them.
They never bore any of the cost of Pump Station 10. They bore the cost of the improvement district work.
Did you have another thing? Okay, sorry, I thought I saw your hand. Other questions from assembly members? Okay, Mr. Nuss, are you going to be here tomorrow?
Oh, yeah.
Okay, if possible, I think the assembly members might want to reserve Mr. Nuss in standby in case we have questions that come up. He seems to be one of the most knowledgeable thus far, so is that okay with both parties? Sure. Thank you. We are at 4:30 at this moment. We're supposed to conclude at 5. I really don't want to start with another witness and split them between days. So with that, Mr. Staley, we'll start with you. Is there anything that you think we need to address today before we adjourn?
I don't think so.
Okay, Mr. Owens?
No, thank you.
Okay, and for members of the public, we did earlier invite members of the public to testify on this topic. Affected property owners, members of the public will have 10 minutes. We did that at the beginning of the hearing, and we will do that again at the conclusion of the hearing after closing remarks by both parties. So you are more than welcome to testify, should that be your desire. And we will stand in recess until 8 o'clock tomorrow morning.